Good afternoon. Welcome to the House Judiciary Committee. It is the 1st of March. The 1st of March. Wonder what happens next month. 2023. We have a number of different bills, including two to begin with the Attorney General, who is here with us, and call up to the table. We're going to begin with House Bill 771. Mr. Attorney General, who would, oh, I'm sorry, they wrote all over this and told me who I'm supposed to be calling. So why don't I read this then? Dana Mulhauser. Okay, just Dana Mulhauser and the Attorney General. That is perfectly fine. And Mr. Attorney General, welcome to the committee. We're excited to see you back here at the Judiciary Committee again. You were once here a long time ago. Not that long ago, I guess, but you know, that's fine. We're very happy and excited to hear from you, so go right ahead.
Mr. Chairman and members of the committee, I remember fondly my second term sitting right where Delegate Moon is sitting as the vice chair. When Delegate Valerio, chairman, was where Chairman Clippinger is. I always enjoyed when Delegate Chairman Valerio left the room, only because as it took 3 hours to get through one bill, I managed to get through 3 bills in less than 10 minutes. But I understand, I understand that that's not an issue here.
It's exactly the same way now.
Well, listen, it's truly an honor to be here today before you. I think this is my first time this session before the House Judiciary Committee. I'm very fond of the committee. I want to thank the chair and the vice chair as well as all the members. And for the record, I am Anthony Brown, your Attorney General. And it's an honor to testify in support of House Bill 771 with the proposed sponsor amendments. Ms. Dana Mulhauser, who is on our team at the OAG. She's chief of the Independent Investigation Division. And is multi-talented. She's going to walk you through the sponsor amendments, and of course, for the difficult questions, as I duck out of the way, she'll be able to field all of them. This bill is one of the top 2 priorities of the Office of the Attorney General this session. We've got a lot of priorities. This is among the top 2. And this bill, as you see in front of you, would authorize the Office of the Attorney General to investigate, prosecute, and remediate. We're doing better. Look at me. Wrong set of remarks, Mr. Chairman. I apologize. I was looking at the board outside, and I was on the Civil Rights Bill. I'm still glad to be here in front of you. This is the second of my 2 most important bills this session. And
we're doing 771, just to be clear, 771. You're doing really well. Yes. I just want you to know, you're doing fantastic.
And what this bill would do is it would give the Office of the Attorney General, or in matters that involve state agencies, as Ms. Mulhauser will describe later, it gives us the authority to investigate and remedy patterns or practices of misconduct by law enforcement and other responsible agencies who have responsibility for the custody or supervision of civilians. This latter category, the others, include correctional facilities, behavioral health facilities, immigration detention facilities, juvenile facilities, and parole and probation services. No other agencies or entities are covered by this bill. To be clear, these investigations are not criminal in nature. While they focus on systemic misconduct by law enforcement and others that I described in the criminal justice system, the goal is to uncover widespread abuses within an agency where they exist, such as discrimination or the consistent use of excessive force, and create change by requiring reforms to agency policies, processes, and culture. The implementation of these reforms is then monitored to ensure agencies actually follow through on their commitments. Pattern or practice investigations are an important complement to existing law enforcement accountability tools, many of which this body has already established for Maryland. Yet most of the current tools in Maryland, albeit significant, and they are important, they address past individual instances of misconduct, such as the police accountability boards and the work of the IID. Important work really looking at past conduct. Pattern or practice investigations, on the other hand, look for widespread trends and put in place reforms to reduce and eliminate misconduct going forward. There's a growing number of states that use pattern or practice investigations as a key part of their police reform efforts. You may recall, in 1994, after the brutal beating of Rodney King, the U.S. Department first obtained pattern or practice investigation authority. In 2000, now over 20 years ago, California became the first state to obtain this pattern or practice investigation authority. And since 2020, in the aftermath of the murder of George Floyd and Breonna Taylor and far too many others, at least 9 more states' attorneys generals have attained authority to conduct pattern or practice investigations. And the list is in my written testimony. That's fine. You guys do it differently. I know in some committees, sponsors
If you'd
get a
like
little
to
bit of
wrap
leeway.
up, if you'd like to conclude your testimony, that's fine.
Yeah, no, I would just, I have submitted written testimony. In the testimony, you'll see footnoted references to studies that show the beneficial effects of pattern or practice, reducing excessive force cases, actually improving public safety, improving the confidence in the relationship between law enforcement and the community, and ask a favorable report, Mr. Chairman.
Thank you very much. Please go ahead.
Thank you. Good afternoon, Chairman Clippinger, Vice Chairman Moon. It is great to meet some of you all in person. I met some of you all in a Zoom box last year, but this is better. My name is Dana Mulhauser. I'm the Chief of the Independent Investigations Division at the Attorney General's Office, and I'm going to walk you through a couple of the more mechanical aspects of the bill, including the sort of major sponsor amendment. So this bill is patterned directly off of 2 federal statutes. The one, which is sometimes called the Pattern or Practice Statute, which is codified at 34 U.S.C. 12601. They changed the number since I was there. And the other is the Civil Rights of Institutionalized Persons Statute, sometimes called CRIPA. So the federal statutes have been sort of adopted by 10 different states, like the Attorney General said. And when we looked at those 10 different states, they sort of divide half and half. And some of them are actually significantly broader than what we're asking for here and ask for pattern or practice authority against any governmental entity. And we went towards the narrower model that really goes to the crux of these violations here, which is police, corrections, and people who are in custody. So I wanted to give you a little bit of background on that, but I also wanted to talk about the sponsor amendment. And this came after we got some really useful and helpful feedback that talked about and asked about conflicts that the Attorney General would have within his office because the Attorney General represented statewide agencies. Now, there are ways to deal with those conflicts within the office. You can build a wall, you can do things like that. But what we decided is that we wanted to go a step beyond that and provide more protections than that. And so what we have in the sponsor amendment, and again, this is only for dealing with statewide agencies. This is not dealing with county agencies or municipal agencies. When there is a complaint or a concern with a statewide agency, we propose the creation of something called the State Agency Accountability Panel. Thank you. This won't take long. So the State Agency Accountability Panel, which would be nominated by the Attorney General, confirmed with the advice and consent of the Senate, and that would allow an independent voice on those statewide matters to make that decision and keep them separate from the Attorney General. Thank you.
Thank you both very much. There, I'm sure, will be further questions as we go through this first panel, beginning with Delegate Phillips.
Mr. Attorney General, how are you today? I got a question, and it just immediately popped out. I got a lot of respect for the state's attorney from Howard County, who is representing the State's Attorneys Association. And in his testimony, he asked that they not be included in this bill. And is that something that you would consider?
Delegate Phillips, as you read the bill, you'll see that the state's attorney's office is not included in the bill. And I appoint the committee to the list of those entities that are. One of them is law enforcement agencies as defined in the Public Safety Code. We have an opinion that I know we sent it to the Judicial Proceedings Committee that clarifies the position. We'll certainly make it available to the committee and committee members here. When you look at the definition of law enforcement agency in the Public Safety Code, which is referenced in the bill, it says, it defines it as governmental police force, sheriff's office, or security force. But then it does go on to say, or law enforcement organization of the state, a county, or a municipal corporation that by statute, ordinance, or common law is authorized to enforce the general criminal laws of the state. And that's what the state's attorneys have concern about. Well, we enforce the criminal laws of the state. Well, you'll see in the written opinion or letter of advice that we provided, when the legislature, when you have a statute and you're defining terms, and you have specific terms like police department, sheriff's office, security force, followed by a more general term like law enforcement organization of the state with common law authority to enforce general, they interpret that more general in light of the more specific. And I don't think anyone sitting in the room would think that the state's attorney is patrolling the streets of your community enforcing the law, right? The other point that's made in the letter of advice is that the General Assembly, you know when you want to include the state's attorney in a statute that includes law enforcement. In the letter, you'll see that when it comes to the family law article, when it comes to health occupations article, there are provisions in there where you say law enforcement and the state's attorney. Law enforcement and the state's attorney. You recognize that the state's attorney is not considered law enforcement. The concern I have, if you adopt an amendment in this bill that takes out law enforcement, that removes state's attorney from the definition of law enforcement, then here's the problem, the unintended consequence you have. 2 years ago, you passed the Maryland Use of Force statute. Great bill. And in there, you have the definition of law enforcement agency, and you refer to the public safety article as we do in today's bill. If you take the state's attorneys out of this bill, but you don't take them out of the use of force, then that means the state's attorney now has to have a written de-escalation of force policy, which none of them, I'm sure, have. They have to adopt a written policy requiring supervisory and command level review of all use of force incidents, which I don't think they do. The unintended consequence, I believe, of taking them out of a bill that they're already not in is that throughout the code, you're going to have to look at every area that you have law enforcement and then make a determination. Should they be in or should they not be in? And that's why I would suggest, Mr. Chairman and Delegate Phillips, that you read the bill in front of you as analyzed in the letter of advice in such a way that you reach the conclusion that I'm offering they're not in the bill today.
Thank you.
Delegate Embry, then Cardin, then Young.
Thank you so much, Attorney General. And I think you've answered it, but if you don't mind, just for clarity, my understanding is in the Senate hearing, the state's attorneys were specifically concerned about, in other states, attorneys general have tried to remove them, and that they were concerned that this gave the authority to the Attorney General in Maryland to do that. And I think you answered that and said that's not the case, but I just wanted to clarify.
And since there's not an opportunity for rebuttal in this forum, and I did hear the testimony yesterday, I'm not sure if State's Attorney Gibson is here again today, so he may offer the same testimony. But let me clarify here. Yesterday, State's Attorney Gibson, who I have tremendous respect for, as I do for all the state's attorneys, he referenced a case in Missouri. It's going on right now. You can Google it, you'll see it. The Attorney General in Missouri has a fundamental disagreement with a local prosecutor in St. Louis. And he's looking to remove her from office, saying, you're not doing your job. Now, interestingly enough, a few years ago, this is a Republican AG and a Democratic state's attorney. A few years ago, a Democratic AG in Missouri tried to do it to a Republican local prosecutor, right? Well, what gives them the authority to do it? Missouri law. Missouri law says that an attorney general can file an action to remove any incumbent. Now, it goes to court and it has to be considered. So we took a look at that and we said, okay, well, wait a second. What do we have here? Does our bill create a problem? We did a 50-state search of this law. I never took Latin. I remember a few Latin terms from law school. It's quo warranto. That's the authority that the Michigan Attorney General uses. 49 states have the authority, quo warranto authority, where either the Attorney General, in some states a state's attorney, in one state a governor, can bring this type of action, either because you're not qualified to or eligible to hold the office, or like in the case of Missouri, you're not doing your job. There's only one state that doesn't have that authority. Guess which state that is? Maryland. Maryland is the only state in the nation that does not have quo warranto authority. So neither your Attorney General nor any state's attorney in Maryland can say, I'm filing an action to remove you from office for any reason whatsoever. Interestingly enough, in Missouri, they do not have a pattern or practice authority law like the bill presented in front of you. So there's no mistaking. It's not like Missouri has pattern or practice and maybe they're relying on that and maybe not on quo warranto authority. No, they've got quo warranto authority. That's the authority that they're using. We do not have that in Maryland, and the pattern or practice bill that you have in front of you is not about removing anybody from office. There's no slippery slope. If you want to use metaphors, we're mixing apples and oranges.
Thank you, Mr. Chair. Thank you, Mr. Attorney General. It's always great to see you here, back where you cut your teeth and started. I was actually going to bring up that Missouri case because Mr. Gibson brings it up in his testimony, and you have done what you always do is you're very well prepared, not just with your answer, but with the documentation that I'm sure we will be able to see about this difference in Maryland versus 49 other states. I just want to make sure that we are, because I love when we talk about unintended consequences, and you and I have had those discussions over the last few months on other matters. Is it possible, is it not possible, and hopefully it's not possible, that because Maryland is an outlier in this, that somehow it could be tested in court and the opinion that your office has come up with actually won't hold water? If you feel like we're good and because we happen to be unique, which I have no problem with Maryland being unique, we're going to be okay, then we can talk to the States Attorney Association and just make sure that they feel comfortable with this and we can move on. Is there any pause for concern for the exact reason that you mentioned that we should feel comfortable?
So the Maryland courts, and we'll get you the citations, the case law, because we do not have a letter of advice on that piece, okay? The Maryland courts have said that unless you can find it in statute, you do not have the authority. So unless this General Assembly passes a law that says the AG or the state's attorney or the governor, those are the three different scenarios you see around the country, has this quo warranto authority where you can basically say, hey, I don't think you're doing your job. Now, the AG in those states can't remove the incumbent. You file a petition in court. Unless, the Maryland courts have said, unless the legislature passes that authority, it doesn't exist. There are other remedies that one could take, a writ of mandamus, but anybody can file a writ of mandamus. Now, whether it's going to pass muster and on the merits, I mean, not likely. Imagine me saying, going to the circuit court and name your favorite county and saying, hey, judge, I'm filing a writ of mandamus to remove the state's attorney because I don't think they're doing what they need to do. Like, that ain't going to happen. Okay, that's just not going to happen. I would neither do that, nor would any court, any judge that I'm sure is confirmed by your colleagues across the road in the Senate would confirm a judge who would say, yeah, okay, you guys disagree, so, you know, local prosecutor, you're out. That's just not going to happen. So the case law is pretty clear in Maryland, and we'll certainly provide you with that.
Thank you, Mr. Chair. Thank you, Mr. Attorney General and Ms. Deputy Attorney General for being here today and bringing this bill. I have two. I don't know if that's the right title. Did I mess up?
No, it's good enough. I'll take it today, for today. Listen.
I got a few quick questions, mostly mechanical on the workings of it. The first, y'all mentioned where the conflict comes, you might do a panel. I can't remember how you expressed it, Dana, but my question is, could the Maryland Commission on Civil Rights help when that conflict exists? They have the investigatory power too, correct?
It's a good question. Do you mind?
Yeah.
Okay. It's a good question, and they will be here to testify on our other bill. So they do very similar work to this, but in other arenas. So their statutory authority doesn't cover a pattern or practice bill or similar conduct against police departments or these departments. And so they aren't set up necessarily to do that. But it's a similar idea, and I think this is a similar idea, but just a slightly different mechanism.
All right, thank you for that. The next question is, so this would basically equate to like consent decrees in state court?
Yes.
Okay. And then lastly, where would you gather the info to determine a reasonable cause? Would it be just public events, high-profile events? Would it be a data analysis? Would it be, and we know the PABs are going to be having some of this data too. Would it be coming from them?
So no, I really appreciate that question because intake, I think, is one of the most important parts of this. And when we were thinking about the fiscal note for this bill, a large part of this was making sure that we have a good intake system so that you can catalog, what complaints you're getting, and are they repeats, and are you getting different things in from different places? And so I think part of that is outreach, which we do at the Independent Investigations Division already, to make sure that we are hearing from the community, to make sure that people know where to find us, that we have a dedicated phone number and a website and a form, and that we are talking to people in the community and hearing from whether it's lawyers or activists, so that when these things happen, we know about it and we can catalog it and see when it's really a problem.
All right, thank you so much. Thank you, Mr.
Thank you, Mr. Chair, and thanks for being here today. I have a question and practical example in practice, so walk me through this. Let's say I have a concern about the use of law enforcement quotas, and thanks for your support, by the way, on that issue. So I've identified what I believe is a course of conduct that indicates to me that there's a problem. When I call around, I talk to a lot of law enforcement around the state. They actually tell me it's worse than I believe it is. I'm actually told in some places they have quotas for the use of warrants. The law enforcement actually has to deliver a certain amount of warrants in a particular month. I think the civil rights issues with this are pretty clear. So tell me, is this an example that maybe you would look at? And if so, how would you exercise that?
The answer is yes, that is the type of issue, and I won't talk about any jurisdiction in particular, but yeah, in theory, if people are using quotas and they are using them in ways that violate either state laws or the United States Constitution or the Maryland Constitution, that's exactly what this power would look for.
And how does that work? What do you do?
So it's a great question. There is an investigative process, and one of the things that is outlined in this bill is the authority to have investigative subpoena authority, so that before you file suit, because filing suit or initiating a consent decree is a major step, and you don't want to do that on a whim, and you don't want to do that without sufficient evidence. So there is, and this is based on what DOJ does, but different states have started doing this, there is an investigative process that you make sure that what you are looking at is real, and there's a lot of documenting of paper, and there's interviews and all of that, building a record so that you are sure you have it when you do it.
Okay, thank you so much.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here. I just have one quick question. Well, maybe it's two quick questions. I know I'm violating my own one question thing. So it relates to the last time I could recall that you all ran into a wall with a subpoena, and it was, I think, one of the attorney generals was investigating alleged discrimination at a country club in Montgomery County, and I believe that issue was, well, can we even see the membership rolls and who applied and all this to know if there was in fact discrimination? But I believe you didn't have subpoena power in that case, and I think that this would have been decades ago. And I think that just went unresolved. Is that the type of case that might fall into this bill?
I'll take that. Delegate Moon, you have teed up perfectly the next bill. But since you've asked the question, let me offer you the best answer I can. The case was brought by one of my predecessors and mentor, my understanding is, Steve Sachs, who was looking at a race-based discrimination case at a country club in Montgomery County. And he came into court, and he filed it, and the court said, what are you doing here? He says, I'm standing in the shoes of Marylanders in my parent parenti authority, right, common law authority, okay, to protect Marylanders against race-based discrimination. And the court said, out, you have no authority. Interestingly enough, soon thereafter, the Maryland General Assembly very narrowly, and I saw this recently, very narrowly passed a bill that gave the Attorney General to look at discrimination at country clubs. Now, the next bill you hear is going to be a little broader than that. But recognizing that in Maryland, and again, it relates back to the other question about the quo warranto authority. In Maryland, and this is why you're probably wondering, why is the Attorney General coming down always asking for more authority? If you were to line up the 50 states and even the territories and, the District of Columbia, and you said, how much authority do you have? Common law authority, right? You'd have states up here, right? And Maryland is like down here. I've got some of the fewest common law authorities. I have none, actually, because in the mid-1800s, when this General Assembly abolished the office of the Attorney General and then reestablished it a few years later, in that case that Steve Sachs argued, the court said at that time, all of your common law authorities were extinguished. So the only authorities you have now are found in the Maryland Constitution or in statute. So
that was going to be my next question is, because the next example I could think of was when I think the Board of Elections had problems when they ran into Governor Hogan, had thousands of overlimit donors, but they had, I think, no subpoena authority to look at the corporate, ownership structure of donors and the LLCs, and so the matter just sort of evaporated as far as I'm concerned. But that was going to be my question. Why these one-off bills then, where we're, nickel and diming very specific subpoena power and subject matter instead of just ripping the Band-Aid off?
Well, Mr. Vice Chairman, you're now teeing up what I am referring to on my team as OMA 24. What is that? The Office of the Attorney General Modernization Act of 2024. We are coming in next session with, and we're going to catalog all of these areas where every term, in the beginning of the term, I did it this term, and my predecessors have done that before, we send a letter to the governor. I think this year it was 13 pages long, and I had to outline all of the authorities that I need for him to give me in order to do my work. Now, it's okay, most governors, and it's not a partisan thing, Republicans and Democratic governors, Governor Hogan's willingly signed most of them for my predecessor. But you remember, Brian Frost came to the General Assembly in 2017 and said, look, I want to be able to file actions against the federal government when they're doing harm to Marylanders. And in that case, then Governor Hogan wasn't going to sign that letter. You gave Brian Frost the authority, and he put it to good use as well. So we're looking in that, and I do think that we can do better. We can look at other states. What authorities do they have? What makes sense for Maryland? So we'll be back next year for that one.
Any further questions? All right, seeing none, thank you both very much. We'll go to your second panel. which will include Heather Warnken, Jason Downs, Nicole Duemle, and Jonathan Smith.
Mr. Chairman, Nicole's not going to do it.
Okay. All right, well, if that's the case, then I could add more people to this panel, then that's what I'd, let's have Debbie Levy and Sumil Trivedi. Let's go ahead from Maryland Legal Aid. Who would like to go first? Usually I start at the right and move over if you want to. Are you okay to
right
begin?
or skiers right? Sure.
Yeah,
I'm
my
proceeding.
right.
Okay.
Your left. Sorry, go ahead.
Thank you. Good afternoon, Chairman Clippinger and Vice Chairman Moon. It's nice to see you all. My name is Debbie Levy, and I'm with the Office of the Public Defender of Maryland, and we're here to urge a favorable report on House Bill 771. We're doing so for 3 reasons. OPD is the largest law firm in the state of Maryland. We represent the most amount of people who interact with law enforcement through the criminal justice system, and it is our contention, and that of others, that there are deeply entrenched patterns and practices that exist within some of our state's law enforcement agencies that result in countless unnecessary and preventable civil rights violations. Number 2, there is no other entity within our state government but for the Attorney General's office who is appropriate to or capable of undertaking a patterns and practice investigation and addressing the harms that are meted out across the state in the form of civil rights violations. And number 3, the federal government, who could do this, is simply not able to respond promptly enough. I included in my written testimony for you today a photograph of an individual who was brutally and unnecessarily beaten by law enforcement in Baltimore. That is just one of hundreds of examples that we have come across of unnecessary beatings and civil rights violations. That act of brutality laid secret for over 10 years, and it was a long wait before the Department of Justice came into Baltimore to determine that there was a pattern and practice of unconstitutional policing. These kinds of harms don't just affect individuals, but entire communities, and we do not have time to wait for more senseless acts of violence and preventable deaths to occur within our state while the Department of Justice decides to make Maryland a priority amongst all of the other states who are rightly so clamoring for help. Put simply, there is no other agency equipped, authorized, or able to do this in Maryland other than the Attorney General. The passage of Anton's Law has not created the kind of policing that we yet strive for in the state of Maryland. We need independent oversight, and we urge a favorable report of House Bill 771. Thank you.
Good afternoon. My name is Jonathan Smith. I'm the Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. More relevant to this proceeding, I was Chief of the Special Litigation Section of the United States Department of Justice from 2010 through 2015. The Special Litigation Section is the portion of the Civil Rights Division responsible for the pattern and practice investigation of law enforcement, correctional facilities, and any place where someone was confined, the CRIPA statute that you heard earlier. Since leaving the Department of Justice, I've also served as a consultant to the Attorney General of Illinois on the investigation, its investigation of the Chicago Police Department and the current ongoing investigation of the Joliet Police Department, and worked for the state of Minnesota in its litigation against the city of Minneapolis in the development of reform of the Minneapolis Police Department. We invest in all of our corrections and law enforcement officials extraordinary power, and those powers have to operate within the bounds of the law. And the failure for the patterns of violations of those powers have an enormous, significant impact on public safety and trust and legitimacy in police departments. And I've seen pattern and practice investigations work. They address widespread problems in communities that need to be addressed. They result in improved policy, training, and significantly internal accountability. I've been involved in about 30 pattern and practice investigations of law enforcement and maybe more like 50 or 60 in correctional facilities. And I can tell you in each and every one of those, lack of accountability has been at the core of the problem. They increase trust and legitimacy in communities that is absolutely necessary for law enforcement to play its appropriate role in the creation of public safety. They protect the public fisc by reducing the level of litigation that results from tort damages and injuries that people experience. And importantly, They hold law enforcement and other institutions to the kind of accountability that communities expect from their public officials. I have much more to say, but I'll end there.
Good afternoon, members of the committee. My name is Heather Warnkin, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in support of HB 771. The similar power bestowed in the U.S. Department of Justice to conduct pattern or practice investigations and compel corrective action has in many places been impactful in holding police departments accountable and in mitigating substantial harm. However, the reach and results have at times been slow and limited. We discussed the reasons why in our written testimony, including that DOJ has the ability only to investigate less than 0.02% of the country's law enforcement agencies each year. Our center firmly believes that placing this authority in the state attorney general is not only needed to expand the reach of this work, but will enhance the effectiveness of it as a tool for change. This change must be measured not in numeric counts of updated policies and procedures intended to correct systemic problems, but in the lives of residents able to say whether they actually did. The state AG is better positioned for ongoing collaboration with the community. Residents bearing the brunt of rights violations in particular are the most important voices in this process. They must continue to have a meaningful seat at the table in designing legally enforceable remedies and in the ongoing follow-through needed to implement, measure, and sustain real change. Unlike U.S. DOJ's leadership, who reports to the chief executive, the Maryland Attorney General is elected by the people and sworn to protect the rights of all Marylanders, thereby more insulated, relatively speaking, from shifting priorities that occur at the state and federal level. And lastly, this tool also benefits public safety, as rooting out patterns and practices of rights violations is a significant part of the work of improving the community relationships needed to solve crime. We urge a favorable report.
Please.
Thank you, Chairman. My name is Somil Trivedi. I'm the Chief Legal and Advocacy Director at Maryland Legal Aid, the state's largest nonprofit law firm, no competition with OPD. We provide free civil legal services to tens of thousands of low-income Marylanders every year, but we don't represent criminal defendants. So why are we here testifying on a law enforcement bill? Well, that's because, as the chairman knows, what happens in the criminal justice system does not stay in the criminal justice system. Law enforcement misconduct has devastating and compounding economic and social consequences for people, their families, and their communities. We represent those people in court when, because of a questionable arrest, or because prison has broken them instead of rehabilitated them, they're now faced with eviction or job loss or family separation. We're there when they lose their driver's licenses due to unpayable and potentially unconstitutional fines and fees, so now they can't get to work, they can't feed their kids, they can't take care of their aging parents. That is to say, we know the true cost of law enforcement misconduct and therefore the true value of accountability and, via the injunctive relief in this bill, the value of preventing those harms before they occur again. Now, we do abut the criminal justice system through our civil expungement work, where we've represented over 11,000 people in the last 5 years, sadly nearly 60% of them black and brown, and far too many of these clients complain that they've been subjected to illegal searches, thefts of property, and excessive force, and they beg us to not only represent them in civil court, but also to sue the officers who wrongfully pulled them into the system, and it breaks our heart that we can't. In fact, even if we banded together all the nonprofits in this room, we couldn't help everybody who needs it. Yes, we have the clients, but we don't have the subpoena power, we don't have the reach, we don't have the resources. This bill is a major step to getting us those tools and forming that partnership, and that's why Maryland Legal Aid supports it. Thank you.
Are there questions for this panel? Okay, seeing none, we thank you all very much. We'll go to what I think is the last panel in favor of the legislation. Jason Billingsley, Lisa Barkan, Jason Downs. I don't know if I called Jason Downs last time and we just didn't see him.
I don't believe he's here.
Okay, that's fine. So we'll hear, this is the last witness in favor, and then we'll take questions and then go to the opponents. Go ahead.
Hi, my name is Lisa Barkan, and I'm here with the League of Women Voters of Maryland. The League's mission is to empower voters and protect democracy. In order to do so, there has to be, the civil rights of all people must be protected. And in addition to do so, it's very helpful for government transparency and accountability. The Attorney General's Office is an independent entity that can conduct impartial investigations, which will strengthen the public perception of government. In addition, it has experience in handling and conducting extensive and complex investigations into systematic wrongdoing and has handled complex cases to stop pervasive misconduct. Additionally, it is the statewide office that can do these investigations and can ferret out discrimination in many places where people are being held in custody or people are being supervised by various county and state agencies. And the impartiality is further shown in the Attorney General's decision to help create a separate entity that would do investigations when it has a potential conflict of interest because it represents state agencies, and then otherwise it would also be investigating the same state agencies. Thank you.
Questions for this witness? Seeing none, thank you very much. That concludes the witnesses in favor of the legislation. Mr. Kroll, please. Do we have Mr. McAvoy? Put him up as well. Mr. Kroll for 2 minutes.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases since 1984. And to answer Delegate Phillips's response, there is nothing in this bill, the way we see it, that says we cannot be sued by the Attorney General, and that's why we're asking to be exempted from it. And I say that because no one here asked the Attorney General, do you have the authority under this bill to sue state's attorneys and assistant state's attorneys? That was asked in the Senate. His answer was no. If the answer is no, we want it documented in writing, because it's not that we don't trust this Attorney General. We do. But it's the next Attorney General and the next Attorney General after that. So what we're saying is take us out of this particular bill. And we say that for several reasons. Number one is the bill does not and should not cover state's attorneys. Imagine trying to recruit people to be assistant state's attorneys, and they say, well, can I be sued? Do I need to get insurance? Who's going to pay if I get a judgment against me? No one's going to want the job. You know where they're going to go? The Attorney General's office or the U.S. Attorney's office. This bill puts a damper on us to recruit, and it still gives the right of the U.S. Attorney to supervise state's attorneys and assistant state's attorneys. So to answer your question, Delegate, we don't have the same confidence that you have. And that question was asked in the Senate but not answered and asked here. And again, it's not this Attorney General, it's the Attorney Generals to come. And people would say, where are we to protect the assistants who are there? It's going to be some assistant who's doing what? A gun case who's going to get sued. Some elected who's doing a gun case who's going to get sued. And quite candidly, by exempting us from this bill, it protects state's attorneys. We're not asking, we don't think we're privileged, we don't think we're special, but we have a job to do, and that is to administer justice. And administering justice, we need the protection to do it right. And for those reasons, we ask for an unfavorable report as to House Bill 771. And I know there's going to be some questions.
Mr. McAvoy, please, for 2 minutes.
Thank you so much, committee. I'm against this bill. I want to highlight for a lot of people that may not know that the Attorney General's office is the largest law firm in the state. And I understand that we have an AG who just got in there and is getting acclimated. But before asking for additional powers, it just seems prudent to go ahead and test out the wheels, if you will. I want to speak briefly onto something that frequently comes about from this type of legislation. And incidentally, it's different, even though other states are mentioned. It's different from Maryland because we have so many commissions, we have so many watchdogs, we have so many whistleblowing techniques. But it's different for the state, and so when we hear that consent decrees are frequently the product of this type of legislation. Understand that in Baltimore, nobody is doubting that the Baltimore City Police Department is being scrutinized with a fine-tooth comb. Nobody is doubting that we're losing our war on crime due to officers having issue with that consent decree because it is unjust. But we do have an issue with crime in the city, and it's not being addressed. I want to now go to focus on page 2 regarding immigration detention facility. The AG's predecessor, who we all know in General Assembly, said at some point, 2017, 2018, I can't do the job I was elected to do, or I can't do the job that my title says because of Trump. And this issue where we have someone who's operating outside the scope to the problem with a bill like this, which is expanding power, but this hasn't been checked. As a corollary and in closing, I want to say that the current problem we have unabashedly open border right now is not being handled by the Attorney General's office. It just seems logically we can't have
Thank
it
you,
post
Mr.
race.
McAvoy.
Thank you for your time.
Thank you. Are there questions for this panel? The Vice Chair, then Delegate Cardin, then Delegate Young, then Delegate Kaufman.
Thank you, Mr. Chair. I'm just trying to understand, I guess, what sort of specific scenarios you think might be in or out that concern you, because I guess I'm having a little difficulty, wrapping my brain around exempting one particular law enforcement wing from being investigated if they have a pattern of depriving people of rights. And I guess most of the named government entities here are on the law enforcement spectrum, A, and B, they have the ability to have people detained, arrested, otherwise incarcerated, and these are pretty serious powers. But in recent news cycles, I've not actually heard how some of these stories are resolved, but we have some acting state's attorneys and state's attorneys where whole courts in the state won't hear cases if that particular person was bringing them because of things happening in their office related to not disclosing evidence or something like this. Now, we do have our legal ethics procedure, as I've pointed to in past legislation, or just one means of handling this, but why wouldn't that be, if it turned out there was a pattern of that, why wouldn't that be an appropriate matter for the Attorney General to investigate?
Well, the first thing I'd say, Delegate Moon, is we favored this bill, but for us being in the bill. So let me just say we're for civil rights. Let me point that out. The second thing is there is a pattern due to the next bill, and I don't mean that the Attorney General said that, but due to the next bill we'll talk about the intricacies of what happens, which I'll deal with at 772. So if you allow me just to pass on that question until 772 comes up and explain why, when it comes to the conflicts, to go over that. My point being is the U.S. Attorney's Office could come in and do the same investigation. I have the utmost confidence in our U.S. Attorney, and that avoids all the conflicts, and I believe he can conduct the proper investigation and the right investigation.
Thank you, Mr. Chair. Thank you, Mr. Kroll, for being here. It's always a pleasure. It seems like based on the testimony, oral and written, from the Attorney General, that the intent is to exclude the state's attorneys. Is that correct?
I didn't hear that directly. I heard it in the Senate, but I didn't hear it here.
Okay. Well, when he was asked, I think, by Mr. Phillips and then Ms. Embry, he specifically said that the law is clear, that they do not believe, based on his review, that they would have the authority to pursue in the state's attorney's office, and that was not the intent of the bill. Now, maybe you didn't hear that here, but that's the way I read it. But that's not the way you hear it here?
And again, it's not this Attorney General. I want to point that out. I do have the utmost confidence in him. It's the next one and the next one. The court system that, quite candidly, Delegate Cardin, you dealt with, and there's no guarantees with the court system whatsoever. So if there's one statement in page 2, line 14, that says, "This bill does not include state's attorneys or assistant state's attorneys," I welcome to support this bill. I'm asking for one line, one line, and the answer is yes.
So that brings me to my next question, which is that the Attorney General was pretty explicit with possibility of unintended consequences of doing that, which could cause additional burdens on the state's attorney's office in terms of if they put in the language that they believe you would require, it could implicate you guys being covered under other regulations, such as the police reform matters. That was the example that you gave.
The answer is, if it's in under Maryland Public Safety Article 3-201, the answer is that would be yes. We're not asking for it. We're asking to put it in the bill itself. Page 2, line 14, this bill does not include state's attorneys and assistant state's attorneys. It does not come in under 3-201 of public safety. It comes in this bill. So you don't have that conflict. It solves the problem.
Okay. I'm going to review that and see if that's actually true, because I'm trying to digest it all right now is not possible. But it seems to me as if the intent is that everybody wants to be on the same page in what we're trying to accomplish, but we have two different ways of doing it. So at least we have that out on the...
I want to...
Mr. Chair, maybe you might understand this stuff better than I do, but it's going to take me a little bit of time to figure out how to accomplish that. Thank you, Mr. Chair.
Before we go, you're down? Okay. So just, again, one more time with feeling, I guess, what you would be advocating for is language that would say specifically related to this specific section of the law.
Correct.
Not related to the definition of law enforcement agency generally, that this specific section of the law would not apply to state's attorneys.
Correct. And I'm happy to support this bill.
Are there other questions for the panel? Seeing none, we thank you very much, and that concludes the testimony to House Bill 771. We're going to go now to House Bill 772, which is what we started to hear, and then, yes, the Vice Chair just announced he was confused, but we're good now, and now we're going to hear it. Again, the Attorney General, please. Dana Mulhauser. I think that's it. Glendora Hughes as well, and there you are. All right, fine. Mr. Attorney General, go ahead.
Once again, Mr. Chairman and members, it's great to be back on number 2 of my top 2 priorities, and this bill is a really measured approach that gives the Office of the Attorney General the authority to investigate, prosecute, and remediate civil rights violations by private actors. It does not apply at all to public entities, any public entity in Maryland, only private actors. It's a measured approach, and it doesn't create any new categories of protected persons or groups or classes of people, nor does it create new practices that are deemed discriminatory. Mr. Chairman, what the bill does, it provides the Office of the Attorney General with the authority to protect Marylanders from discrimination based on race, color, religion or creed, sex, age, ancestry or national origin, marital status, physical or mental disability, sexual orientation or gender identification, as well as discrimination based on genetic information in employment and familial status or source of income and housing. These are all protections that currently exist under Maryland law, but are all too often unenforced. So by way of example, with this authority, my office would be able to safeguard families from being denied housing because they have children, defend employees' right to wear a headscarf at work, protect homeowners from being denied mortgages because they live in a minority neighborhood, preserve accessibility for disabled individuals who require wheelchairs and wheelchair ramps, and ensure fair wages for women and people of color, just to name a few. This bill will supplement the important and successful work being done at the Maryland Commission on Civil Rights, and I'm so honored that Glendora Hughes is at our side testifying in support of this. They have done fabulous work for the last 53 years, investigating looking at claims in fair housing, public accommodations, employment discrimination, commercial practices. They're joining us today. We view them as partners. Ms. Hughes will describe what that partnership looks like. We're very excited that also in the bill, we are creating a civil rights enforcement fund from any civil penalties that are recovered, and there will be. That's not the motive of the bill, but there will be civil penalties recovered. It'll go into a fund that will provide funding for enforcement actions both in the Office of the Attorney General and the Maryland Commission on Civil Rights, as well as education to protect Marylanders. Mr. Chairman, establishing civil rights authority within the Office of the Attorney General is not novel. I mentioned in response to Vice Chair Moon's question, this is a recognized best practice throughout the United States. At least 21 states have civil rights enforcement authority vested within their Attorney General, including our neighboring jurisdictions. It's a model used at the federal level. The Department of Justice has its Civil Rights Division. They also have the EEOC and HUD that does administrative type stuff. So it's a model that's been used at the federal level. It's in 21 other states. And, Mr. Chairman, we ask for a favorable report of this bill with the amendments that Ms. Dana Milhauser can describe.
Smallhauser, please.
Thank you very much. I'm Dana Mulhauser. I'm Chief of the Independent Investigations Division at the Office of the Attorney General. I want to make a few more technical points about this bill. The first is that all the authorities in this bill are civil. They are not criminal. This is only a right to sue. It is not a right to prosecute anybody. As Vice Chair Moon was discussing earlier about subpoena power, this bill also, as with the prior bill, has subpoena power, and it also has the power of injunctive relief in it. I want to talk a little bit about the sponsor amendments, which are fairly minor in this bill, and they have to deal with some more technical aspects. A couple of them deal with the relationship with the Commission on Civil Rights and just spelling out a little bit more clearly what their authorities are and how we would work together. The other amendment, and I think the most substantive of these, is to make as clear as possible that this bill does not give a right to sue any governmental entity. So the bill, as it was originally drafted, said there is no right to bring a bill again or bring a suit against a political subdivision. The sponsor amendment would add to that any subdivision or any body of state or local government that is established by law. So I think that covers the waterfront. And the last thing that the sponsor amendments do is we got some really good feedback making sure that nothing in this bill inhibits the ability to bring, for other entities to bring criminal investigations or criminal suits when that's appropriate. And so we have some amendments to make sure that nothing in this bill inhibits that. So those are in the Attorney General's written testimony, but I'm happy to take questions.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Glendora Hughes, General Counsel of the Maryland Commission on Civil Rights. As has been described, this bill, House Bill 772, amends the state government article Title 20, which is the statute that the commission enforces. It does not impair the rights and powers of the commission. It does not interfere with the sole jurisdictional authority, and one of the amendments is very specific of the sections that are covered by the Maryland Commission on Civil Rights. What it does do is give the Attorney General authority to enter into the field of civil rights and support the work that the commission is carrying out. And part of the preparation and drafting the bill, the commission was involved in cooperatively working with the Attorney General's office with the language to ensure that there is a smooth partnership in the carrying out its mandate. Where there are areas of overlapping, there is going to be, through regulations, a process in which we make sure that we're not duplicating and that we are cooperating on those issues. We welcome the Attorney General in the area of civil rights because there are areas that the commission doesn't have jurisdiction over, like police departments, education, and voting rights issues. And therefore, there's plenty of work in areas that the Attorney General's office can fill the gap. This is similar to the broad partnership that we have on the national level with EEOC and HUD. and now we have it in Maryland in terms of the relationship with the Attorney General's office, and we ask for a favorable vote on this bill. Thank you.
Questions for the panel? Delegate Bartlett, I see you, and Delegate Kaufman to follow.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for bringing House Bill 772 and all the witnesses. I have a question for Mr. Attorney General, and then I have a question for Ms. Hughes. My question for Mr. Attorney General is that, I know and I appreciate and have worked with the Consumer Product Division of the Office of the Attorney General, and I know that you gave a list. I wrote some of them down on some of the ways that that you all that this authority would help further protect Marylanders. You mentioned housing, employment discrimination, and are there any others that you would like to include? I just kind of want to get an idea of some of the areas. And the reason why I want to ask Ms. Hughes her question, because she mentioned about the overlap.
Well, thanks for the question, and it really gives me an opportunity, I think, to illustrate the power, the potential of this authority. And I want to do it by way of comparison. Okay, 50-plus years ago, you gave the Office of the Attorney General Consumer Protection Authority. Every year, we're out there protecting your constituents, our consumers in the marketplace, right? We use that sometimes in a creative way. For example, many of you know that last year we settled a case with Westminster Management Company. They had 9,000 rental units under management in various properties throughout the state. And we brought an action under consumer protection for misleading and deceptive trade practices. Why? They show a renter a nice, pristine showroom model, and then they put them into substandard housing. They didn't provide maintenance. They charged them fees that they shouldn't have charged. We settled and recovered a $3.25 million settlement for the state, but more importantly, we got injunctive relief for the renters. Some of those actors, bad actors, will never rent again in Maryland. And for the renters, the ability to recover damages in that case. That's what we did with Consumer Protection Authority. Give us the authority to enforce civil rights laws in Maryland, and we'll deliver the similar results. And here's an example. When I was sitting in that seat over there, where I think Delegate Taylor was sitting, that was one of the first few years when we started debating source of income discrimination, right? Using Section 8 vouchers in housing, and you can't discriminate in Maryland. Well, it took 15-plus years until the General Assembly finally passed that. It's not necessarily being enforced in Maryland the way it should be. A year before we passed it, they passed the same discriminatory prohibition in the District of Columbia. And last year, the Attorney General in the District of Columbia, now former Attorney General Carl Racine, he settled the largest housing discrimination case in the history of this country, $10 million. He got injunctive relief. Many of those real estate management individuals can no longer participate in that market in the District of Columbia. He did it because the District of Columbia passed a law prohibiting discrimination based on source of income. Give me that authority. We'll provide that kind of protection to Marylanders. That's one example. And that's the difference between the work that we can do and the fantastic work that's being done at the Maryland Civil Rights Commission. They'll do the one-offs here. They'll take a complaint in housing here, and they'll take a complaint in housing here. We widen the aperture. We're looking at 9,000 units under management. We're getting complaints here, here, and here, filing those subpoenas. We got the investigators. We got the attorneys. We're going to bring relief. We're going to protect Marylanders. This is not about money. I mentioned the money just to give you a sense of magnitude. This is more about the protections and the injunctive relief that we can bring to Marylanders when we identify, investigate, and help remediate civil rights violations.
Thank you. And, Ms. Hughes, I was going to ask you a question, but actually, Mr. Attorney General kind of got to it. And that was, and you mentioned it in your testimony, and I appreciate that, when you were talking about that any areas of overlapping that you all would make sure that, you didn't have that and that you weren't duplicating efforts, which is great. You have to have that level of efficiency. And then Mr. Attorney General alluded to something and that is some of the larger type cases or that are, that his office might be able to handle because of the number of investigators and the number of attorneys that are present. Would you agree with that, my understanding of that?
One of the conversations we had in terms of framing this bill and working on the bill is in the areas of overlap. We get individual complaints, but sometimes as we are going through the individual complaint, we recognize that it may be larger than just this one person. This is an instance where we can contact the Attorney General's office and say, look, this looks like this is bigger than this one person. You may want to take a look at it. Vice versa, someone may go to the Attorney General's office with an individual complaint, and they may say, well, we'll refer you to the Maryland Commission because that is their jurisdiction. We have jurisdiction over the individual complaints in the state government article. And yes, we do have authority to do class and pattern practice and commission complaints, but that is something through the regulations we will talk about defining how we're going to cooperate in those issues. We may intervene into each other's cases depending on what it is, or we may just release the case altogether. And it is, honestly, in terms of resources, it is very difficult. And we've tried. We've had a systemic unit, which was cut because of cost containment, where we did go into the area of doing a large investigation on mortgage lending. And having the support of the Attorney General's office on those kinds of issues is imperative in terms of addressing the violations in the civil rights field.
Mm-hmm. So essentially, we're getting two sources that we can refer constituents to. Thank you.
Basically.
Thank you, Mr. Chair. Mr. Attorney General, it's good to see you as always. And to, you were vice chair here, so I can't help but turn to my friend, Delegate Moon, and say you too could be Attorney General one day. Mr. Chair, I have two questions, if that's all right. Just always try to make it a little more fun. Mr. Chair, I think that, Mr. Attorney General, Mr. Attorney General, I wanted to just talk to you about how, from where I sit, pun intended, I think far too often people with disabilities are the forgotten minority, even though we're the world's largest. For the people listening at home, I have cerebral palsy and use a walker. And are you committed, if you're granted this authority, to making a significant focus of the new authority, disability rights work? Because from my personal experience, almost 33 years after the ADA, it's still not being totally followed, and there's still so many violations. And my second question, and I'll let you tackle them both, is you mentioned wheelchairs and walkers and things like that in your testimony, which I appreciate. But the other thing that I would mention to you, because that's Title III and Title II and Title III of the ADA. But the other thing that I would mention that I think is often forgotten is that Title I is employment. And there's still a great deal of employment discrimination that you can tackle. For example, when I was looking for a job and I went to the University of Maryland Alumni Association for advice as I was preparing to send out resumes and stuff, the woman said to me, Aaron, do me a favor. In your cover letter, don't mention that you're disabled and don't list the accommodations that you need, because if you do that, it'll go straight in the garbage. Now, I know you won't be, you will only be looking at people with an egregious pattern of discrimination, but I would encourage you to look beyond brick and mortar discrimination against people with disabilities to employment and other areas. Thank you.
And thank you for raising that. I, of course, had a short list of examples, but look, I view the American with Disabilities Act as one of the greatest and among the greatest civil rights legislation ever passed in this country, and perhaps to this day, one of the least enforced. So this gives us a true opportunity to enforce federal and state civil rights laws, every title and every component of it, unless otherwise prohibited by law. But that's why we're here today, to get that authority so that we can enforce all of the titles of the ADA, not just the brick and mortar that I happen to include in my litany, my short litany of examples.
I do want to add that in terms of data with the Maryland Commission, if you look at our annual report, disability complaints are probably the second largest number of complaints that we receive after retaliation.
Thank you, Chair. You mentioned in the beginning of the testimony that this was for private entities, but then Ms. Hughes had brought up police officers. Would public officials fall into that? I mean, can you elaborate on that for me?
And I appreciate the question. I did notice the conflicting testimony, and for clarification, since you asked, I didn't want to put Ms. Hughes on the spot. I think she was talking broadly about civil rights enforcement. In this bill, this is not intended to, it is not applied to government entities. It is not intended for, nor does it provide for criminal prosecutions.
Against police officers or?
Yeah, against anybody. No, criminal prosecutions against anybody, or civil rights claims against any public entity. Now, the Maryland Commission on Civil Rights does a lot of that work.
Yes, we do. We are able to take complaints from police officers as employees.
Not as individuals, because that gets brought up quite a few.
I mean, the individual
bills
employee may file a complaint of discrimination in their employment, that they're being discriminated in their capacity as an employee at the police department or law enforcement, or we take those complaints, and we have investigated those complaints.
Sure. Okay.
And let me add, if I may, the Maryland Commission on Civil Rights, as I said, fantastic work. A lot of employment discrimination cases, as Ms. Hughes mentioned. A lot of those are complaints against state agencies. I represent those state agencies, so in those cases, we're sort of, we're on a different side of the V on that one.
Right.
And while in the other bill that you heard, we set up an independent entity, we thought that would have been way too unwieldy here. So the cleanest way to do it was to let the Maryland Commission on Civil Rights handle the public sector complaints. We're going to focus on the private sector.
So when you're on the inverse of that relationship, your employees cannot be sued as individuals, is kind of what you're saying there.
When you say my employees, you mean the Office of the Attorney General?
Correct.
No.
Or state.
We Office of the Attorney General, an employee in my office can bring a claim to the Maryland Commission on Civil Rights.
Gotcha.
Thank you, Mr. Chair. I want to ask you the same question about the last bill, but for this bill. Kind of how does this work? And let's start here. So you mentioned a case in D.C. It was a housing case. They ruled it was a violation. Can you walk me through the facts of how that panned out?
Sure. So this legislature, I think it was in 2017, maybe a little bit after, passed a bill that said that a landlord of a certain size, right, cannot discriminate against a prospective renter based on their source of income. Think Section 8 vouchers, because it happens all the time. Oh, you're Section 8? Nope, don't have a place. Hey, I got Section 8 value that will cover the rent. Still not interested. So this body saw that, and we saw it for decades. So we prohibited that in Maryland. Well, the District of Columbia did it as well. That practice was happening in the District of Columbia. There was a real estate management company. I think there were 3 of them. They had about 9,000 units under management, and they were discriminating against would-be renters based on their source of income. So those complaints were brought to the Office of the Attorney General. They did an investigation. They thought it met the threshold for them to go further. They filed suit, and they ended up settling with the management company for $10 million recovery and injunctive relief. Some of the members of those management companies are now prohibited from being in that sector, that industry in the District of Columbia. They put a lot of injunctive relief in terms of what they need to do now going forward. And that's where you get most of the benefit, I think, in these both consumer protection and civil rights cases. It's the injunctive relief. The money's important, and it certainly is for the people who are injured. But again, a lot of this is what are we doing prospectively to create an environment, either a marketplace or housing or wherever we find Marylanders, so that they're living free of discrimination. So it's that injunctive relief, I think, that is perhaps even the greatest value.
and I have a lot of problems with the rental industry. One of the ways they do kind of look at a tenant is they'll do an interview and screen them for various things. They'll interview them at their current place of residence. And in some cases, that's a way they kind of say, I'd like to have this person, but I have concerns about their ability to keep up a property. And that naturally screens people from having people that have a voucher. So I want to give you an example. Let's say a Maryland individual has 5 to 10 rental properties. They don't have any Section 8 holders or any voucher holders currently. That person could come under a subpoena if it was suspected that they had declined a tenant based on their source of income, even though that wasn't necessarily the case, even though they had never asked. That person could be investigated. That person could face a subpoena, and if found guilty, they could be subject to the fines $10,000, $25,000. Is that kind of correct?
That's right. And the other thing I will add, to go back to your question about source of income discrimination, is source of income discrimination is not illegal under federal law. So right now there is no one in the state of Maryland who can do these large-scale cases on source of income discrimination because DOJ can't cover it. So it's a real hole. And there are a few other areas like that, genetic information discrimination, things like that, that are not illegal under federal law, but that this legislature, in its wisdom, has decided should be illegal in Maryland, and it's just sort of whistling in the wind.
And I can extrapolate from there. There was a case in St. Joseph's Hospital. As you know, the University of Maryland is involved there. They had scheduled a case for a gender transition surgery at St. Joseph's Catholic Hospital. And they said, you've scheduled it incorrectly. You're going to have to schedule it somewhere else. They got sued for a civil rights violation. That plaintiff won. Would that be something you could investigate?
Well, and I just want to be clear too, right? We're not creating new practices that are discriminatory, nor new classes of individuals that can be protected. So without knowing the fact pattern of that case, I can tell you that discrimination in Maryland based on gender identification is prohibited. So those types of cases would be considered by us. Now, not looking at the fact pattern of that case and whether we would be in the case, whether we'd find reasonable cause. I've read about the case. I have not investigated the case, so I wouldn't want to comment on that. But gender identification is certainly a protected group of people, class in Maryland.
And if
I
we
do-
did, sorry.
I mean, I just wanted to interject that the Civil Rights Commission does have joint jurisdiction with the Department of Health for that very topic that you brought out in terms of services and facilities discrimination. And also in terms of source of income, the law passed, and we're just beginning to see people bring in complaints. And one of the things that we'll do with this law is if we see a pattern of we're getting multiple complaints from a same management company or from the same property, that would be something we would refer to the Attorney General's office and say, you maybe need to take a look at this particular industry or this particular respondent, because there seems to be multiple complaints coming from that same entity.
Sure. And just to explore the bounds here, like if we put something in the Constitution like abortion, that becomes a civil right. That would be something, if you denied this person an abortion, that'd be something you could enforce.
One of the reasons that we drafted, the answer to your question is yes, and one of the reasons we drafted this bill the way we did, to not spell out this is housing, this is employment, this is discrimination, commercial transactions, is to give this legislature that leeway so that if reproductive rights is a perfect example of this, as this becomes more of an issue, if there are additional protections, that the Attorney General would be empowered to protect those as well.
Okay, thank you.
Thank you, Mr. Chair. I wasn't going to ask the question initially, but then you opened up the door when you talked about the 771 juxtaposed against 772 and some conflict of interest. You just mentioned that in a response. I just want to give you an opportunity to respond, I don't know, whomever you deem appropriate, to the unfavorable or the issues raised by the Maryland Chamber of Commerce, specifically that that we're concerned the legislation will allow the Attorney General to circumvent, potentially undermine the critical work of the MCCR. The language would grant the Attorney General the ability to disregard any active or ongoing investigations undertaken by the MCCR. To avoid potentially contradictory or duplicative investigations, they believe that the Attorney General should wait until, or should not use its limited resources until after any of those investigations are completed. Is there any response you have to that? And then the other issue they have is they say that there could be a potential issue, conflict of interest, where 771, or, I don't remember which one is which now. The other bill that you were talking about, that you brought to us, deals with public sector. This deals with private sector, and it could establish an unhealthy double standard, an overly complicated two-tiered justice system. So if you can maybe just preempt anything that they may say to us.
Yeah, I guess what I would just say, I mean, look, a picture's worth 1,000 words, so take out your iPhones if it's permissible in the committee and just take a picture. I mean, we're sitting here together, and our conversations around this bill started with the MCCR. We were like, look, they're doing fantastic work. We're not trying to be duplicative. We're also mindful of taxpayer dollars. The analogy, if you will, is look at the federal government, right? There's a Department of Justice Civil Rights Division. There's also the EEOC, right? You do a lot of work referrals from the EEOC. There's HUD that does administrative complaints around housing discrimination. So, and in many of those 21 states that I mentioned, you have an administrative body that's able to take these complaints, and you have an attorney general who's able to bring these cases. Part of the bill, as you'll see, requires us to develop regulations. I think that's some of the amendments to make sure that we are clear. And I think the fact that we're both sitting here together, all three of us, quite frankly, demonstrates that concern raised by the chamber is just unfounded. So the second one about the double standard, that's so confusing that I'm not really know how to handle it. I mean, these are two separate bills. Pattern of practice, okay, you know, the identities that we're looking at, okay, it's non-criminal, okay, and we have a walled off if it's a state entity. Civil rights enforcement, which we're talking about here, is non-criminal and it's private sector as far as the Attorney General's office is concerned, right? MCCR, they do some public sector stuff. We're not changing that jurisdiction in this bill. So I think they complement one another in that sense. They complement one another in the sense that we're adding additional protections and for Marylanders.
Thank you.
Any other questions for this panel? Seeing none, we thank you very much. Mr. Attorney General, are you heading out the door, or?
I can stay. I'll make your.
Well, let me do one thing before we go to the next panel. If the pages would come up and say hello to the Attorney General, that would be very nice. Because the
Do we
pages.
have time for a photo too?
Over there, yeah, sure. The pages, for some reason, we are the only committee that they come to. They only come here, and I'm not sure why, but I wanted to take this opportunity.
Let's get a picture. Who's taking the picture? Let me say, Mr. Chairman, while we're convening for this picture.
I'll do that here real quick.
While not we'll get that thing. While not a page, my very first intern that I had when I was a member of the Judiciary Committee, he was my first intern, and this was his first internship. Well, he was going to testify today, Jason Downs. He just finished as the Chief Deputy Attorney General in the District of Columbia. So you too, one day. Chief Deputy, yes indeed.
Thank you very much, Mr. Attorney General. Thank you very much.
Thank you so much.
Thank you.
We'll make sure.
All right.
Thank you.
One moment. All right. All right, so now the second panel, now that I just, blew up things. Lisa Jordan, Michelle Seary, Tiffany Relaford, Vicki Schultz.
Lisa Jordan and Michelle are across the street.
Well, that's a terrible idea. Willie Flowers, I'm going to go down the list then, and maybe Willie Flowers also. Lisa Barkan, who was here before, we could have you come back up. Andrea Finuccio. And I see Lauren Pruitt on from Free State, and so we'll add her to this panel. If others come back from across the way, we'll add them in, but let's go ahead right now. Please, from my right, your left across. Thank you.
Thank you. Good afternoon, Chairman and committee members. My name is Tiffany Relaford, and I'm an attorney in private practice, namely focusing in one of the areas of employment law. As a former commissioner for the Montgomery County Human Rights Commission and a current commissioner for the Howard County Human Rights Commission, I ask for a favorable result with regard to House Bill 772. House Bill 772 would give the Office of Attorney General civil rights enforcement power that is integral to the power vested in attorney generals in approximately 21 other states. The enforcement authority would allow the Office of Attorney General to assist the Maryland Commission on Civil Rights in investigating and remedying violations of Maryland civil rights laws. Currently, as you previously heard, the Maryland Civil Rights Commission lacks the resources to bring systemic challenges or engage in pattern and practice investigations. This has created a void in which some have expressed concerns that systemic abuse in particular civil rights areas may be occurring within Maryland and going unchallenged by state governmental agency. If given the statutory authority sought in House Bill 772, the Office of Attorney General could fill this gap and bring high-impact litigation to enforce state or federal civil rights laws. In addition, the bill would give the Office of Attorney General subpoena power. This is a compelling mechanism that can motivate private entities to promptly remedy civil rights violations. Further, I support this bill as the bill's establishment of Civil Rights Enforcement Fund would reach a broader base to provide education and outreach to prevent discrimination. In closing, I urge a favorable result of House Bill 772 as the bill is necessary to ensure civil rights violations are prohibited in Maryland and that violators are held accountable.
Chairman Clippinger, Vice Chairman Moon, and members of the committee, thank you for the opportunity to testify on this bill. I'm Vicki Schultz, Executive Director of Maryland Legal Aid. We're a statewide nonprofit firm that provides free civil legal services to low-income and vulnerable Marylanders. We urge support for this bill because it gives the Attorney General's office critical tools to combat discrimination that is often difficult, if not impossible, to prove by the victims of that discrimination, even by nonprofits such as ours. Our clients live in low-income communities that disproportionately suffer the legacy impacts of discrimination, which was often enshrined in public policy throughout much of our history. Regrettably and yet inescapably, our clients continue to experience and suffer harms due to discrimination. However, bringing such cases is complicated in today's environment. I was engaged in such enforcement when I was a Deputy Assistant Attorney General in the Civil Rights Division of the Justice Department during the Obama administration, overseeing the enforcement of fair housing and fair lending laws. Some of the department's largest fair lending cases, such as those against Wells Fargo and Bank of America Countrywide, required multi-year investigations involving tens of thousands of records to establish the discriminatory impact the bank's practices had on Black and Hispanic borrowers during the mortgage crisis. They also required substantial monitoring after settlement. There's a vital role for Maryland's Attorney General to play in conducting these complex investigations, bringing these cases, and ensuring ongoing compliance. Our Attorney General has a strong interest in ensuring that all those doing business in Maryland are held accountable for any discriminatory conduct and for violating the law. Our clients need the protections of civil rights laws against housing, lending, employment, and source of income discrimination. While our resources are often insufficient to bring these cases, we have insights and information to refer such cases to the Office of the Attorney General. Maryland Legal Aid urges a favorable report for HB 772. With this bill, the Maryland General Assembly will have taken yet another step toward creating a more equitable society where all may live and thrive free of discrimination. Thank you.
Hi, my name is Lisa Barkan. I am privileged to be here today, and I thank you all. And again, I am still the representative for the League of Women Voters of Maryland. I agree with everything that's been said and want to emphasize that individuals cannot bring these cases by themselves. And even if they did, the results of such a case would apply only to that individual. It's the Attorney General's office, who is the public lawyer and is elected by Maryland residents, who has the resources and the ability to conduct wide-reaching investigations and who can change practices. And for those reasons, we strongly support and urge a favorable report on this bill. Thank you.
Thank you, Chair, Vice Chair, and the members of the Judiciary Committee. I'm Andrea Finuccio, an attorney with CASA, the largest membership-based immigrant organization in the Mid-Atlantic region, with more than 90,000 members in Maryland alone. On behalf of our members, CASA urges a favorable report on HB 772. Overall, this bill would expand the powers of the Office of the Attorney General, and this is beneficial not just for our members, but all Marylanders facing civil rights issues. As a direct provider of pro bono legal services to the low-income immigrant community, civil rights violations are not uncommon to see, specifically in the areas of employment and housing. Almost as common is hearing repeat names, repeat offenders who feel that they can exploit marginalized communities because they will not get caught. As it stands now, our members are often disheartened when they hear that the Maryland Commission on Civil Rights is their only option for recourse. This isn't because the MCCR is ineffective, but on the contrary, their office provides an invaluable resource, and we're fortunate enough to have them working for Marylanders, but a purely administrative avenue is not often something that victims of civil rights violations want to hear when there is an ongoing issue that they are facing on a day-to-day basis. Allowing the MCCR to focus on individual cases while allowing the OAG to go after repeat offenders or offenses that affect a large swath of Marylanders would be beneficial all around. This would allow providers like myself who identify these issues to be able to know who to send complaints to and give us more than one option. Injunctive powers as proposed by this bill is imperative for immigrant safety. Threats of deportations or calling government agencies are tactics often used by these offenders that are often discriminatory, and we believe that they would prevent these violations from continuing. Thank you for your time, and CASA urges a favorable report on this bill.
Let's hear from Lauren Pruitt, please, for 2 minutes, and then we'll take questions.
Good afternoon. My name is Lauren Pruitt, and I'm the Legal Director for Free State Justice. Free State is here today in support of House Bill 772, and we thank Attorney General Brown for making this issue a priority. This bill addresses the bottleneck of resources available to victims of civil rights violations to find recourse. We think it is a good solution to a significant resourcing problem that impacts every Marylander who experiences discrimination based on their status as a member of a legally protected class, and whether they are LGBTQIA+, as our clients are, or otherwise. We assist many clients as they file claims with the Maryland Commission on Civil Rights after being discriminated against in their places of employment, areas of public accommodation, and housing based on their status. And despite the existence of several laws which prohibit this and other types of discrimination, we know firsthand that the Commission is overburdened because when it does get to our clients' cases, it often cannot investigate their claims as thoroughly or take as aggressive an action as it otherwise could if it were more fully staffed and fully funded. We appreciate the hard work of Ms. Hughes and the MCCR staff, but these bandwidth problems in turn impact LGBTQIA+ Marylanders broadly and our clients specifically, all of whom are seeking recourse for the discrimination they experience. While MCCR struggles to manage the large number of investigations of individual claims of discrimination, we need a system that is working in collaboration with them that focuses on eliminating the large-scale discrimination and has the enforcement powers behind it. We support HB 772 because it helps bridge the state's civil rights enforcement gap, allowing the Attorney General's office to use its significant institutional resources in conjunction with the Commission to ensure every Marylander is provided sufficient recourse from any discrimination they might face as a member of a legally protected class. For these reasons, Free State Justice will report on House Bill 772. Thank you.
All right, we'll go to questions. Delegate Phillips, please.
Thank you, Mr. Chair. I'm sitting here, and this may not be the appropriate question for this panel, but I want to get it out because I'm thinking about some things that are taking place this session that relate to discriminatory impact on individuals, particularly around housing. And this is the appraisal area, which it's difficult to figure out if it's an individual group, but how might something like this allow us to address a situation like appraisal bias?
I think I have to draw on my experience when I was at the Department of Justice. There was, in fact, I came in on the heels of the mortgage crisis, our team, so there was, in fact, movement to look at appraisals and to see whether they were being done according to similarly situated reliable factors. You really have to isolate for the discriminatory conduct. And it takes a lot of research and review to be able to look at that. It's hard for an individual to understand whether they're getting an appraisal that differs. But often it's by community. It often follows the redlining maps that we're familiar with from historic discrimination. But that's a way of doing that. How is that done? And that is really exactly the type of case that the Office of the Attorney General would be well positioned to bring. However, for individual nonprofits, that would be a very hard case to bring. It requires an in-depth research and analysis to be able to show discrimination, because there are legitimate factors that certainly that our appraisers are able to take into, market values, everything. Those are legitimate, but you need to be able to isolate by race through regression analysis, and it's a complicated task to do that.
So this would be giving this power to the Attorney General would give him an opportunity to do something like that.
That is potentially true. I don't want to speak for the Attorney General who's sitting
understand.
behind me.
I understand.
But it
I
is
understand.
potentially true that they could delve into such an area.
All right, thank you.
Further questions for this panel? All right, seeing none, we thank you very much. Just one more time, just to be sure. She spoke. Jason Billingsley. Andrea Finuccio, Willie Flowers, Michelle Siri, Lisa Jordan. Okay, I guess several of them are stranded across the street, and I apologize for that, but we have to keep moving. So we're going to go ahead and take the unfavorable testimony now. Mr. Kroll and Mr. McAvoy. So we'll hear from Mr. Kroll now for 2 minutes.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator and Executive Director of the Maryland State's Attorneys Association, who's been prosecuting cases since 1984. I'm going to incorporate, by reference, to use a legal term, my argument, which was in the bill right before us, 771, and say the following. The big question here, I wish Delegate Moon was here, is that the question that's not in the fiscal note is, what if an individual gets sued? The Attorney General is correct. The bill says entity, but does not say anything about an individual who could be sued. That individual could be a prosecutor, an assistant. Who's going to represent them, since it's the job of the Attorney General to do that? There's no protocols at this point in time which indicate what would happen to that person. Is it going to be a third party? Is it going to be somebody else in the Attorney General's office? Somebody they could have confidence in? Somebody who's got a contract with the Attorney General? Who's it going to be at that point? So they're kind of left at whim about what's going to happen. So it's not been clearly developed. We are in favor of the bill, again, if it does not include us, if we're exempted. The bill has great importance. Also, when you look at the third party representing them, what motive do they have? If they win cases, if they lose cases, there's some motivation that may be there. So we don't know, as soon as that person is sued as an individual, which happens in 1983 cases, the 11th Amendment's at play that to get to an individual, the entity no, the individual yes, and again, without better protocols, without an idea of what's going to happen, and incorporating the argument that I had in 771, would ask for an unfavorable report as to 772. And I'm happy to answer questions.
All right, we'll hear from Mr. McAvoy for 2 minutes, and then we'll take questions.
Thank you so much, committee. I appreciate it. I am against this bill. I find it to be prone to overreach, duplicative efforts, political witch hunts, and I find it a vehicle for slush funds. I'll give you just a couple of examples here. When I'm talking about overreach, what I mean here is the Office of Maryland Commission on Civil Rights had a day in Annapolis. You all know this, just in January. Here's who was there: Maryland Civil Rights Commission, Anne Arundel County Human Relations Commission, City of Annapolis Human Relations Commission, Baltimore City Office, Baltimore County Office, City of Cumberland Office, Harford County Office, Howard County, Montgomery County, Prince George, everyone is there. This is already being reviewed. So there are duplicative efforts. And just by logic, if the President Attorney General is not saying that the previous Attorney General didn't do his job, then somehow, some way, Brian Frosch found the way with his, again, the largest law firm in the state of Maryland to address these issues and to prosecute these issues. And that's the prosecution issues why I bring this up to overreach. Just because it's not criminal doesn't mean that injunctive action and other honing in on particulars cannot be used to actually destroy businesses. Maryland's businesses are extremely fragile right now, and you look at the fines that are involved, the issue to compel discovery, this could bankrupt businesses or individuals. And when I get to the issue of overreach and political witch hunts, the wording here is to say a reasonable cause to believe, a reasonable cause. That'll be tried in the justice of Twitter. That a person, that could be anyone, and then any type of discrimination. Basically, this bill could make him take on every single case within the state. Strongly urge, and I'm favorable on this, let him get accustomed to this office, maybe next year or the year after. Thank you so much for your time. Available for questions.
Questions for the panel, starting Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Mr. Crowell. How are you doing?
Good. How are you, Delegate
I'm
Bartlett?
doing well. Okay, so let's go back to your point that you were making. I don't understand it because I don't understand what you were saying about you want to leave the state's attorneys out of 772. Is that what you were saying?
Both bills, yes.
Right. Yeah, I got 771, but we're not allowed to go backwards in time. So 772, the state's attorneys' offices do not want to be a part of any investigation, prosecution, remediation on behalf of anyone who might feel that they have a civil rights violation.
That's correct.
Why not?
Well, it's again, who's representing us? First of all, without representation, I can't agree to anything whatsoever. You have people who might get sued by the Attorney General. And again, not this Attorney General, who I trust, but another one. And there's nothing in place to say who's going to represent them. The Attorney General, if we're sued, has to represent us. So who's going to be there? So how can I agree to something when there's no protection for my people, my 643 assistants, and 24 elected? So that's why.
Well, the Attorney General's office doesn't bring anything on behalf of an individual. So I thought, when I read this, I understand it to be that someone in the state's attorney's office may feel that they have been, there may be a civil rights violation of someone in the state's attorney's office. So therefore, the Attorney General's office, or there could be a collection of people, I'm sorry, because I just said no individual. So there could be a collection of people who state that, we're being discriminated against, our civil rights have been violated. My question to you is, why would you not want your members to be able to have that level of protection just like everyone else?
Again, Delegate Bartlett, I'm all in favor of this.
I'm sorry.
I understand what you're saying.
Let me finish it 1 second,
Sure.
though, and I know where you're getting ready to go. So we already know that the premise is that there's going to be a collaboration between the Attorney General's office and the Civil Rights, MCCR. Okay, so if we already have that, then are states' attorneys allowed to go to the Civil Rights Commission now?
I've not seen that happen.
But are they allowed?
Are they allowed? I don't know, but I guess it would be a guess on my part. I don't see why they couldn't. But
Right. So I don't understand why, if we're working on the premise that they're working in collaboration, what does this have to do? What does 772 have to do, or how does 772 in some way prohibit the law as it already exists, and that is that someone could go from the state's attorney's office, could go to the commission now?
let me just explain to you why we're opposing. We're opposing under one ground, and that is the protection of our 643, I believe it's today. If they get that protection, in protocols or something in writing, we're in favor of this bill, and they can go and do any complaint they want to do. I just have to make sure they're protected. But we're in favor of this bill as long as they get the protection in a protocol to say who's going to represent them.
I guess what I'm getting at is I don't understand the protection that you're speaking of. That's what I don't understand.
Anytime, because we are technically, although employees of the county for the most part, with the exception of some state's attorneys, we're employees of the state, we get state's attorney protection. So if I'm sued as an assistant state's attorney or a special assistant, and there's nothing special about me, it's just my title, just to tell you. But if I'm sued, the attorney general has to represent me. So here you have the attorney general who's supposed to represent me, suing me as an individual, not as an entity, as a government entity, which they can't do, but I could be sued individually. Who's going to protect us and represent us? There's nothing in this bill or the protocols to say. And all I'm suggesting is, I'm not objecting to the bill. I think the bill's a very good bill. I'm not objecting to this attorney general, who I like and trust. But for future ones, and if we do get sued, I'm leaving my 643 plus 24 exposed. And what I'm suggesting is, until I get them protected, i.e. somebody's going to represent them, I have to oppose the bill.
But but we know that individuals are not subjects of the
Individuals can't sue, but they can be sued.
well, sure. So if they can be sued, what would happen now? I guess my question is, what is going on now where this bill changes it so drastically that the state's attorneys say, I don't want to be any part of it?
The Attorney General was never allowed to sue us. Now this bill gives them the right to sue us individually. And the answer is that's never been done before. They haven't been, we would always be sued by a third party, not by the Attorney General.
Okay, well, we can talk offline. Thank you.
Thank you, Mr. Chair. I feel like it's gotten more confusing than it actually is. So currently, if I sue you, he would come to your defense.
Correct.
Okay. Under this bill, the same person that traditionally would come to your defense is now going to be the person suing you, and you will have no one to your defense.
Not at this point. Not until there's some protocol or part of the law that says what's going to happen, no.
Right, so you would have to hire outside counsel, not use anyone who was...
Or get insurance, or pay for our own counsel, yes.
Okay.
That's our problem.
That seems not complicated, but...
No, it's not.
Yeah, okay. Thank you so much.
Further questions for the panel? Sorry, Delegate Young. Delegate Bartlett, your light's still on. I'm just not sure whether you want to... Did you? You're not going for a second bite. Delegate Young.
Thank you, Mr. Chair. Colleagues, this is not complicated. As the Deputy Director of the Baltimore City Office of Equity and Civil Rights, let me be clear. Today, if a state's attorney, supervisor, was discriminating against one of their state's attorneys, that supervisor, or that employee, could file a complaint in any of those offices that Mr. McAvoy posted or talked about, including the State Commission, including my office, and we would investigate that complaint of discrimination. So, to be clear, today, to answer your question, these state's attorneys can be investigated and dealt with by the Civil Rights Commission, by the Baltimore City Office of Equity and Civil Rights. Respectfully, Mr. Crow, I don't think you all fully understand this bill. I also look at the testimony provided for by State's Attorney in Howard County. It's very clear to me that they took the same bill, the same testimony from 771. Which one is this? 771. They changed the number to 2, and they submitted the exact same thing that does not apply to this bill. Again, this bill does not change anything as it pertains to an individual who is discriminating against another individual. If a supervisor is discriminating against their employee, there can be a complaint against that individual.
And again, you're much more scholar than I am on this subject. What I'm suggesting is, who's going to represent us?
The person that would represent you today.
The Attorney General.
And again, the complaint would come from the Civil Rights Office. So if your people that you represent were complained against, they would either get private counsel, or if the Attorney General was supposed to represent, then the Attorney General's office would step in. This bill specifically states that the Attorney General's office has only jurisdiction over non-governmental entities. In individual instances, this bill clearly states that that jurisdiction is with the Civil Rights Commission. So respectfully, I just don't think that the concerns that have been raised actually apply to this bill as drafted.
I'm happy to speak to you offline and we can debate this because I'm looking forward to talking to you about your expertise, which I welcome.
Sure, I appreciate it. Always a pleasure, Mr. Crowe. Thank you, Mr. Chair.
Further questions? Seeing none, thank you very much. That concludes the testimony for House Bill 772. Thank you all very much for being here today. Committee's indulgence for 5 seconds. All right, we're going to take bills out of order because we're waiting for people from the Senate, which appears to be the story of my life right now, but 756 is Delegate Grammer. Delegate Grammer, and then virtually, Carla Mooney, Brett Omspaugh, Mark Pennack is here, Michael Burke is supposed to be virtual, or Michael Burke, I'm sorry, Michael Burke's supposed to be here. Mr. Pennack, is Mr. Burke here or no?
I'm not sure.
I don't see him. That's all right. We'll start with the two of you. We'll see if we can get the other people loaded in, and then we will go from there.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 756. Currently, state police are using expunged convictions to deny permits to wear, carry, and transport a handgun. House Bill 756 clarifies that an expunged conviction does not constitute a conviction that disqualifies a person from eligibility for a handgun permit. This was requested by the Office of the Public Defender. Recently, this committee heard testimony from Guy Powell, also known as the Sabatos guy, and when he asked about the practical impact of the inability to expunge a charge, his first answer was that he lost his right to bear arms. He lamented that while he felt that it was his responsibility to protect and provide, holes in our current law take this away from him. This bill attempts to fix a technical problem that was discussed during that bill hearing. Federal and state law allows for the restoration of rights by expungement. However, current state law leaves legal ambiguity about the nature of expungements in Maryland. It is viewed by some that expungements in Maryland are not considered to be true expungements, as law enforcement agencies may, under limited circumstances, still access expunged records. Due to this, state police are using expunged convictions to deny permits. House Bill 756 reconciles this problem by reconciling the public safety article with Title 10, Subtitle 1 of the Criminal Procedure Article, which governs the expungement process. With that, I'd be happy to take questions, and I'd ask for a favorable report on House Bill 756.
Thank you, Mr. Vice Chair. Mark Pennock, President of Maryland Show Issue. You have my written testimony that lays out the statutory scheme for expungements in Maryland and under federal law. We support this bill, and I would say that the problem identified by Delegate Grammer is actually larger. What the state police are now doing is actually revoking existing permits, including handgun qualification permits that had already been issued. They're doing so on the basis of the interpretation, which we think is just dead wrong, that the FBI has told them that Maryland expungements are not good enough. Now, Delegate Attar has a very good bill that's related to the same problem, and we support that bill as well. But both bills could be easily enacted. The state police should be required to give full force and effect to Maryland's expungement law. It's permitted by federal law. It's permitted by state law. Indeed, state law expressly provides, and we cite it in our written testimony, that an expunged conviction is not a disqualifying crime. So if you're going to give effect to that express statutory provision, you're going to have to instruct the state police to obey it, because right now they're not. And we urge a favorable report on that basis alone.
All right, next let's hear from Carla Mooney online. You have 2 minutes when you're ready.
Thank you very much. My name is Carla Mooney. I am from 29C in Maryland, in Leonardtown. I agree with Mr. Pennock wholeheartedly that if the expungement has been completed, that this gives no more reason for someone to be denied. And I request that you have a favorable report on this bill to make that adjustment so that those who have current clean records, thanks to an expungement, are able to be permitted to have HQL and handgun permits. Thank you.
All right, Brett Armsbaugh, you have 2 minutes when you're ready.
Thank you. My name is Brent Amsbaugh. I'm from Carroll County, Maryland. I also urge a favorable review. During various testimony, we heard not the best news from the state's attorney general in the respect that they would have discretion as to whether or not they would prosecute if someone was inadvertently carrying in a place that they shouldn't and they had their concealed carry permit. And unless it's in writing, we can't trust that. So I need to plan on what happens if I accidentally get caught up in this. I can expect to spend a number of years fighting the state of Maryland, getting clear of it, getting it expunged, and then getting my gun rights back. There's been plenty of lip service today about protecting the rights of Marylanders. This is one of those bills that protects the rights of Marylanders. Put your money where your mouth is, and I urge a favorable review. Thank you.
All right, I think that's it for the favorable witnesses. Are there any questions? All right. Yes, go ahead.
Okay, do I understand this correctly that, just clarify for me, is the person, they have been found guilty of something, is that correct?
Correct.
And now it's been expunged?
Correct.
So what comes to mind for me is the guy who I won't, the one for the Capital Gazette, if you recall, I mean, with kind of harassment, was found guilty. So this individual, by being expunged, would be able to purchase a gun?
Not necessarily.
I mean, not after his crime now, but I mean the prior.
Well, you can't get just any crime expunged. The Maryland law has a list of items for which expungement is available. They're all set out in Section 10-110.
Would harassment be one of them? 'Cause that's
I simply don't recall one way or the other, but I tend to doubt it. One of my clients, for example, has a second-degree assault charge from dating back from 1986 expunged. And recall, assault doesn't even necessarily have to include a bodily contact, because under the law of Maryland, just a threat is enough to constitute assault. That's a disqualifying crime, technically, because it's punishable by more than 2 years. But it happened 4 decades ago, so he wanted to get it expunged. He was successful in getting it expunged. It was a one-off, but now he has been stripped of his HQL. So that's unjust, because the whole point of the expungement, as this committee is well aware, is to give people a fresh start from mistakes. Now, you're not going to get repeated violations expunged, because judges are simply not going to do that. But if you're going to have an expungement law that allows people to have a fresh start, it's a restoration of their rights and totally. Now, the judge in an expungement order always has the option of saying, well, I'm going to condition your expungement on no access to firearms. Well, okay. But where that hasn't happened and where there's been a total expungement, Maryland law expressly provides that's no longer a disqualifying crime. That's in Section 5-101. So that ought to be given full force and effect, because otherwise, what's the point of expungement?
Yeah, and it's the intent of the law that the expungement grants you your gun rights. This is really kind of a technical issue, and it's viewed by some that, okay, well, you have an expungement, but it's not a real expungement. So this bill, what we're trying to do here is, frankly, just close a little bit of a loophole and honor our own law that says expressly that these folks should get their gun rights back. That's the intent of our current law.
Yeah, I think I'd need to talk to you further about it, just because, as you know, as a domestic violence survivor and lots of others, I know folks who've had where there were minor issues and then they went and shot their family, you know, or whatever, you know, and this, I don't have a problem with the expungement. I have a problem with giving them some of these individuals, or rape, where they've gotten, I mean, I see here a sentence for less than a year. There's lots of folks for sexual assaults and rape who get a lot less than a year, you know, barely spend any time in jail whatsoever. So they just, people with gender violence, it makes me nervous when I think about.
So, Delegate, I would urge you to take a look at the list of statutory offenses that are actually listed in the statute for what things can be expunged and what cannot.
Well, we've looked at that
So
extensively.
10-110 is the relevant statutory provision. So, I mean, the committee can always amend that if you want, but if you're going to have expungements for crimes, then you ought to at least give full effect to the expungements. That's the point. But if you don't want to have an expungement for a particular crime, the committee has the option of removing that or from that list in 10-110.
Yeah, and keep in mind, you know, right now we're not talking about the crime. I mean, it could be stealing a candy bar. If there's something on your record, what's happening right now is expungements are not functional at all, and people are losing their gun rights completely. Doesn't matter what the offense is.
Okay. I mean, I do see where you're, I don't know that I agree with saying, well, we wouldn't have an expungement at all if we don't want to mean that that means they could have their gun rights. And I see that, you know, it says felony or misdemeanor, so I don't know if you would be open to just making that a misdemeanor as opposed to a felony.
Keep in mind that's current law. So
Yeah, I see
it's like saying we see a loophole, so let's change the entire structure of our expungement law. I think that's a much bigger question that goes beyond this bill.
That's true. I do see that that's current law, but this is adding that extra component to the expungement of being able to permit them to have a gun again.
So what's odd about this is that under current law, the state police were administering current law according to its terms until they got this bogus advice from the FBI, which leaves the individual open to not only to being deprived of his gun rights in Maryland, but being prosecuted under federal law. Now, we're going to take care of that separately. It's important for this committee to address this aspect of Maryland law. So you've got to be understanding that the state police are acting here that's contrary to Maryland law, and that the committee shouldn't permit. And that's why the bill is directed to the state police. And frankly, the bill ought to be amended to exclude not only 5-306 of the public safety article, but 5-117.1, which is a handgun qualification license as well, because they're revoking those licenses.
I do think our laws should be based on research, and if they know that, particularly when it comes to gender violence, that it can lead to the death of people in Maryland, there should be some rules and regulations and laws to prohibit it.
That's beyond the scope of this bill, though.
Well, this bill, it's not just about expungement, but I would want to look at that a little bit further. I do understand feeling that they're, like you said, stealing a candy bar or something else and then having their rights removed forever. I can totally see that. I hope you can also understand, for me, it's a little sensitive to think of the possibility of somebody, when it comes to gender violence, or some of those behaviors, which is beyond stealing a candy bar, the thought of them then having a gun.
Well, I would love to be able to research that question on this. It's simply a matter of going down the list in 10-110 and seeing if that's even subject to expungement. So I would do that first. It may not even be subject to expungement.
It's all sensitive to me as well, Delegate.
I understand. Thank you, sir. Thank
I didn't see the order, but let's go Boucher and then Bartlett. Okay.
Thank you, Vice Chairman, and thank you, Delegate Kramer. Would this bill also be beneficial to females?
Be beneficial to everybody from my vantage point.
Thank you.
Thank you.
Thank you, Mr. Chair. So I just want to make sure I understand. Is it current practice that the MSP are not granting petitions because someone has gotten an expungement? Is that what the system?
The current practice of the MSP is where the expungement is for an otherwise disqualifying crime, of which there are about 2,000 in Maryland. The MSP is not granting a permit on grounds that, in their view, as advised by the FBI, they are no longer actually, expungement is not good enough, in other words, so that they remain a prohibited person even though their conviction has been fully expunged under Maryland law. This is FBI's, it's in my written testimony, it's relying on an old 10th Circuit case dating back to the mid-2000s, in which has a very distinguishable Wyoming law was at issue. I don't think the advice that they're getting from the FBI is good enough or even colorable, but they're actually implementing it now. And I'm here not here to bash the Maryland State Police, because they're simply taking their lead from the FBI in this. But this bill actually would give them a reason to change their practice in that reliance.
So would you say that what they've been doing is historic tradition?
I'm sorry, again?
Would you say that what the MSP has been doing is historic tradition?
I would say what the MSP has been doing is accepting the FBI as word that these people are still disqualified, and for whatever reason, that whether it's not consistent with historic tradition or otherwise, but again, because Maryland creates a disqualification for 2,000 offenses, some of those may well be within the historic condition, some of them may well not be. So it's a statutory crime under Maryland law 5-101G3, any crime punishable by more than 2 years imprisonment, regardless of whether what the prison sentence was inflicted, is a disqualifying offense. And many of those crimes are not violent crimes.
Right. Okay. Last question, Mayor. And one last question, and that is, are you saying that currently, other than what's in 10-110, is on the list of qualifying crimes, are you saying that currently there is nothing in Maryland law that says that the MSP cannot do what they're doing with this?
Oh, quite to the contrary. Maryland law expressly provides in citations in written testimony that an expunged conviction is not a disqualifier. It's right, very express. So what MSP is doing now in insisting that they're still disqualified flies in the face of that statutory provision. So it's actually contrary to Maryland law.
Yeah, are they being sued?
Well, I'm not going to comment on that.
Okay.
But they have been sued. I know of at least 3 cases, one of which is in circuit court right now, in which the Maryland State Police lost in the Office of Administrative Hearings. There was an appeal by the Maryland State Police in circuit court, and the circuit court in that case denied a motion for a stay filed by the Maryland State Police on grounds that the Maryland State Police were unlikely to prevail on their appeal to the circuit court. So, yes, there's litigation. I don't want to get into the particulars of that litigation, but there is active litigation on this front. And we'd like to have the Maryland State Police be responsible for obeying Maryland law, regardless of what the FBI tells them.
Okay.
All right, let's go Valentine and then Phillips.
Thank you, Mr. Vice Chair. And thank you, Delegate, and thank you for both coming today and also presenting this bill. And I'm just looking at the testimony in our system, and I see where the Office of the Public Defender, although there is no written testimony, has indicated a favorable on this bill. But what is missing, and I'm kind of curious if your office has heard, I see no testimony one way or the other from the Maryland State Police, and I know this directly impacts them, and I was curious if you've received any feedback one way or the other on this bill at your office.
I have not. From the Maryland State Police, I have not.
Thank you, Mr. Vice Chair. I guess I'm trying to figure out if we're relying on the FBI, state agencies relying on the FBI, is there another alternative to fixing this specifically as it relates to a federal proclamation, designation, or, just specifically dealing with this as a congressional matter versus a matter here in the Maryland legislature?
Yes, there is, actually. Delegate Attar's bill will actually amend the expungement statute in such a way that would satisfy the FBI's insistence that Maryland's expungement statute is not good enough. It's already in federal law that an expungement it acts as a to obviate any conviction that's a disqualifier. It's in 2 sections of Maryland law. I cite them in the written testimony. So what the FBI is reading those provisions of federal law in such a way that we think is contrary to law, but Delegate Attar's amendments would in fact amend the expungement statute that even the FBI would agree. So is a complete expungement and would thereby restore Maryland's law to its place as a complete vindication of that person for purposes of these rights. So you can do this bill, you can do her bill, and you can do both. And we would suggest doing both.
Okay.
All right. And I think that's it. I don't think we've got anyone on the other side of this one other than written testimony. So
Thank you.
thank you, everybody.
Thank you.
Thank you.
All right, we're going to go to Delegate Munoz, HB 750 next, if you'd like to bring your panel up. And I think we've got a couple, maybe of the same people signed up virtually on this one. All right, whenever you're ready on House Bill 750.
Thank you so much. Good afternoon, my Judiciary Committee colleagues. For the record, my name is Delegate Rachel Munoz, and I come before you today to humbly present House Bill 750, the Gun Theft Felony Act of 2023. This is not the first time this bill has been heard in this committee. It's not the second or the third. This is the 4th time. I was asked to bring this bill forward by a dear friend who is a constituent of mine, a fellow mother of little ones, who's very concerned about rising gun violence in the state of Maryland. And all I had to do was tell her yes and file the bill and prepare to come before you and share it. And I thought that would be a simple thing for me to do. But then, as many of you know, just a couple weeks ago, my husband was robbed at gunpoint in his pharmacy here in Annapolis that you can walk to from the building we're sitting in right now. And so it changed things for me a little bit. The gentleman who robbed him had a very extensive record. He should not have had a gun of any kind, and he should not have been on the streets able to commit the crime that day. And so I was able to see firsthand how Maryland's system failed. And we're very lucky that, my husband and his staff were not harmed. But being a member of this committee, like everyone else here, I hear the stories every single day of Maryland families who are not as lucky. And so I bring this bill today because I just want to curb gun violence in the state of Maryland. And I don't think there's anyone here who doesn't want to do that. And so I just want to share with you that 18 other states have already taken the step to classify theft of a gun as a felony. States as close to home as Virginia and Pennsylvania, and as far away as California and Washington. The only thing I can find that all of these different states have in common is they care about the lives of their citizens, and they're willing to, put it on the books as a felony in order to deter violent criminals and protect the lives of their citizens. Currently, under Maryland law, theft of a firearm is the exact same as any theft between $100 and $1,500. But a gun is not a bicycle or a cell phone or a handbag. Guns in the hands of criminals who have been shown to be the ones who commit most violent crimes take away our families. They take away our children, our parents, our grandparents, and our neighbors. So for those reasons, I humbly request a favorable report on House Bill 750.
Thank you. Good afternoon. For the record, my name is Michael Shire. I am a police officer in the state of Maryland for 19 years. Speaking today on behalf of the Maryland Fraternal Order of Police, I'm also one of the fine lawyers that you've heard about in previous days here. Thank you to the committee and to Delegate Munoz for introducing this legislation. I am here to speak in support of it. I thought it was interesting, something that Delegate Munoz brought up, that this is currently, under current law, theft of a firearm is the same as the theft of a bicycle, theft of any other item that is of similar value. And it's not without precedence to set a specific item having a special classification under law. For as long as I can remember, certainly, motor vehicle theft is a special classification of theft because we have recognized that it is, even though your car might only be worth $500, that is how you get to work. That is your car is a very personal thing. And we have said, okay, we're going to make this special. We're going to make that a felony, even though, and I have charged people with misdemeanor theft because it's a lesser included charge, misdemeanor theft of a vehicle, but also motor vehicle theft, which is a felony. We wouldn't want theft of a vehicle to fall under a misdemeanor theft. So the idea of having that special crime is not without precedent. Our police officers have obviously seen, as we all have, a marked increase in the number of firearm thefts statewide, and that's surely a driving factor in supplying those firearms to those that are committing violent acts around our state. I think that by making theft of a firearm a felony, we would add some deterrence value to our criminal code. Admittedly, that's not going to stop every firearm theft, but it will give our police officers, our state's attorneys, an important tool to discourage and incapacitate those that are flooding the black market with stolen firearms that become so readily available to the criminals who want to commit violent acts against the citizens of our state. So with that in mind, we ask that you please report favorably on this legislation. And thank you.
Thank you, Mr. Vice Chair. Mark Pennock, President of Maryland Show Issue. We are in support of this bill. And while we understand that there's a lot of resistance, perhaps, in the committee to particular terms of years for this violation of this crime, our perspective is that at the very least, this committee should enact this bill to make it a disqualifier so that future possessions of firearms by persons who steal firearms and who have been convicted of doing so are disqualified persons and may be appropriately charged in the future for violations with possession violations and the like. You can do that in one of three ways. You can make it a felony, as this bill does, because under 5-101 of the Maryland Public Safety article, that's a disqualifier. A conviction, you can make it for more than 2 years, and that's another disqualifier under 501G3. Or you can make it a separate listed crime, a new G4 subsection, if you will, by saying that conviction of this crime of 7-104 is a disqualifier all by itself. Any one of those would be sufficient, in my view, to provide a deterrent towards theft and allow future enforcement actions in a way that would actually promote the public safety here. Because stolen guns are crime guns. It's not just me saying that. That's the ATF has been saying that for years. That's my old Department of Justice friends. And they're right. Guns can be legitimately purchased those guns are not being procured by people who are law-abiding. Stolen guns are being stolen by people who cannot otherwise legitimately acquire them. And they're being sold and used illegally for violent crime. It warrants severe punishment. It warrants disqualification. I urge a favorable report.
Good afternoon, Mr. Chairman. John Jocelyn, speaking for 2A Maryland. Echoing what my colleagues have said, this body has indicated its concern about training, purchase, possession, use of firearms. Unfortunately, the theft of a firearm is so low on the hierarchy that in most jurisdictions, a simple property theft will never, ever be prosecuted. The theft of a firearm, as Mark mentioned, is a precursor. That device is now in the illegal market. It will never have a legitimate use. Because the property theft is so low, we understand that it doesn't get prosecuted. But it is an extremely serious thing because that's the initial event. This person has put in place the vehicle to commit other more serious crimes. We need to deal with it in that light. I strongly support making this crime a felony. I go with the penalties that we have. I think they are appropriate and necessary in order to make it, if you will, worth it to prosecute the person. I strongly agree with making the sentence concurrent. When we go shopping, we don't get to pay for the same groceries over and over again with the same $5 bill. We shouldn't have crimes that are basically freebies because you're serving the same time. If you've done the crime, you should do the penalty that's appropriate for it. And we believe that this is a way for all of us to say to those who would steal a firearm, knowing that it's cheaper for them in terms of punishment right now, to steal it rather than go out and make their own. It's advantageous to them to steal the firearm. It's time for us to send the message, no, it's not. And we're going to make sure that if you do it, you will be dealt with severely, and we are not getting any more. We ask for a favorable report.
Do we have Lavelle Canaday here? No? Okay. All right, we're going to take our two favorable online witnesses. Let's start with Brett Amsbach.
Thank you. My name is Brent Amsbaugh, again testifying from Carroll County, Maryland. I was surprised that the theft of a firearm in Maryland wasn't already a felony. So I think this will do a lot, echoing what everybody else said. I think this will do a lot to help strengthen things here in Maryland, help act as a deterrent. I forget which one of you said it, but I was going to make the analogy that it's kind of like a gateway drug. You get a gun, then you can be better at robbing people and, you know, work your way up the criminal totem pole. Somebody here said it much more eloquently than I could have. So the other thing to keep in mind is the more people are, my concern is if this doesn't pass, is that there is no effective deterrent to stealing a gun. Because again, like someone else said, it doesn't get prosecuted. It's a simple property crime. I would imagine it's one of the first ones that gets thrown out the window when you're negotiating a plea bargain. I urge favorable review. Thank you.
Carla Mooney, please, for 2 minutes.
Thank you very much. Again, my name is Carla Mooney. I represent the women in the state from the Armed Women of America chapters. We have 5 chapters in the state, lots of ladies included. We're looking at the first bill I've seen this year, and I know it was introduced last year as well, that will actually start affecting crime, meaning that this is the first time something's been brought up that might actually make a criminal think twice about taking a firearm if it's going to actually put them in jail. It's going to actually have a sentence attached to it. The current petty theft law for misdemeanors, slap on the wrist and out the door the next day to steal another one or to do something more. We want this type of support in giving punishment to crimes that can escalate. It is more than a petty theft if it's a gun. A gun can be used in a violent crime. Yes, they'll still commit the crimes, but if they have a crime where they have something small, like a knife versus a gun, that's a bit different crime, is it not? we're trying really hard in this state to make people feel safe and make people feel like they can go out and live their lives. I personally chose to have the ability to defend myself. My right to do so has been allowed, but criminals are not going through the process. We want them to have a process. So if they're not going to be able to, because they are prohibited, all the better, because again, they are criminals. These are not guns that they bought. Please find a favorable report for this bill. Thank you.
Go to questions. Delegate Schmidt, then Bartlett, then Erickson.
Thank you, Chair, and thank you, Delegate, for bringing this bill. I feel like we had a conversation about this a few weeks ago with Ivan Bates here in the room regarding increasing some penalties on some gun laws. Would your panel be able to maybe speak to light of increasing to a felony? How is that going to help us? Because I know we were talking about going from 3 years to 5 years, I believe, was the previous one, a misdemeanor.
So I'll let everyone else get a turn, but I'll just mention, just right before we came into committee, I actually got the report from State's Attorney Ivan Bates, and it's the United States Sentencing Commission June 2022 length of incarceration and recidivism report that they had done, and I didn't get a chance to email it, but I will get it, to everyone on the committee to be able to look it over yourself. But the conclusion was that the commission found a statistically significant preventable effect for offenders sentenced to more than 60 months incarceration. And so offenders sentenced to more than 60 months incarceration had lower odds of recidivism as compared to similar offenders receiving shorter sentences. And I had a conversation with Vice Chair Moon earlier today, and I said, truthfully, I don't want anyone to be convicted of a felony under this, because I don't want anyone to steal a gun, and I'm not here for the punishment. I'm here for the deterrence and, keeping Marylanders alive. But I have people who know a lot more about that than me.
Just say real quick, Mike Shire, from a law enforcement perspective, this gives us additional charging tools when we arrest somebody who has stolen a firearm. If it's just a theft charge, the court commissioner who's conducting the initial appearance may not understand the gravity of it. I'll compare it again to the motor vehicle theft. That is a much different thing when it comes before a court commissioner. Even though it might be misdemeanor theft, it is a much different thing when it's motor vehicle theft. So similarly, it would be a much different thing that this is somebody who is out there on the supply side of the firearms market, the firearms black market, that is pushing these firearms into that market that can be used for violent crime. So from that perspective, you have a greater chance of that person being held without bond. But also from the prosecutor's perspective, and certainly the chairman can speak to it, it's just putting tools in their toolbox when it comes to plea arrangements or finding one charge, getting a guilty plea or conviction on one charge or another, and then the collateral consequences, as the folks from the 2A organizations have mentioned as well.
So could I elaborate on State's Attorney Bates' bill that you asked about? Our problem with that bill is not so much the sentence, is that it fails to differentiate people who are otherwise law-abiding, who happen to be caught carrying a firearm, but have no criminal record, who are not otherwise disqualified. That goes on a lot in a lot of places in this state, including the inner city of Baltimore, and this is documented well in the 2020 Johns Hopkins report, which I've cited to you before. Those people should be treated differently than people who are already disqualified and who are carrying, who are probably violent criminals or using it to terrorize the community. So you got to make a distinction here between people who are exercising a constitutional right to carry outside the home, but simply haven't yet been able to get a permit, either because it's outside their financial reach or they simply haven't had time. And those people who are already disqualified by virtue of being convicted of a disqualifying offense, who shouldn't be having a gun at all. So I think that
there's a difference there.
There's a big difference there.
Sure. Thank you for explaining that. That helps. Thank you.
Well, my research assistant is is checking on my question right now. And until she gets my answer, I'm going to ask you all. Could I? Does someone else have a question?
Yes, I'm ready. Thank you. Yes, I'm ready. Thank you, my friend. It's always good to see you. I thank you for bringing this bill forward. My question is, I know you said that 18 other states had similar laws, but do you have any data that suggests or that you can share that in the 18 other states, as a result of this enhancement in penalty, etc., that there has been a decline in gun thefts in the other states that have tried this?
So that what I can point to is data from the Department of Justice and research that show that punishment does have an effect in creating deterrence. Right now, this statute existing for thefts of firearms simply isn't being enforced. The penalty for the initial crime is parole under the sentencing guidelines of Maryland. The penalty for the second offense is parole under existing guidelines of Maryland. No prosecutor is going to spend his time enforcing it. No law enforcement is going to spend a lot of time enforcing it. If you make it a felony, you thereby alone bring a lot more resources to bear, which will result in more prosecutions, which will then have the deterrent effect that we're looking for.
Well, I appreciate your insights, sir. You always have nice things, interesting things to say, but respectfully, that wasn't my question. My question was, has, in the 18 other states, has it led to a decline in gun thefts that have this law? And if you don't know or you need to get back to me, that's fine. But
I don't have the data.
Okay,
I'm sorry.
No, we can definitely get back to you. But I would also just add to that point, under current Maryland law, as a misdemeanor, if you steal anything worth between $100 and $1,500, it's the same exact penalty and deterrence as if you steal a firearm. But if you steal something worth $1,500 or more, that is actually considered a felony and carries a higher penalty than I'm asking for in this legislation. So I think that the threat of illegal guns is more of an issue than people stealing $1,500, $2,000 worth of a flat screen TV or whatever have you, but that is in fact a felony with a higher penalty than what I'm asking for in this bill.
okay, and just for one last thing, Mr. Chair, just so I make sure I understood the distinguished ranking member's point. So you're telling me, Delegate Munoz, that if I steal $100 worth of steak at the Giant, it's the same penalty as if I were to, steal someone's engagement ring that was $1,000 or something like that?
Well, yes, and if you stole a handgun.
Wow. Okay, thank you. Live and learn. I learn something every day.
Delegate, if I may, I have sent public information requests to various law enforcement agencies over the past 5 years, and I find that data collection for stolen firearms is spotty at best. I can tell you that the Maryland State Police do not track them as a line item. Anne Arundel County has been the most responsive of the agencies, and over the last 5 years, the average theft is 300 firearms per year.
Thank you. Are there further questions for this panel? So there's an existing 5-year penalty, correct? For possession of a stolen firearm and seeking to transfer it? Under the public safety article?
Yes, I believe that's right.
Correct. So all this bill would do would really effectively change it from a misdemeanor to a felony, correct?
Well, no, that's, if I recall, and I haven't looked at that section recently, but this would actually punish the theft itself without regard to whether it's being transferred. For example, it could be used by the person who's the thief for crimes without regard to whether he actually sells it.
Then they would be subject to the mandatory 5, correct?
No, I don't think that's right.
If they use the gun in a violent crime, that's not a mandatory 5?
Yes, if he used it in a violent crime.
What you've been describing repeatedly. I'm just,
yes,
yeah.
you certainly would.
Thank you very much. Seeing no further questions, we'll go on to the next panel. if there is one, which I don't think, Brian Johnson was not here?
No.
No, okay, that's fine. And Michael Burke, I don't see Michael Burke. So that's fine. Thank you all very much. That concludes the testimony for House Bill 750. All right. Delegate Cardin. Hi, 755. Delegate Cardin, Alexis Burrell Road, Laura Thomas, Brian McFarland.
They're coming in right now.
Are they? Okay, that's fine. Here they come. Mr. McFarland, I don't see Mrs. There he is. Okay.
You good?
That's fine. Delegate Cardin, go right ahead.
Thank you, Mr. Chair, members of the committee. This is the final bill that I'm bringing on behalf of the both the Estates and Trusts section as well as the Registers of Wills for the state of Maryland, asking for your favorable report on House Bill 792. I will let the experts explain it. I will just say in summary that this bill allows for all people in the state of Maryland to be treated fairly and equally, regardless of their sex, gender, or sexual orientation. Am I not on the right? Am I not on the right? Am I not?
I think you go to the Senate bill.
Oh, did I give you the wrong bill number?
House Bill 755.
I apologize.
Registry. Yeah.
I apologize, Your Honor, Mr. Chairman. I have the wrong bill number, but
Take him down. Take him down. Would you like to start over, Delegate Cardin, or no? Are you okay? Seriously, would you like to start over, or?
I'm fine. We're good. We're good.
You're good.
House Bill. I'm asking for a favorable report on House Bill 755.
Sounds good. How about you? Go ahead.
Mr. Chairman, members of the committee, my name is Laura Thomas, and I'm here today on behalf of the Estate and Trust section of the Maryland State Bar Association. We support House Bill 755 and urge a favorable report. Although this bill is titled Registered Domestic Partnerships, it is the result of a task force convened to study the intestacy laws of the state of Maryland. The task force consisted of representatives from the bar, the Register of Wills, and legal services for low-income Marylanders, and we met frequently during 2022 to review these laws. The purpose of an intestacy law is to make a will for a person who dies without a will, as that person would have made. Data from our registers show that about 60% of Maryland estates involve decedents without a will, so most Marylanders have de facto wills created by our intestacy laws. Maryland's intestacy statutes were last updated in their entirety in 1974, and since then, the structure of families and relationships of the citizens of our state have changed. These changes require that our intestacy laws are updated to ensure that the law makes a will for a person as that person would have made for themselves. In my practice, my clients write wills that are very different from the de facto will that the intestate laws would provide for them. The issues that the work group identified are: there is no distinction in our current law between nuclear families and blended families. There's no recognition of couples who are not married, but whose financial and personal affairs are intertwined in many of the same ways. Identifying the descendants of great-grandparents is costly in probate estates of modest means. Including parents as beneficiaries of an intestate decedent with a surviving spouse is an out-of-date concept, and the statutes included stigmatizing terms. We urge a favorable report on House Bill 755 to provide for the citizens of the state who die without a will, the will most like the one they would have made for themselves. Next, Alexis Burrell Rohde will provide detail on the changes the legislation makes to the intestacy laws.
Hi, thank you. My name is Alexis Burrell Rohde, and I'm the Register of Wills for Baltimore County, and I participated in this legislative work group. And I'm going to talk about the important changes in the intestacy law as it relates to assets passing to a surviving spouse. One of the most misunderstood and surprising aspects of the current law is the share of an intestate decedent's estate that passes to the surviving spouse. The public is often confused because the spouse does not always receive all of the assets of the predeceased spouse. When a married person passes away with adult children, the spouse and adult children share in the decedent's estate. Or if a couple is married less than 5 years and have no children, the spouse and the decedent's parents share part of the estate. People don't expect these results, and the proposed law corrects some of the issues with the current law. In general, under this new law, the surviving spouse receives the entire estate. In the case of blended families, that is, with adult children, the surviving spouse receives the first $100,000 of the predeceased spouse's estate, with the balance shared equally with adult children. We are doing away with the 5-year distinction between marriages of more or less than 5 years. If there are surviving minor children, whether of the marriage or not, the spouse and minor children share the assets equally. Importantly, this is not a change from current law. Under current law, it's the same, that the surviving spouse and minor children would share equally. So we did not change that aspect. The law, as it's currently written, does not track with what most people hope and expect would happen to their assets when they pass away. The current system leads to housing and financial instability. My time is up, so thank you, and I look forward to any questions you all might have.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Byron McFarland. I am the Register of Wills for Howard County and was also pleased to take part in the work group that you've heard about. This bill, I'm going to touch on the domestic partnership piece of this bill. This bill recognizes that many adults in committed relationships in Maryland choose to partner rather than marry. Statistics show that at least 7 to 8% of cohabitating adults are partnered, and we know that will increase over time. Our laws should reflect and respect how our residents choose to orient their relationships, and that is why this bill proposes that Maryland join many other states by establishing a domestic partnership registry and explicitly provide specified benefits to those individuals who are registered domestic partners. When it comes to probate, domestic partners are treated as legal strangers for the most part. The lack of protections for the surviving partner can lead to intense conflict with the biological family of the decedent and a tax burden on what is often jointly accumulated wealth. What we propose is that any two individuals who are not otherwise partnered or marry may apply to become registered domestic partners with their local Register of Wills. We would charge a nominal fee and maintain a statewide database of those registered partners. It would put a surviving partner on equal footing as a surviving spouse of if the decedent died without a last will and testament. So a surviving registered domestic partner would have the same priority to serve as the personal representative or executor of the estate, the same right to inherit, the same right to be exempt from the inheritance tax as a surviving spouse. It's important to note that the partners would have to take the affirmative step of registering as partners prior to either of their deaths for these benefits to be granted. They would need to jointly file a notarized application signed under the penalties of perjury during their lifetimes to achieve these benefits. This new registry would be an affordable and cost-effective method for partners to obtain some limited protections in lieu of more robust and extensive estate planning, which frankly many Marylanders cannot afford. Thank you.
Questions were promised. Are there questions? There's Delegate Phillips with a question. Delegate Phillips.
So I'm just trying to. Thank you, Mr. Chairman, and thank you, Delegate Cardin, for bringing this. I'm trying to. So there are a number of changes. It's called the domestic partnership, but you're looking at making a number of changes on how intestate succession works today.
That's correct.
Okay. In terms of the domestic, help me understand how the registration works, because I'm a little confused. I know that in some instances, if I'm in a domestic partner relationship, and I go to my employer, and my employer recognizes domestic partners, I register with my employer. Would that satisfy this?
No. So the domestic partnership registry that we are proposing specifically only creates a status within the estate and trust section of the code. So in order for it to count, and one of the big portions of it is it exempts registered domestic partners from inheritance tax, is that they actually have to go and register at the Register of Wills office, which would keep a statewide database of the registries in the state of Maryland. So registering with your employer wouldn't satisfy the requirements under this section.
So we're creating a database. All right. In terms of, help me to just outline, because I'm thinking about the rules of intestacy session, and I'm listening to this and I'm reading this. Highlight the items that are changed again for me. I really didn't understand that.
So is it okay if I talk?
Because you might not have finished, I think.
Yeah, so we because of the extensive changes we're proposing, I know that all of us have submitted pretty extensive written testimony as well. But currently, under Maryland law, if you are unmarried and living with a domestic partner, you get nothing under the laws of intestacy. It's as if you're a legal stranger. So you had no right to inherit. Everything but a jointly held primary residence is also subject to inheritance tax. If you live with a domestic partner, you don't have priority of appointment as personal representative. And if you did inherit anything from your predeceased domestic partner, you'd pay a 10% inheritance tax on that outside of your joint primary residence. So it really penalizes people who have opted not to get married for whatever reason, in that they pay additional taxes and they're less secure in inheriting assets that a lot of times they assisted that as a couple, they work together to accumulate joint savings accounts, IRAs, those kinds of things. They would have to pay tax many times on money that they helped accumulate. So it eliminates that injustice.
So I want to make sure, but I want to make sure. So in essence, it takes a domestic partner and puts them in the same standing as a spouse.
A registered domestic partner.
A registered domestic partner.
For the purposes of inheritance.
And for the purpose of inheritance, I got that. But I also heard you said you would change it. There were other changes.
Yes. So
that's what I'm concerned about, because that piece I understand. Domestic.
So the other changes were that, that we propose are that in the instance where someone dies with a surviving spouse, the surviving spouse, if all of the children of the decedent are also children of the surviving spouse and they are all adults, that the surviving spouse would inherit the entire estate from the decedent. So if all of the decedent's children are also children of the surviving spouse and they're adults, the surviving spouse inherits 100%. If the decedent had children that are not all the surviving spouses, even if they're not minors, so they can be adults, if they have children with their surviving spouse and children with somebody else, then their children, even if they're all adults, would still share in the estate, but we propose increasing the amount the surviving spouse would receive from $40,000 to $100,000, and then they'd split the rest. In regards to minor children, we've made no changes. It still will not matter whether they're minor children from the decedent and the surviving spouse's relationship, or there's children from another relationship. The surviving spouse and the minor children will split the estate 50-50. The other proposed changes are that we eliminate great-grandparents and descendants of great-grandparents from the intestate succession, which effectively moves stepchildren up a level, which in many estates we have to notify all of the heirs of the decedent, even if they do have a will. And sometimes we, spend a lot of time and money trying to track down descendants of great-grandchildren, and especially in estates where they don't have a ton of money to pay a genealogist to figure that out, it can be a big burden to find if there is anybody. The other changes that we propose in this legislation, we're removing the term illegitimate and legitimate and replacing it with non-stigmatizing terms. And then what did I miss? feel like I missed something. Okay. I think that's it. So those are the changes.
Because the title, I mean, the most important, we would say, or the most impactful would be the domestic partnership issue, which is why that's in the title. But right now, if you have the death of somebody and they have children, the children and the spouse split it right now. Is that correct?
If they're minors.
If they're minors, they split it, and this doesn't have an impact on that.
Nope.
But it does have an impact on whether if there's a child of another person, that person that the amount of money that goes to the spouse increases, and then the splitting up happens for the calculation.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in and presenting this bill. I have a few questions. The registered domestic partner, that would be a person, that would be two people that are not married but are in some sort of, they're in a financial relationship. Would that be correct, delegate?
I'll leave it.
I'm going from what you talked about this morning in the subcommittee. So it would be a financial. It wouldn't be medical. It would be financial. We're talking about.
Well, for those who weren't on the subcommittee, we were talking about powers of attorney and the different types of power of attorney agreements. These would be domestic partnerships. You guys can define that a little bit better than I can, probably.
Thank you, delegate, for that question. So it would be two cohabitating adults, so at least 18 years old, who are not otherwise partnered or married. So two people who are otherwise legally single.
Right, we like the Odd Couple. I don't know if you're old enough to remember that show, but it doesn't mean that they have to be sexually involved. They could just be good friends and would that be could they be a domestic partner? Could I have my best friend register as my domestic partner or domestic friend?
So part of the requirements for the affidavit are swearing under penalties of perjury that you are in a committed relationship with one another. We didn't define relationship, but in theory, yes, I guess if you wanted to pay $25 and go to your Register of Wills and affirm that under penalties of perjury, you could.
No, I wouldn't want to perjure myself. What I would ask is, then why did we do the marriage equality if you're going to go to the Register of Wills and register it? So you don't want to say that you're married? Is this the kind of situation where you want to retain your maiden name or something like that, and you don't want to be married, so to speak, so therefore you go to the Register of Wills and you file this form and you pay a fee, but it's similar to being married, but not being married, but being in a domestic partnership?
So I think the first point to make is that this only confers benefits upon registered domestic partners after one of them passes away. So it affects nothing outside of our state and trust code and nothing during lifetime. So it would have no effect on the provisions that are already under Health General that include the ability for the visitation. That all stays in place, and it would still, if people choose not to be registered domestic partners and they own property jointly, if they file the document that's outlined in Health General, they can still be exempt from inheritance tax on that jointly held real estate. What this does is after one of the partners dies, it allows the surviving registered domestic partner to have increased rights in that intestate estate.
Okay, so if a person is someone's registered partner and partner got sick, they wouldn't be able to speak up for them in reference to their health concerns?
So this wouldn't...
Yeah, I understand. That's just yes or no. I can
Yeah, so this wouldn't affect or change any of their rights under other current law, or if they had executed an advanced medical directive or medical power of attorney, that, you know, whomever they appointed as the first person on there would be the person that I believe would be able to
And at the Registered Wills office, will this database be a part of a public information, or how will that work?
Yes, it would be.
So like some people stroll through case search to look up information, you'll be able to look up at this database to see if someone has a registered domestic partner?
No, well, you would not be able to do it online. Similar to the way if you get married, your marriage license is not searchable online, but you could go into your county and look it up.
Okay, thank you very much.
I think everything except for addresses, right?
Addresses are specifically excluded.
Yes.
Delegate Phillips?
I'm sorry, Mr. Chairman, to come back again, but as I'm looking at this, so help me to walk me through. I see there's a provision for termination. Why 6 months? And there's no provision for creating any kind of urgency to have it done in any shorter period of time. If it is as easy as walking in and paying $25, why is it so difficult to get out of?
So there are a few different time periods where a termination would take effect. There are some terminations that would take an additional amount of time to be effective. There are some that are effective immediately.
So it looks like if I do it mutually, you could do it immediately, right? But if one party is not interested in a termination, then we go through a different process?
Yes, and I think that's to give the other person the ability to receive notice of the filed termination, and to, if they want to consent to it, or it has to wait 6 months.
And a will would supersede this, just like intestate succession, a will would, okay.
Correct.
Okay.
Thank you, Mr. Chair. I apologize. This is sort of an unusual bill for me. I'm just curious if I missed it. Did we hear why we're not just fixing the domestic partner and marriage disparity for all of the things, testifying against your spouse and hospital visitation office, and why we would just do this? And I say this as someone who had a registered domestic partnership in D.C. for very specific personal reasons, and when I moved back to Maryland, I realized I was in huge legal limbo, owned property, and this was a very big mistake, and I ran to the courthouse, and we converted to a conventional wedding license in Montgomery County. And so I'm just looking at this, I was like, oh, they're about to fix it. And I said, oh, not quite. So what's the story there?
So our entire work group was based out of we started creating the work group prior to last legislative session to look at the intestacy laws of Maryland as a whole. And it was actually, I think in the Senate, there was a bill introduced to form a task force to review the intestacy laws. And we, a member of the section council for the estate and trust section of the bar, and with the registers, we had already started assembling the task force to do the same thing. So our view on this legislation comes out of our intestacy task force, and that's why it's focused specifically on rights of inheritance and doesn't expand beyond that.
That's fine. Am I not wrong, though, that this might actually be dealt with in a more clean manner if we actually just flattened them the same down the road?
Well, the work of the work group came out of when the needs of the public and being registers, this was front of mind to us. Just the inequities upon death with domestic partners. We see a lot of people come into our offices who have to pay a lot more in taxes, whose domestic partner doesn't receive anything when they pass away, which causes housing instability and financial instability and can really disrupt families. And this just, because of the work in our perspective, this was an easy first step. And some of these issues are controversial, and we would rather have this done, and then if other people want to start working on some of the other problems with not having domestic partners, we'd probably all be in favor of that, but
fair.
This was the first step because of just our work.
Thank you.
Mr. Vice Chair, maybe we can convene a number of different law sections and see how well that works when we start convening 3 or 4 or 5 law sections that will incorporate all the different issues.
Delegate Williams.
Thank you, Mr. Chair, for your indulgence. Really quickly, so I know I'm judiciary, so sometimes we like hypotheticals.
I think we're all lawyers, so okay.
So I have a friend of mine, actually she's a mentor of mine, older, she's in her late 70s, her and her partner are roughly around the same age. They do not wish to get married for a variety of financial reasons, not because they do not love each other, but it's just because of their age and kind of their status in life. Everyone knows that they are a couple, they hold themselves out to be a couple, but they will never get married. Would this bill kind of protect them in that particular situation, because they are a partnership very clearly to everyone who knows them, but have absolutely no desire whatsoever to get married in the future?
Well, first of all, if they don't have a will, and if one doesn't have a will and dies, this will save them a lot of money in inheritance tax. So
If they register. So the reason it's an opt-in program is, or an opt-in option, is some people who are living together have children from prior relationships and they don't want their assets going to their domestic partner. So this doesn't trap someone into giving something to their domestic partner that they don't want to, because it's an opt-in program.
Okay.
But if you were of modest means and you had a domestic partner and you want all of your assets to go to your domestic partner and have them be appointed as personal representative, the sad state of where we are is there's a lot of people die intestate. Majority of our states, the estates we open are for people without wills. So this means for a nominal fee, we're proposing $25, that couple could register as a domestic partner and then make sure that that domestic partner is protected and had all the rights to priority of appointment as personal representative. They wouldn't have to pay inheritance tax, and they could get all the same, would have the same rights to inherit as a spouse would. So for that, it's, for that couple in that situation, I think it's a great solution.
Okay. Thank you very much.
Sure.
Seeing no further questions, that concludes the testimony on House Bill 755. Thank you all very much.
Thank you.
I found my correct notes, Mr. Chair.
Actually, great. Let me make sure, actually, was there someone signed up in opposition? No? Oh, right. There we go. That's fine. Delegate Young, would you please recognize people in the audience for a moment? Just, no, because it's a little unusual, but go ahead.
Don't worry, I'm laughing. Colleagues, with pleasure and joy, I was sitting here with you all when I received a text message that my aunt just got married in the Annapolis courthouse. Please stand, please. Colleagues, please welcome Mr. and Mrs. Galmore, Mr. David and Mrs. Lori Galmore to the committee. Thank you for your indulgence, Mr. Chair. Now,
some people choose Niagara Falls. It's others the House Judiciary Committee. It's a real possibility. It's full of possibility for us. All right. Well, great. Okay. Traumatized the pages. Yes. Celebrated a marriage. Yes. Now let's do House Bill 882. Delegate Smith, we're joined now. They may never want to leave the Environment and Transportation Committee now that they see how this place works. Delegates Holmes, Holmes, Long, and Ciliberti. Where is? Oh, he went that way. All right, that's fine. So we'll hear from Delegate Smith, please.
Thank you, Mr. Chair, Mr. Vice Chair, and distinguished members of both the Judiciary Committee as well as House Environment and Transportation Committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 882. While it's not noted in the system, this is a bill that I introduced at the request of the Mayor Scott administration, so I just wanted to make a note of that. So I'll quickly give a summary. I must admit, to follow that, hate to bring it back to reality with this bill hearing here, but House Bill 882 would amend the Courts and Judicial Proceedings article to allow for emergency civil injunctive relief in District Court of Baltimore City, in the District Court of Baltimore City Public Law Local 9-15, which prohibits illegal eviction and constructive eviction of tenants. The proposal would also harmonize the public local law with the state law prohibiting unlawful evictions. Currently, injunctive relief is not authorized by the illegal eviction statute, and tenants are often left with only a breach of contract remedy, which doesn't adequately address the harms caused by suddenly losing your home. Adding an injunctive relief provision in district court could create a remedy that could more effectively address the harms that the public local law is designed to prevent. By creating an injunctive remedy for tenants and by harmonizing the city's public local law with the state lockout statute, we would create additional, more effective protections and remedies for tenants and clearer provisions on the obligations and duties of landlords. This would provide for a more effective remedy for tenants, and you will hear today from Evan Helfrich, I apologize, Evan Helfrich from the Baltimore City Department of Housing and Community Development, who will also speak more specifically to the benefits of the passage of this legislation. And I do want to say that in a past but very recent life, I've been a landlord, and I think that's important for people to know because I'm not only chair of the delegation, but I'm a real person. I've been a renter, a homeowner, and a landlord. And so without further ado, thank you for your time and your indulgence, and I do hope to have careful consideration and hopefully a favorable report for House Bill 882.
Thank you. Good afternoon. My name is Evan Helfrich. I'm an attorney with the Baltimore City Department of Housing and Community Development. I'm also I'm also an assistant state's attorney who handles some certain criminal cases in the district court and the housing court, and including this type of case. And the purpose of this law, this proposal law, is to basically to create a remedy for tenants. Right now, the only thing that happens if a tenant is either the locks are, they come home from work, the locks are changed, all their possessions are inside the house, they can't get in, they don't know what to do, they have nowhere to go, they're homeless, or if the tenant basically all of a sudden their electricity is off or the water has been turned off, they have no heat in the middle of winter, and it's and currently, if there's a criminal case that's filed, it's going to be set 6 weeks out, and there basically everything kind of goes. And the purpose of this is to basically to get things so that to get them before a judge quickly in a civil context for injunctive release, where they can actually have a remedy rather than a breach of contract claim down the road that basically isn't going to replace your family photos or isn't going to, your kids still need to go to school. They have to take baths and all that and things like that. So that's kind of the purpose of what we're trying to do. And the criminal process is not effective because of there's no police investigation. You have an unsophisticated tenant going to the court commissioner to swear out cases, and most of the cases are lost, not because there wasn't a wrong done, but basically because we can't prove beyond a reasonable doubt that the landlord convicted the crime because there are no witnesses. And occasionally, I guess it came up yesterday, that occasionally, yes, there are some cases that are inappropriately filed, but it's a better way of handling inappropriately filed cases by tenants is in a civil case as an injunction, not bringing someone into court on a criminal charge with the power of the state and the threat of arrest. Basically, we're just trying to create a more fair and equitable process for all involved. And we ask for a favorable ruling.
Nina Thumless, thank you, Mr. Chair, members of the committee. I'm the interim director of the Mayor's Office of Government Relations, here to testify in support of HB 882 on behalf of the Baltimore City Administration. I think Mr. Helfrich pretty much covered everything. We're just looking for a more streamlined process for tenants to be able to access their homes, have their water turned back on, all things that through the current criminal process are not necessarily solved through that process. And so with that, I'm able to take some questions, but I request a favorable report on HB 882. Thank you.
Questions? Delegate Schmidt, then Valentine.
Thank you, Chair. Thank you, Delegate. I too am a landlord. We talk about the title of this bill being holding over, and we've had this conversation in this committee. When a tenant's holding over, the contract has expired. And I struggle with this because I want nothing more for somebody to lose their home. But when a tenant has possession, they have all the control. So how is this going to help in a situation where a contract has expired? I'm at a loss, I guess, to understand it, because we've talked about this offline a few times.
Basically, the purpose, the law basically requires that the law prohibits self-help evictions. You have to go to district court, get your judgment of restitution, and have the sheriff give you possession of the property. And it also prohibits basically constructive eviction, which is basically, you turn the water off, you remove the front door of the house, some ways of trying to force the person to leave in order to deny them the right to go before a judge. And they may have a defense, and for failure to pay rent and for a tenant holding over. It does not apply to detainer, which is a girlfriend or a boyfriend who you're estranged from, who lives in the house, or a squatter, who basically breaks into your house or otherwise. Or getting your 26-year-old kid out of the basement.
Oh, sure. I'm going through something like that right now where a tenant left and moved somebody else into the property, right? And similar situation. So, so I hear what you're saying. You're talking about where a landlord doesn't unlawfully take possession, where they're not following the law.
Yes.
I got you. Okay. Thank you.
I just want to confirm that this does only pertain to the city of Baltimore, correct?
I was going to say, as it's currently written, the first portion of it does apply statewide, but that was a part of the drafting process, so we were looking to amend that to be local only.
Local.
Right, doesn't want to leave that.
Thank you.
Thank you, Mr. Chairman. Thank you, Delegate and people who came to testify. My question is real simple. Are you going to have an amendment for this? Amendment is being drafted. This is going to be Baltimore only?
Yes, that's what she just said.
Yes,
sir.
okay. Thank you. I just want to be clear.
Of course, Delegate.
See?
Yeah, it was just a drafting thing. Yeah.
All right. Are there further questions? Hi, Delegate Erican.
Hi, thanks for coming in. So since it is now going to be a delegation bill, is there a delegation letter that we should expect to come as well?
Oh, of course, yeah. It was just a drafting.
Yeah.
They've been very busy. Our good
I
friends
know.
been-
I know. There's been some funky stuff for sure. All right. Thanks, guys.
Not a problem.
Now, are there any further questions? Seeing none, thank you all very much. That concludes the testimony on House Bill 882. All right, the people from Environment and Transportation don't want to leave, but they have to. And now we're going to switch them out for people from the Health and Government Operations Committee. So delegates, oh, I'm sorry, wait a minute. We have an unfavorable.
Oh, yeah,
we
we
have
do
an
have this
unfavorable. Sorry. Back with E&T. Yeah, like a well-oiled machine this afternoon. Sorry. Let's hear from you for 2 minutes, please. I apologize. Go right ahead.
Good afternoon, Mr. Chair, members of the committee, members of the Environment and Transportation Committee as well. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. When we looked at the bill, so if you take a look at page 5, line 20, they've separated the provision out in public local law. And the way we read this is that it would apply back through the section of the statute which references a significant number of other public local law sections. And so I think I'm going to, they mentioned that it's only supposed to apply to landlords who are breaking the law, okay, but the bill seems to apply to other types of cases that would be moving through the court system, and so there was confusion there. That caused some concern, and then when we met with the city, and there was a reference to this, so if you take a look at page 5, lines 16 through 19, that's the criminal penalty that they mentioned. And we asked, how many cases do you get a year? Criminal complaints. They said 250 to 300, but 95% are dismissed. primarily, I think, for lack of evidence. And we were informed that, we asked kind of why is that, and we were informed that tenants are sent to a nonprofit legal service provider where they are instructed to file criminal complaints against the landlord for, quote, leverage. We took that to mean leverage in a landlord-tenant case. So that created significant concerns for my client because we're being told by an organization or a local government that is moving in support of this bill that the criminal provision here is being used for leverage against property owners in Baltimore City. And the example of the case that we were provided that was referenced is a tenant who filed a criminal complaint against their landlord because there was a power outage for 4 hours. And so that has raised significant concerns, and that's why I'm here today. Thank you.
Are there questions? Delegate Eric, and let me make a note here because Mr. Hill just walked in and is favorable with amendments to 882. Okay, so we're going to have another person after this. No, we're going to, he's unfavorable, so we're just going to do that. Delegate Eric and then Delegate Bartlett.
Okay, so the last thing that you just mentioned, are there any other things like that? So the 4-hour, electric going down, what other kinds of things are you worried that you might see?
Well, I think based on the conversation with the city, we're concerned that tenants may be instructed to file cases, or if you expand this to a civil remedy, civil cases as for leverage is what I was told. So I think that's where the concern comes from. And just candidly, I don't know that I've ever seen a criminal statute that was reviewed and 95% of the cases are dismissed and people are talking about using it for leverage, and we've ever looked at expanding anything like that.
Yeah, that's concerning. Okay, thanks for coming in.
Thank you, Mr. Chair. I'm not a landlord. I have rented in life. I just wanted to know, when you were given the example, you said that the power was out for 5 hours, right? 4 hours, 5 hours, something like that.
Yes.
So what was the result of that case, and who was responsible for the power being out for that time period? Was it a BG&E issue?
It's a fair question. The case that was mentioned was given to me by the city. I didn't get the specifics. I would hope that the case was dismissed. I would hope it was dismissed. I don't know to be certain. The question for the city. I think the concern is that, again, is as it was described to us, that these criminal complaints may be getting filed not in a pursuit of justice, but for some other alternative reason.
Okay, it's relevant because if it were a situation where the landlord did anything with the power, then that could be, criminal. Or if that individual actually needed power for that particular time for whatever reason. So that's why I was asking the question. But thank you.
It's a fair point. I think, and we're not trying to repeal the criminal statute. We're just pointing out where the concerns,
can be used as leverage.
and where the concerns are coming from.
Okay, great. Thank you.
Before Delegate Conaway goes, how many times has this charge been brought in district court?
In criminal,
the charge that carries the 10-day penalty? How many times is that the specific charge?
I was told 250 to 300 in a year. This is what I was given by the city.
Okay.
And then 95% were dismissed.
All right, Delegate Conaway.
Thank you, Mr. Chairman. Thank you, witness, for coming in to testify. What would this leverage be used for?
I think it could be used for any number of things. If there's a separate landlord-tenant case that's happening, maybe a tenant has breached a lease and there's a breach of lease case that's separately going on, and a tenant were to file some kind of criminal complaint against the landlord.
To get the landlord to
drop the breach of lease case. I mean, yeah.
Okay, thank you very much.
Further questions? Seeing none, thank you very much. Mr. Matt Hill signed up favorable with amendments. So we're going to hear from him for 2 minutes, and then we will switch out E&T for HGO. Go ahead.
Thank you, Mr. Chair. Apologies for being late. I was on the Senate side. Very excited to support. twice apologize. Very excited to support HB 882. I just can't tell you how many tenants come into my office, and I know this is the same in other jurisdictions around the state, and tell us that they have been illegally locked out by their landlord, or their landlord has cut off their heat or their hot water. It happens all the time. They are in tears. They have lost their belongings. They don't know where to go. They don't know what to do. And right now, there is no effective, quick remedy for them. They can file and why does this happen? I mean, a lot of times it is retaliation. I think the tenant's complaining about a problem at the property, and the landlord says, well, screw you, I'm just going to lock you out while you're gone. That's the most common reason I've heard. Now, there's no good answers here. They could go and file a criminal complaint against the landlord, and many do. But that judge in a criminal case, it's not going to happen for at least 6 weeks, probably longer. And that judge can't order the landlord to restore the tenant to the property, right? They could file something in circuit court for a temporary restraining order. Circuit court judges don't want to hear it. They're like, this is a landlord-tenant matter. This should be in district court. So there's no good way to get a tenant any sort of quick justice in these kinds of cases, and that's why we're really excited about this. I just want to highlight the real potential for violent confrontation when this happens too. If a landlord illegally locks out a tenant, those tenants, as I said, are incredibly upset, and we have seen the situations escalate into violence when that happens. How do you address that? Well, that's why this bill is actually part of the American Bar Association's recommendations to states around landlord-tenant, which is to give tenants a quick, effective remedy that can adjudicate whether or not they should be restored to the property. And so we strongly support this bill. We ask for one amendment, which is just to require the court to hold a hearing within 7 days of the filing of the complaint so that you can actually have that quick process happen. Thank you.
Questions? Seeing none, thank you very much. Now we're finished with House Bill 882. Thank you very much. Have a pleasant evening to our friends from the Environment and Transportation Committee. Now we can trade them out for Health and Government Operations. We're joined by Delegates Bagnall, Rosenberg, and Chisholm. And we're now going to hear who's going to be offering the bill for the AG. You, come on up. All right, so what's your name? Zach Shirley, okay. Who would you like to have join you? There are several people. Shelley Martin?
Yes.
All right, we'll hear from the two of you, then we'll hear from all of the other witnesses, and we will go from there. So, since he's speaking effectively on behalf of the sponsor, which in this case is the Attorney General, who would like to go first and get the extra minute? Okay.
Me.
Yeah, really. Don't sell it. All right, 3 minutes. Go ahead.
Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Zach Shirley. I'm the director of the Maryland Medicaid Fraud Control Unit in the Office of the Attorney General. The Maryland False Claims Act is a key tool in our unit's mission to stop Medicaid fraud at both the state and national levels. Fraud against state health programs is rarely overt, and it's not ham-fisted. Fraud against state health programs is hidden in records, data, and documents that only the perpetrators know of. And for that reason, enforcement agencies such as the Medicaid Fraud Control Unit rely heavily on whistleblowers to come forward with claims of fraud based on inside information and perspectives. These brave men and women risk their careers and reputations within the industry to stand up to wrongdoing. They are to be commended for assisting the government in focusing its investigatory resources where they can have the greatest positive impact. At present, the Medicaid Fraud Control Unit's cadre of 3 civil attorneys handle over 200 active key TAMs filed in jurisdictions across the country. These investigations range from pharmaceutical manufacturers to medical laboratories, rest home chains to medical device distributors. Since 2019, the Medicaid Fraud Control Unit has recovered more than $56 million for the state from these unscrupulous companies and providers. But those recoveries could have been greater had Maryland not been required to dismiss its claims in cases it declined to take up. If Maryland's False Claims Act mirrored those of other jurisdictions, the whistleblower in those cases Maryland did not take could have carried our claims forward on their own, and the state would have shared in any resulting recovery. Simply put, it's a win-win for Marylanders. Delegate Cardin, you said earlier that you don't mind Maryland being unique, and neither do I. Look at that flag. We've got character. But what we're talking about in this bill is a way that Maryland is unique, that is resulting in demonstrable damage to the state. We are being defrauded, and we are not recovering as much of the money that's being stolen as we could. And another way that this unique characteristic of Maryland's False Claims Act, in addition, this bill would bring Maryland's False Claims Act into closer alignment with the federal False Claims Act, and that's very important. At present, because Medicaid is jointly funded, the state splits its Medicaid recoveries with the federal government 50-50. So that $56 million that I referred to earlier was actually split. $28 million went to the state of Maryland, but $28 million went back to the federal government. Under Section 1909 of the Social Security Act, a state with a qualifying False Claims Act is eligible to keep an additional 10% of those Medicaid fraud recoveries and makes the split 60-40. Since 2019, that 10% would have been an additional $5.6 million. That's $5.6 million that would have been available for patient care through Medicaid. To qualify, however, the state's False Claims Act must closely mirror the provisions of the federal False Claims Act, and right now it simply does not. This bill seeks to fix that. This bill will not guarantee the additional 10%, but it will help us qualify to apply.
Thank you very much. Please go ahead.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Shelley Martin. I am the Director of the False Claims Unit in the Office of the Attorney General. The False Claims Unit handles all of the civil fraud cases for all of the state government programs except Medicaid. So all of the rest are now handled by literally one person, me. And that is not a very balanced way to address $40 billion in state spending and the potential for misconduct that entails. So what we are hoping to do with this bill is bring more balance and allow us to better use our resources to make sure that all of the meritorious cases get time and attention. What we would like to be able to do, and what our colleagues in the federal government and other states can do when looking at those whistleblower cases, is to say, this one looks good, but there's just so much else on the plate, we are going to let relators handle that, let those whistleblowers proceed. And we do not currently have that option. What it does not do is open some sort of door for all kinds of frivolous whistleblower lawsuits. The government would still maintain an important gatekeeping role. The statute would give us the ability to request that a court affirmatively dismiss any of those whistleblower cases that we don't believe should go forward. And we could do that upon making the initial decision to decline, or later, as we're monitoring the progress, it appears that something that we thought might be promising is not as good as we originally thought it might be. We can also change our decision on intervening, and if 6 months or 9 months into looking at how that whistleblower is handling the case, we think it would be better served in our hands, we can jump back in and take it back over and pursue it from that point forward. So we think that this is really a win-win for the government. It allows us, in appropriate cases, to balance our resources so that we can use the resources that the private bar can bring to bear in those whistleblower cases, but still maintain supervisory and monitoring control to make sure that these aren't being used inappropriately.
All right, are there questions for this panel, please? Delegate Arakan, then we'll go to Delegate Chisholm, Delegate Williams. Go ahead.
Thank you, Mr. Chair. Thank you both for being here. So I'm just looking at the fiscal note, and I just wanted to touch on it and flag it for my colleagues as well. So in here it says that it looks like instead of costing us money, this would actually save us obviously a lot of money. They said $1 million annually, but at least $1 million annually. But they also said down here that it looks like because we don't have this legislation, it looks like we missed out on some federal funding. They suggested that we could have qualified for up to $6.3 million in enhanced recoveries. If you know about this, can you just talk a little bit about that specifically?
Sure. So there's actually two False Claims Acts in Maryland. There's the False Claims Act and the False Health Claims Act. The Medicaid Fraud Control Unit operates under the False Health Claims Act. And so the $1 million that's cited in the fiscal note relates to Shelley's operation and the False Claims Act. What we're talking about later on in that additional 10% recovery would be under the Medicaid Fraud Controls Unit's recovery under the False Health Claims Act. Now, that's the part of my testimony I didn't quite get to, even though I was given an extra minute. But that is a program run by Health and Human Services. It's designed to encourage states to bring their False Claims Act into alignment with the federal requirements. And Maryland is nowhere close.
Okay.
But this bill gets us closer. And we could, if this bill were to pass and these changes were made, we could apply in good faith. Would we qualify? It would be a review process, and we'd get a decision. But the really important thing is either we qualify and we get an additional 10% of our recoveries, or we don't qualify and we get a very detailed letter that lays out all the things that HHS would want us to change. And then I promise I'll come back and talk to all of you,
We can't
and we'll
wait.
fix it.
Yeah, great. Well, hopefully you'd qualify the first time, but if not, we're always here.
Yes, we are always here. Delegate Chisholm.
Thank you, Mr. Chair. My question's in regards to Medicaid. Do you have an idea of what percentage of Medicaid dollars paid out are actually fraudulent? And can you give me a dollar figure? And I don't want to hold you to it, but considering we have 40% of our state is now on Medicaid.
You want me to?
Yeah, go ahead.
So you can find estimates that range from 3% up to 25% being maybe improper, but not necessarily fraudulent. I think what you find is if you actually start looking into the details of how those were come up with, there's no real substance to how anyone estimated that. I mean, they're not telling us when they submit a fraudulent claim that it was fraudulent. So it's out there. It's probably way more than any of us would like. But this is an $8 billion program. 1% is still a huge amount of money and needs to be taken seriously.
If this bill were to pass, I love this that I can ask more than one question. If the bill were to pass, do you perceive that percentage would then go up because it would give you more time and resources to pursue this type of thing and to look deeper into suspected fraudulent cases?
Yes, that's our hope. And DOJ has some published statistics at the federal level that these non-intervened whistleblower cases bring in about 20% more revenues than if they did not have those whistleblower cases. So we think that we will see a substantial increase in what we are able to recover on behalf of the state.
I don't want to push my luck and ask about test kits, but we'll save that.
If I could just briefly respond, and I apologize for balking at your first question, but I understand that those statistics are based on fraud we found, and from my perspective, I know there's fraud out there that we're not finding. So I always hesitate to say, it's 25%. Could be more. That's just fraud we've been able to detect. In regard to your second question, I do think that we will see more recoveries through the Medicaid Fraud Control Unit. And I'll say this. In 2013, Bristol-Myers Squibb was sued in a key town. In 2014, and it was Maryland and a lot of other states and the federal government. In 2014, we declined. And because of Maryland's law, we had to be out of the case. Other states let the relator move forward. Relator continued to investigate, but Maryland was out. We were dismissed. In 2022, my phone rang, and they wanted to settle with all of the states, regardless of whether or not we had claims. So we ultimately collected just shy of $1.6 million in free money. But the important point here is they didn't have to do that because we didn't have any claims left in the litigation. So that was a very rare occurrence. But that tells you that there's $1.6 million that we almost lost out on. How many other times have we done that because we were dismissed and we just never hear anything else about the case that 8 years later might have been worth $2 million?
Thank you, Mr. Chair.
Delegate Williams, then Rosenberg.
Thank you, Mr. Chair, and thank you for presenting this bill that obviously has some need in trying to put us in alignment with the federal act. My question I have it sort of a two-part question. And so one, I noticed that there isn't like a spelled out in the bill, like a pleading standard that is explicitly spelled out in the bill. And so that's my first question is what would be the standard under this new kind of law that we're trying to achieve here? Or is it comparable to what the federal standard is? Like, what would that be?
So It would be, fraud in Maryland must be pled with particularity. So it would be subject to the existing laws in Maryland that must be pled particularly. There is quite a bit of federal case law under the Federal Act. That is not binding on a Maryland court, but because if it is a statute that is modeled on a federal statute with similar wording, it is generally considered persuasive. So that existing body of case law, you may not 100% apply, where Maryland has different case law already established, but it would be persuasive if there was something being argued in court.
Got it. And then in terms of the enforcement ability, we've heard a lot from the Attorney General's office about all the wonderfulness that they wish to do. I guess my other question is just the capacity in which to enact this. Does the department feel that they have currently enough capacity?
Well, there's definitely a different universe. We're sitting in front of you saying we want 100 more positions to do anti-fraud work. That's probably not realistic. But for this specific bill, we don't think it will take any additional personnel because it changes things from me having to personally do absolutely everything in every single case. So instead of spending a day prepping for deposition and then a day deposing that witness, I can delegate that out to a whistleblower's attorney and spend an hour reading the transcript after it's over.
Okay, so you don't think there's going to be like a huge influx of cases if this were to pass that would cause you guys to, okay.
I don't think so, and I would be perfectly happy if there were. I would love to be back here next year telling you about all these extra cases and how we need more people to deal with them.
All right, no worries. Thank you.
Thank you, Mr. Chairman. If I heard you correctly, you've introduced a bill that still leaves in doubt whether it would be okayed by the federal government. Is that correct?
Well, it's a bill that fixes the 800-pound gorilla in the room. I cannot guarantee that we will receive approval from HHS. I won't know until I try. What I do know is that as long as I've been in this job and asked about this program, the people who have been here longer than I have and who operate around the nation have told me that there is no point in even trying so long as we have the requirement of dismissal upon declination. Said it would just be a waste of time. And Shelley used to be in our unit, and she said that she heard the same thing all the way back in 2010. This is the biggest obstacle. Once we clear that obstacle, we may or may not receive approval, but we will certainly have much smaller details to mess with than this one.
So your view is it's better to proceed with this bill as introduced, and if there are other issues that need to be addressed, to do that subsequently.
Certainly, because we have the added benefit of being able to allow the relators to carry forward, and as my example I gave about Bristol-Myers Squibb, we'll start recovering that money in cases where relators have moved forward but we've declined. So we'll have an immediate benefit with a potential future benefit.
Thank you.
Thank you, Mr. Chair. And I'm just trying to understand the problem we're solving with this bill, which is a result of a bill that we passed in 2010. So do we know what the problem was we were trying to solve in 2010, and has that problem been solved, and will this get us closer to identifying and capturing any outstanding fraud?
So 2010 actually predates both of us. I was actually hired after the 2010 bill passed to start implementing the bill. The original issue in 2010, the original impetus for the False Claims Act, was to try to capture that extra 10% federal money on the Medicaid fraud cases. And that led to a broader effort to have a more robust anti-fraud program and to have these tools available. Compromises were made in 2010 that meant the statute that ultimately passed did not qualify for that original 10%. And there may almost certainly will have to be additional changes made once HHS finishes its review and tells us what they think, because there are numerous differences between the state and federal acts at this point. But the acts did provide more anti-fraud tools and the ability for these whistleblower cases to exist.
Thank you. Thank you, Mr. Chair.
Seeing no further questions for this panel, thank you both very much. We'll go ahead. We're going to call everybody else now. There are two people who are on virtually. I see Ms. Aguilar. I see, I'm going to ruin that, Matsy. Ooh, all right. Get a point for that. We're also going to hear from Jacqueline DeMar, Brian Markovitz, John Monroe, Renee Booker. I have several of them. We're going to hear from the people at the table first, then we'll hear the people who are here virtually. I'll begin with you on my right, your left, and we'll go over. So 2 minutes to everyone, please.
Okay. Thank you for having us. My name is Jacqueline Damara. I'm the Director of Legal Education at Taxpayers Against Fraud. We're a nonprofit that's devoted to protecting whistleblower and whistleblower laws around the country, including in Maryland. The proposed amendments here will directly serve the purposes of the acts to deter fraud on the state, to encourage ethical business practices, and to recover stolen taxpayer funds. Our state of Maryland is the only False Claims Act prohibiting relators from pursuing decline cases, creating a vast disadvantage for our state in fighting fraud. As all other states that have implemented False Claims Acts and the federal government have recognized, the very purpose of a qui tam statute is to allow private citizens to supplement the limited resources of the state in its efforts to recoup taxpayer funds. It's become increasingly clear that declined qui tam actions are crucial to rooting out and deterring fraud against the government. The federal government recently announced that declined qui tam cases helped the government recover more federal funds than did intervened cases this past fiscal year, with over $1.2 billion recovered in declined cases last year alone. That's $1.2 billion of taxpayer money that the federal government would have missed out on if the federal statute included the restrictions that Maryland's does. The large majority of relators are those who see fraud leading to patient harm, harm to the public, and outright thieving of taxpayer funds, and feel compelled to put a stop to it despite risk to themselves and their careers. Knowing that their case may be dismissed if the government declines to intervene, despite the merits of their case and their willingness to pursue their cases on the state's behalf, this incentivizes those with credible knowledge of fraud from stepping forward. The amendments also serve to promote and protect ethical businesses by deterring those who would commit fraud where the risks that they would be exposed and face legitimate consequences less real. The amendments will help level the playing field for honest healthcare and infrastructure providers, as well as other government contractors seeking to provide services to the taxpayers. Maryland should not stand as an anomaly in the fight against fraud and miss opportunities to recover taxpayer funds. We urge favorable decision.
Mr. Chairman and members of the committee, my name is Brian Markovitz. I'm a litigation attorney at the law firm Joseph Greenwald & Lake, and as part of our practice and throughout the country, we represent whistleblowers that report fraud on government entities. When this type of fraud happens, it's not localized. It causes harms to all of us because we all pay taxes. It also harms the programs that get robbed of the money. I can just tell you, I'm going to kind of go off my script here, but Ms. Martin's office, I've worked with them. In my federal practice, I've had numerous conversations with assistant U.S. attorneys where they will tell me that they're declining my case, but they don't have the resources to take it on, or they have a larger case, or there's some other reason. It's not based on the merits. But they'd like our office to go forward. I've personally been involved in 2 cases at the federal level that recovered $7 million, a little bit over $7 million for the taxpayers. I've never had that conversation with Ms. Martin's office because when they decline, the case is over. So, I think this is a very important fix. It's not costing the state any additional money. And, to be honest, you want people like me out there trying to go after this, because we really do go after it when we can. So that's pretty much all I have to add. I'll take questions, and I hope for a favorable report. Thank you.
Thanks a lot. My name's John Monroe. I'm Executive Director for the Foundation for Fair Contracting Mid-Atlantic Region. We're headquartered in Prince George's County. Really appreciate the opportunity to testify today in support of 773, also in support of 771 and 772. That legislation just makes me appreciate being here in person with y'all. Delegate Kaufman, appreciate you for wearing a mask and everything that you do. You're a champion, and for removing it when you spoke. Even though I could hear and understand everything that McElvoy, who testified virtually in opposition to 771 and 772, was saying. It's nothing like face-to-face, mask off communication. But I reckon that McEvoy's opposition to those civil rights, common sense legislation that you heard earlier is more about 772, which struck me as important for ensuring that civil society, the third sector, the second sector, nonprofits, businesses, and arrangements that incorporate both, don't trample on the civil rights of United States citizens, innocent folks that reside, on this chair soil, But 756, 882, 755, it's been a really great day. I think this is all slam dunk legislation. And, for 773, it's really important. My organization is a Labor Management Trust. We're funded by the National Electrical Contractors Association of Maryland, the National Electrical Contractors Association of Metro Washington, D.C., the Iron Workers Employers Association, and also local building trades unions and the Baltimore, D.C. building trades. And our employer partners, their value proposition is second to none, but they are routinely underbid by unscrupulous contractors, and I'm very looking forward to engaging with you all to talk more about all that this bill does and why it's needed.
Thank you. Ms. Aguilar, please, for 2 minutes.
Good afternoon. My name is Esmeralda Aguilar. I am a shareholder in the law firm of Sherman Dunn, and I am submitting testimony on behalf of the Foundation for Fair Contracting Mid-Atlantic Region. The foundation is a nonprofit labor management organization dedicated to protecting workers on public construction projects from substandard wages and working conditions. Among other things, the foundation monitors public projects for compliance with prevailing wage laws. Such laws are designed to promote responsible contracting in public procurement by incentivizing contractors to compete on the basis of merit, not on the basis of who can assemble the cheapest workforce. Unfortunately, the construction industry is an industry in which labor laws are too often ignored. According to the DOL, the construction industry consistently ranks among the top 3 for noncompliance. And to make matters worse, many aggrieved workers are reluctant to report labor violations. Employee fear of retaliation, including the potential loss of employment, is always of great concern. It is therefore critical that third-party stakeholders, such as workers' rights organizations, including the foundation, it's critical that we have access to a wide range of enforcement mechanisms, such as the False Claims Act. Prevailing wage law violations can form the basis of an FCA suit because contractors who violate such laws will, in their certified payroll reports, falsely declare to the government that they are paying workers the proper rate when in fact they are not. The foundation therefore fully supports House Bill 773, which seeks to strengthen the FCA by allowing whistleblowers to proceed with the FCA claims even without the participation of the government entity. Giving private citizens, specifically third parties, the right to pursue FCA claims. Thank you.
Thank you. Ms. Matsey.
Thank you for the opportunity to testify today in support of amending Maryland's False Claims Acts to modernize them and to bring them in alignment with the federal False Claims Act and those in the District of Columbia and Delaware and Virginia. By way of background, I'm both a resident of Maryland, District 20, and I'm also a partner at Phillips & Cohen, which is the oldest and most successful law firm representing key TAM whistleblowers. Nationwide, our firm's recovered over $12 billion for the United States and state treasuries over the last several decades. And our law firm has substantial experience with litigating False Claims Act cases, both when the government has intervened in them and also when it's declined to intervene. And the False Claims Acts, both the federal and the state, contemplate a public-private partnership where the private bar, as Mr. Markovitz mentioned as well, is available to amplify the resources of the state enforcement, mechanism, the Office of the Attorney General. And that's critical to recoveries. And as Ms. DeMar mentioned, last year, recoveries at the federal level in decline cases actually exceeded the United States recoveries in intervene cases, which is quite remarkable. Knowing that the cases will not be dismissed if not intervened is a critical factor, both for our law firm and for whistleblowers. And it's important to note also that our law firms, our QUITAM whistleblower firms, only recover fees and costs if the state prevails. So only if there's a recovery for the state are we eligible for a recovery for ourselves and for our clients. It's a significant deterrence against fraud, and highly recommend a favorable report on the statutes amendments. Thank you.
Questions for this panel? All right. Seeing none, that concludes the testimony for House Bill 773. We thank you all very much. We thank our friends from the Health and Government Operations Committee for being here with us this afternoon. And just remember, if you need a place where you can ask multiple questions or have a wedding reception, consider the House Judiciary Committee. House Judiciary Committee, more than just bills about guns. House Bill 862 now. Delegate Ziegler. We'll hear from Delegate Ziegler.
May I bring up my panel?
Yes, please. It seems Chambly, Donahue. Who else would you like to have? Well, actually, if Patrick Thronson, come on up, because that'll be everybody who's signed up to testify in favor. There's one person signed up to testify against. Delegate Ziegler, go ahead.
Thank you so much. Good afternoon, Chair Clippinger, Vice Chair Moon, and distinguished members of the committee. For the record, I'm Delegate Natalie Ziegler, here to present House Bill 862. So this bill is very simple. What it does is repeal Maryland's 1986 cap on non-economic damages in a wrongful death or personal injury, not including medical malpractice. Repealing the bill would incentivize safer conditions for Marylanders, ensure a more fair and just system for victims and their families. And I know this issue is not new to this committee, so I first want to thank and acknowledge Delegate Moon, Vice Chair Moon's work on this issue. He brought a similar bill in 2020. But I am bringing this bill on behalf of one of my constituents, Andrea Chambly, who, as many of you know, lost her husband in the mass shooting at the Capitol Gazette here in Annapolis. She's been a tireless advocate for sensible gun legislation and victims' rights, and she's here to give her perspective on what we all believe is an arbitrary, outdated, and unfair law for a number of reasons, starting with the idea that if a damage isn't economic, then it isn't really real. It is difficult to put a price on something intangible like the pain of losing a spouse or a child, but that doesn't mean the pain isn't real or that a jury can't decide on a reasonable award. The flip side is the idea that economic damages are fair, but think about a CEO and a janitor who sustain an identical loss or injury. The CEO walks away with vastly more money in economic damages than the janitor, who of course needs it more. Non-economic damages allow juries the discretion to equalize an award. The other big misconception is that juries tend to award astronomical damages that make no sense and bear no relationship to the actual harm to the victim. But studies have shown this is simply not the case, and as a society, don't we want it to be expensive to kill or seriously hurt someone? Lastly, at least 20 states have ruled that caps on damages are unconstitutional. These states acknowledge that the legislature should not arbitrarily decide what a maximum damage award should be. We need to trust our judges and juries, who actually hear the evidence and have a solid basis for making a decision. To sum up, caps on non-economic damages disproportionately harm women, people of color, the elderly, because these groups tend to earn less money. Caps change the incentives for companies, making negligence less expensive in many cases than responsible behavior. They deny victims reasonable compensation, and they wrongly put a decision that should be made by judges and juries in the hands of the legislature. The current law is outdated and unfair. I ask for a favorable report on House Bill 862. Thank you.
Good. Thank you, Natalie. Asked me to go next. Good afternoon, Chairman Clippinger and members of the committee. On a sunny afternoon almost 5 years ago, a man with a violent criminal history walked into the Annapolis Capitol. He had spent years terrorizing the staff. He had shown up at the old building on Capitol Drive, but it was too secure for him to get in. When his criminal record had been expunged, the Capitol reported on the ruling, and the panicked victim, who knew that this meant he could finally get a permit to have a gun. And he did. During that time, the paper had moved from that secure building, the one that carefully protected their printing presses, to another building that didn't protect its people. The staff had asked local police about the threats, who remembered saying that the guard who left should be replaced immediately. But security cameras continued to record while no one watched. When this dangerous man cased the building, he learned that not only was the guard no longer there, he learned the keycard controlled back door was broken open and had been for years. His threats went silent as his plans came together, a deadly sign well recognized by law enforcement. He entered the building easily through that broken door, carrying something called a barracuda. It weighs 10 pounds and is over 3 feet long and a foot wide. No one challenged him. It would lock the door, preventing escape. He also carried a shotgun, a flamethrower attachment, ear protection, a stopwatch, and a purpose. The telephone lines had been combined with the Baltimore Sun's, so the 911 calls didn't even go to Annapolis. Baltimore City emergency responders didn't know where the call was even coming from. Despite this intentional disregard for safety, I almost couldn't find a lawyer to take my case. I was up against a real estate magnate who's one of the largest owners of business rental property in Maryland. I was up against a billionaire hedge fund in Chicago. They spent millions of dollars defending themselves, and I didn't have $1 million. I had to find a lawyer who would take the case on contingency, willing to risk $1 million of his own. The lawyers knew about the cap on non-economic damages in Maryland, and they wouldn't do it. And the defendants knew this too. It was cheaper to let people die. In conclusion, this cap changes the risk-benefit analysis that's needed to prevent this from happening again. As long as there's a cap, it will be cheaper to let people die than to hire a guard for a building or to fix a broken door or even to keep landlines working. It's cheaper to let people die than to keep us safe at work or anywhere else. I urge your support on HB 862. Thank you.
Good afternoon, ladies and gentlemen of the committee. My name is Kelly Donahue. I am the legislative chair with the Maryland Association for Justice. Mr. Chairman, Mr. Vice Chairman, ladies and gentlemen of the committee, thank you for your time today. I ask you for a favorable report on House Bill 862. A member of the General Assembly shared with me recently that when we pass laws here in Annapolis, we're asking ourselves 3 questions. Is there a problem? What's the cause of the problem? And will the bill solve the problem? So in 1986, 11-108 was passed, and it was passed somewhat unintentionally. There was an allegation that there was a medical malpractice insurance crisis, and that was the intention, to pass laws to make insurance for doctors more readily available. 11-108, which is a general liability tort cap, was swept up in that. Nevertheless, we're obviously years and years and years down the road now, and we have answers to questions 2 and 3. Did this bill solve an alleged insurance crisis problem? And the answer to that question is there wasn't a problem, and no, it doesn't solve the problem. And how do I know that? It's the empirical evidence that's available. When we look at California, MICRA was passed. That's their cap reform and legislation there. Property and casualty rates went up 450% in California after tort reform was passed. Some of the opposition to this bill comes from the American Tort Reform Association. In 1999, more than 11 years after this bill was passed, the General Counsel for the American Tort Reform Association said, "I never promised that tort reform would lower rates, and I would never make that statement." That comment was echoed by the American Insurance Association in 2005. This bill does not solve a problem. In 2010, the Honorable Judge Chazanow, sitting on the Maryland Court of Appeals, echoed the same sentiment. He said there is no clearly established need for this legislation. He went on to say that the right to recover full and fair compensation for a tortfeasor is an important personal right. Unfortunately, what the Court of Appeals of Maryland has said is that they are constrained by existing legislation. We are asking you for a favorable report. Undo a law that has not served a purpose, that is arbitrary, and doesn't protect people like Andrea's husband. Thank you.
Thank you. Sir?
Thank you, Mr. Chair. Patrick Thronson on behalf of MHA. I'd like to briefly tell you about a client of mine named Maddie. Maddie's 56 years old. She has cerebral palsy. She's legally blind and is unable to care for herself. A few years ago, she lived in a group home not far from here. Over a period of 2 months, the staff began to notice unexplained severe bruising on Maddie. They did nothing. One morning, a caregiver was changing her diaper and discovered a grapefruit-sized bruise on her vagina. They ignored it. They sent her to the day program. The day program referred her to a forensic rape kit exam, which determined not only did she have the bruising externally, but she had internal cervical lacerations. Simply put, Maddie had been sexually assaulted and been tortured for months, and nothing was done. Maddie then started having seizures. She refused to eat. She was no longer able to walk even with assistance. She now has to be fed through a G-tube, and she's confined to a bed in a wheelchair. To put the present-day cap in the context of Maddie's case, if Maddie recovered the entire cap of $920,000, which is impossible because of court costs, that would amount to $72 a day for the rest of her life expectancy. That's less than just the monthly rent for a suitable apartment in Annapolis. These aren't just non-economic damages, these are human damages. Human damages. They're for injuries every bit as real and harmful as important as those causing economic loss. If Maddie were able to ask me why this cap should exist, I would have no good answer for her, and neither does the opposition. The written submissions opposing this legislation rely on a metaphor that characterizes jury verdicts for significant harm as weapons of mass destruction. I'm not making this up. If there is a serious fact-based, not fear-based argument in favor of the cap, why resort to this kind of rhetoric? We respectfully urge a favorable report on House Bill 862. Thank you.
Delegate Erican, please, to begin.
Thank you, Mr. Chair. Thank you guys for being here and bringing this bill forward, Delegate. Is this your first bill in Judiciary?
It is.
Congratulations.
It's my first bill in my whole life.
Congratulations. So I'm just looking a little bit online. I noticed that it looks like there's only 11 states that that still have these non-economic caps. Is that accurate? It looks like they're the really liberal bastions like Alaska, Idaho, Kansas, Mississippi, Oklahoma, those kind of folks. So anyways, just thought that was very interesting that we're in that club. So for the claims, I would just kind of like to know if they, you know, the cap actually shifts with the inflation rates of our country. Do they actually go up with inflation?
Delegate Erican, they do not. So the cap increases by $15,000 every year, which obviously over time is a diminishing percentage. And the increases have not kept pace with inflation. So to date, if you were to, you know, based on looking up the rate of inflation on the Consumer Price Index, the current cap would be over $1 million versus $920,000. And just if I may, to pick up on a point you indicated earlier, only 11 states have a cap on all non-economic damages. Virginia doesn't have it, Delaware doesn't have it, DC doesn't have it, Pennsylvania doesn't have it, and these kind of damages are constitutionally prohibited in Pennsylvania. So I appreciate you raising that.
Yeah, I thought that was quite interesting. The other question I sort of have, and this is what some of the opposition testimony seems to reference, is that if we repeal it, we're going to have all these like kind of runaway verdicts, you know, frivolous lawsuits are going to just come pouring in. Has that been the case in the other states where this doesn't exist, or, you know, any evidence you have on that would be great.
Right. Thank you so much for that question. So I read that as well in the opposition papers, and it is interesting to me that every opposition paper that's been presented has almost exclusively been on behalf of an insurance company or an arm of an insurance company, and the overarching constant theme is, oh my goodness, if we repeal caps, we're going to have runaway juries. Ladies and gentlemen, that is an absolutely false statement. And the reason I can tell you that in such a bold fashion is because we as lawyers and a judge, you are not allowed to tell a jury in the state of Maryland during a trial that caps exist. So juries have no idea that right now non-economic damages are capped. So whatever it is they do today is whatever it is they're going to keep doing after 11108 is hopefully repealed, because the juries will still be exactly in the same position. There's also no basis for the allegation that there will be more lawsuits. Plaintiffs' attorneys still have to prove the essential elements of their case: breach, causation, damages. You have to prove breach and causation before you even get to the point of damages. You know, the other opposition argument is, my goodness, well, businesses might be disincentivized to come to Maryland, or this may raise insurance rates, or we may see businesses that struggle. 40 of the 50 states in the United States, including the District of Columbia, have no caps on general torts like what we're talking about here. And I would venture to say it's probably a fair statement that those 40 states have robust economies, robust businesses, and affordable insurance. So really, what I would encourage you to ask yourself, in that case I referenced with Judge Chazanow, that was a case of a 5-year-old boy who drowned in a pool in Crofton because the lifeguards weren't interested in watching him. They said it wasn't their job. And that little boy's family was awarded $4 million by a jury. That award was reduced to $1 million because of the cap. I would ask you to ask yourself, is the motivation here to shield wrongdoers from accountability so that they're not responsible? Or is our motivation here to protect children and to protect adults and all Maryland citizens so that we provide them with safe businesses, safe accommodations, and so forth?
Yeah, and Mr. Chair, if I might have a follow-up, thanks. Yeah, that's kind of what I was wondering. So who are the people that are often most impacted by this cap right now in Maryland? Are we talking about, you know, wealthy business owners? Who are we talking about? Who's hurt by the current cap, and what was the sort of, you know, original idea for creating it? Who thought of this idea, and where did it come from? Do you know?
Well, caps came from insurance companies terrorizing people like all of you. So what we historically now know is, you know, markets do cyclical things. There are times where markets are what we call soft and insurance rates are cheap, and there are times that markets are hard and insurance rates get more expensive. So if you look at a publication from the Emory Law Journal, they went back to the early 1990s, which is shortly after we passed 11108, and they talked about the fact that in the late 80s, we were in a hard market cycle. And what we now know from decades of evidence is insurance companies take advantage of those hardened markets to scare lawmakers and to scare businesses into thinking that, well, you know, a hard market is something other than a cycle, that it has something to do with lawsuits. And then they incentivize lawmakers to pass tort reform, which, you know, sometimes when bad bills are passed, it's very difficult to undo them. We applaud Delegate Ziegler for, you know, her very exciting and bold efforts. So I think that's where it came from. But in answer to the other part of your question, Delegate Arakan, caps most significantly adversely impact people of color, children, elderly, and women. And the reason for that is because historically speaking, white men make the most money. So their wage loss claim, which is not capped, is worth more. So if you're a senior citizen, you're a child, you're an at-home wife, your case is just worth less because the value of your injury is capped by some arbitrary and unjust law.
Yeah, and we have tried to address some of those issues in the past, and hopefully this will be another one that we can address. Thank you, guys.
Thank you, Chairman. Thank you, Delegate. So I have a question or a concern that's addressed in the fiscal note. I don't know if you have that in front of you.
Yes, I have it.
If you look under the state expenditures, so it says that MDOT or MTA in particular, they didn't submit unfavorable testimony, but I mean, they essentially did via this fiscal note. So the MTA advises that the removal of the non-economic damages cap will likely lead to significantly greater awards and settlements against MTA and a lack of predictability in litigating and settling MTA cases. while most state agencies are covered by the liability limits of the Maryland Tort Claims Act, MTA's tort liability is governed by the Transportation Article, which does not have a limit on liability. And they're worried that this is going to lead to a lot more expenditures regarding the Transportation Trust Fund, which has a pretty major revenue problem currently due to the fact that just less people are filling their gas tanks right now. So I didn't know if you've had any conversations with MDOT, or if you'd be willing to speak with, or have you connected with them, or to see if there's any kind of way to work around this, or maybe some kind of amendment?
Well, I'm going to turn this over to Kelly or Patrick, but I mean, the reality is that a cap is predictable, right? I mean, it's a cap. So companies that could be sued, and certainly insurance agencies, would prefer that there be a cap in place. And there's really nothing we can do to take that away. But states and localities do have relatively limited liability, as you can see further on. Actually, there's very small, to me, they seem very small caps. Hey, Kelly, do you want to?
Sure. So I appreciate the question, Delegate Tomlinson. And I guess I would answer it this way. When I saw that part, you can ask Patrick, we were out in the hallway reading the fiscal note, and I said to Patrick, I said, there's actually something in here about buses. And it really kind of made me chuckle, because frankly, it's ridiculous. A negligence claim is a negligence claim. A negligence claim is not born out of how much money could you collect. A negligence claim is only born out of, did somebody do something that was below the standard of care that caused harm to an individual? There is no claim that can be made if you can't prove those individual factors. So the suggestion that there will be more claims against MTA because there's no cap is inaccurate unless MTA bus drivers decide that they're going to act negligent on more frequent occasions because there is no cap. So that's part one. Part two, the idea that MTA is going to pay out more money is also an inaccurate statement, because as we talked about earlier, a jury is not allowed to know whether there is a cap or not. So the idea that runaway juries are going to occur and these grossly large verdicts are going to result against the MTA is not an accurate statement, because juries will be in the same position then as they are now, where juries don't even know that there is a cap. Let's say hypothetically, however, that the floodgates open and the rain starts pouring down and juries start entering $20 million verdicts against the MTA. There's already a law on the books to fix that. Judges have the discretion to do what is called remitter. So if a verdict is not supported by the weight of the evidence, even if 11-108 doesn't exist, the judge can say, sorry, plaintiff, you don't get 20 million, you get 10 million or 15 million or $5. That's the law as it already exists, and that's unrelated to 11-108.
If I could add just one thing, Delegate Tomlinson. We talk in other areas about incentives to promote personal responsibility. So in the areas of driving, in the areas of work, we try and craft laws that incentivize people to act in a responsible fashion. And caps like this have the opposite effect. I mean, there's no incentive created by this sort of cap for MTA to solve any potential liability problem it may have by making things safer, right? That's how we should be addressing this problem, is by addressing the harms and the risks and the negligent conduct that create the need for these claims. Our clients don't want to bring these claims. They don't want to have suffered the losses that they suffer. But we should be incentivizing people to act responsibly, and this kind of cap does the opposite.
Gotcha. Thank you.
Thank you.
Thank you, Mr. Chair. Thank you especially to the sponsor for bringing this bill. This is an amazing piece of legislation, and thank you to everyone who's come to testify for it. I just wanted to clarify a couple of things. How many states are we joined with currently that have these caps in place?
40 states plus the district don't have caps.
Okay, 40 states plus the district.
So
we are in
10.
a very extreme minority still having these caps on the books. And then my other question was, I see that we're keeping out medical malpractice and wrongful death. And I was just curious a little bit about that. Is it because it's a separate piece of the code? It's a different bill for a different day? Or was there perhaps another reason?
It is a separate piece of the code, yes.
Okay, thank you. Thank you very
Thank you, Mr. Chairman. Thank you, panel, for coming in and testify. To Mr. Patrick, how often does the jury award go beyond the caps? Let's see, if you would say 100% was the total number of awards in a year. How often do the claims go beyond the cap?
Delegate, I don't have hard numbers for you, but in my experience, it's less than a majority of the time, certainly.
That means less than 50%.
Right.
Would you
Yeah, I
say-
mean, and most claims also are not these high-value claims. I mean, most claims are, claims that are, that's why we have a district court, for claims in less than $30,000. Most claims are lower-value claims. That doesn't mean they're not important, but they don't even get into the territory that we're talking about here. But of claims that get into that territory, I'd certainly say less than 50%.
Would you say more than 25%?
I couldn't give you hard numbers.
Okay.
But certainly we can research that and provide your office with that information.
Well, thank you so very much.
Any further questions for the panel? Seeing none, thank you all very much.
Thank
you. Go now to one person testifying in opposition. Mr. Silverman, please. All right, Mr. Silverman for 2 minutes, and then we'll take questions. Mr. Silverman.
Good afternoon, Mr. Chairman and members of the committee. My name is Kerry Silverman, and I'm here today on behalf of the American Tort Reform Association to respectfully express our opposition to HB 862. I've submitted written testimony that provides more detail. For nearly 40 years, Maryland has had a system in place where a person who is injured by negligent conduct can recover their full economic damages, their medical costs, the cost of future care, rehabilitation, lost value of household services. Anything that you can place a financial measurable value on can be fully recovered. It can be in a considerable amount, and it is unlimited. But the part of the award that lacks any basis, any way of objectively measuring, that can vary widely from case to case, non-economic damages, has been subject to what we feel is a reasonable but not unlimited amount. Right now, that amount, as you know, stands at close to $1 million and close to about $2.3 million in wrongful death cases, and it goes up every year. It's been upheld by the Maryland Supreme Court multiple times. It's worked very well. It strikes the right balance. It facilitates reasonable settlements because you don't have situations where people are requesting astronomical amounts. It avoids unnecessary litigation and appeals. And while we've seen a rise in large verdicts, primarily non-economic damage verdicts, in states that lack caps, Maryland law and Maryland's civil justice system has been a stable one. Repealing this statute will mean that the sky becomes the limit. A minor slip and fall case will become a multi-million-dollar case, or at least the threat of one. A plaintiff's lawyer can ask simply for $100 a day for the rest of a person's life for minor discomfort, which over time will add up to $2 million. In more serious injury cases, you will see lawyers, as we have in other states, ask for $10 million, $20 million, $80 million just for non-economic damages. And juries who struggle with trying to reach amount for what is real pain and suffering will rely on those amounts requested by the plaintiff's lawyers. We've seen there is empirical evidence for years that says the more that you ask for, the more you will get. And plaintiff's lawyers understand that. If this law is repealed, Maryland's going to see settlement demands across a wide range of cases spiral overnight. And this is going to adversely impact drivers, it'll impact Maryland homeowners, and it will impact Maryland businesses large and small. And I welcome your questions. Thank you for your time.
He kept it within 2 minutes anyway. All right, that's fine. Delegate Erican.
Thank you, Mr. Chair. Thanks for being here. So in those situations where the juries have awarded a significant number, does the judge have an opportunity to change the number?
The judge does, as they do in Maryland, and what will often happen is an amount may be reduced to a still very high number, and then litigation will follow at the appellate level, and these cases can drag on for some time.
Okay, thank you, but the judge does have the final
Yes.
say. Okay, thanks.
Can you hear me? Yeah, you can. My question is this, just very simply, and I have a couple questions if that's okay, Mr. Chair. Has there been inflation since 1986?
Of course.
Well, I think that in real dollars, the cap would be less. Because, to be honest, Mr. Silverman, when the cap was instituted in 1986, I wasn't born yet, and I'm already 36 years old, so it's been quite some time. My other question is, do most attorneys take these cases on contingencies?
Well,
Most
to answer
plaintiffs'
what I thought
attorneys?
was your first question, the cap, when it was initially implemented, was far lower than it is today. I believe it was $350,000, and it's increased. It was adjusted, I think, in the 90s, and it's increased by $15,000 a year, since then gone upward. But yes, plaintiffs' lawyers will typically take cases on a contingency fee basis.
Therefore, my question is, and then I will, I have one last one, and then I'll wrap. Therefore, my question is, when a plaintiff's lawyer takes a contingency case, if they lose, they have to absorb all of the expenses, correct?
Yes.
So therefore, lawyers don't like to lose their shirts, so therefore they must think that they have a reasonable chance of winning. Then lastly, you said that there were going to be major jury verdicts, or if your position prevails in this committee and the cap remains, but how do you reconcile that with the earlier testimony, sir, that jurors are not allowed to know about the cap? And secondly, I find a lot of times in this area, juries rule for the defendant, but that's my own opinion, but I'm confused as to why there would be runaway verdicts without a cap if jurors aren't allowed to know about the cap.
Yeah, the real reason isn't runaway juries, it's runaway lawyers. Right now with the cap in place, a lawyer's not going to say to a jury, award $20 million, award $80 million, or award $500 a day for a person's pain and suffering, because they know at the end the court is just going to reduce it by the statutory cap. And juries have a hard time, dealing with, what's real pain and suffering, and how do you value that? And so when they're offered those types of numbers, research has shown that it will impact and manipulate the jury into awarding much higher figures than they ordinarily would.
Well, we're not going to agree on this, but I thank you for my polite grilling.
Thank you.
Anyone else with some polite grilling?
Or heavy grilling.
All right, seeing none. Oh, Delegate Pasteur, there you go.
Yeah, again, thank you for bringing this to us. I want to piggyback on what Mr. Kaufman just said in that conversation the two of you had about runaway juries, and you said it's not runaway juries, it's runaway attorneys. But I think Delegate Erican asked if the judge had the opportunity to change the amount. So then are we asserting that we have runaway judges?
No, but the judges and what we've seen in other states is when there are extraordinary awards, judges will often reduce it somewhat, and that will result in further appeals and litigation, and it could drag on for a while, and over time, the amounts just keep going up and up. But judges are a safeguard.
But if the judges are our safeguards, but if they see, if the judge, the jury see that the particular case warrants an amount, we have 40 states that have no cap, then isn't that equitable? Isn't that fair that they are looking at the case? I mean, are they going to, I don't even want to insult any of this by coming up with some stupid situation. But I'm just caught here over the notion that, in the first place, that we even have to be in the situation of putting that kind of value and have this kind of conversation over someone's life and well-being. But if it goes beyond the pale or goes beyond what you're thinking, then where does the righteousness come in this? What the fairness, the equity in this? So if it goes on, it goes on if that's what's right.
Judges struggle with this issue, as jurors do too, and what we have in place in Maryland and a lot of other states for review on remitter or at the appellate level is a shocks the conscience approach. Unless the award is at such a high level that it shocks the conscience, the judges will typically let it go. And so there aren't standards in place. When you have a massive punitive damages verdict, which is very different, for example, there are standards that the U.S. Supreme Court has set to determine whether a verdict is excessive or not, and they're objective standards to measure based on proportionality. But you don't have those kind of objective measurements to review the size of a non-economic damage award, so it doesn't function as well. I don't know if that answers your question, but...
No, but thank you. Thank you.
Any further questions? Okay. Thank you very much.
Thank you.
That concludes the testimony on House Bill 867. Now we have Delegate Hartman sitting there patiently for House Bill 860. We'll have him, Mr. Pennack, Mr. Jocelyn, Carla Mooney, Mr. Amsbaugh, Michael Burke are supposed to be on virtually. So we will call them up. No, none of them are on virtually, so we will not hear from them. All right. Delegate Hartman, please, for 3 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. It's great to be back. It's been a few years hearing that testimony. Brings back so many memories, seeing some of the staff. It's wonderful to be here. This bill is going to feel like a softball after the last one you heard. For the record, Delegate Wayne Hartman with House Bill 860. This is a bill simply about fairness. This bill is about refunding those that were denied a permit to wear, carry, or transport a handgun for their application fee, for those that were unconstitutionally denied for a good and substantial reason. So, if many of you recall, after the Supreme Court ruled in New York, Governor Hogan had ordered the Secretary of the Maryland State Police to stop requiring the good and substantial reason. Prior to that, people were paying $50 for renewal, $75 for an initial application, and that amounted to what I see is a flawed fiscal note. So if you read the fiscal note, it appears that there's, and what I did to cap this, because I know if we didn't put a limitation on the number of years, it could have gotten out of hand. People wouldn't have had their paperwork to warrant that they've paid the application fees and so forth. So in the bill, it offers a 3-year cap, 3 years prior to the time when Governor Hogan made the order to the Secretary of the State Police. In that time, DLS suggests that there was just over 3,000 people that would have been denied an initial or a renewal application. $233,000 is the true amount that Maryland collected unfairly. And the only analogy I have for this is I know how much we love landlords in this body. And if I were a landlord, which I am, and if I had an empty apartment and I took application fees from 50 people, knowing that I had one apartment and collected $75 from each of those people, knowing that I already had my choice in mind, but I continued to collect those fees, and unfairly, they weren't going to have what they were actually coming for. That's the only analogy I can offer to what happened in Maryland. So the crazy part of this fiscal note, and I don't know if the person writing it is a contractual employee, but they suggest contractual employees giving out this $233,000 as a maximum case scenario would cost the state $347,000 to administer that. Taking the 3,069 people that applied, that means the fiscal note suggests it's going to cost $113.24 to process a $50 or $75 refund. So I hope this is just terribly flawed or shows terrible incompetence in who would be administering this. So with that, I'll turn it over to either, but I appreciate your time today and hearing this and ask for a favorable report.
I'll give a stab at it. Thank you, Mr. Chairman. Mark Penick, Maryland Show Issue. The bill is very modest. It costs roughly about $600 to $700 to get a Maryland carry permit in the state. Once you calculate the application fee of $75, the initial fee, the training, which is between $400 and $500 if you find a class, and the fingerprinting and background charges that go with the live scan that you have to pay for to a private vendor. So $75 is simply addresses a situation where the state has imposed an unconstitutional requirement, and under controlling Supreme Court precedent, it was unconstitutional when it was charged 3 years ago. It's unconstitutional today to charge for by virtue of a good and substantial reason. So the state police have stopped doing that as of July 5th, and they are to be congratulated for that. But that doesn't ameliorate the unlawful charges that took place prior to that time, and they remain unlawful. It's a very modest bill. $75 is out of pocket for these individuals. That's the least they deserve. So I would urge a favorable report.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland. I agree with everything that's been said. My support is with the amendment because I'm a bit of a purist, and I believe that those who applied between 1972 and today, their rights were violated just as well. I believe that it really should cover from the beginning of the good and substantial era. Do I think that many of these people are going to apply? No, I don't. But philosophically, I think just to do the right thing, they shouldn't be excluded just because of a calendar. So my support for this bill is I like the bill the way it is. I'd like it even better if we extended it to the 1972 era.
Mr. Amsbaugh, virtually, please.
Hello, everybody. My name is Brent Amsbaugh, testifying again from Carroll County. I'm angry about this bill because I feel like the state of Maryland stole money from me. I'm not the only one that feels that way. You knew after Heller that good and substantial was illegal. You knew after McDonald good and substantial was illegal. And you continue to set up everything in the state to take my money and not give me what you were offered. That is theft. Plain and simple. Any definition of it is theft. I urge a favorable review. It is incumbent upon Maryland to return the money that I spent in good faith to exercise my constitutional right to carry outside the home. I'm tired of having this fight with Maryland. You need to get on board. You need to protect the rights of Marylanders. Give us back our money when it's due. I can't say anything. Urge a favorable review. Thank you.
Delegate Aircan.
Thank you, Mr. Chair. Thank you, Delegate, for being here. My question is, I think, for Mark Penick. So tell me a little bit about a class action law. You know how we get in the mail, sometimes I'll get like $1.25 back. And so, you know, in terms of potential for a class action, what are we looking at, and how much money would that cost the state?
Well, it wouldn't be any more than the number of people who were denied for good substantial reason during this 3 period. And the fiscal note makes a rough estimate of that. That's roughly about 1,000 people total. So it's, I should say, 1,000 people per year. The state police back then were granting over 90% of the permits, but most people who were applying thought they had a shot at it, but didn't have a good substantial reason. So that's a relatively small number, and it probably falls well within the 10% or even less. So my guess would be roughly about 3,000 people, which is consistent with what the fiscal note says. And that's the biggest class action. Would there be a class action? Well, you would have to have every one of those individuals submit the documentation required by this bill to probably limit the number of people. The better methodology for doing this would be to proceed without a class action.
Oh, yeah.
Because of the documentation requirement.
Yeah.
So I wouldn't expect a class action from this.
Yeah, no, this seems like an easier way to get this same job done rather than taking it through litigation.
Yeah, I would be surprised if you got 100 people applying for this.
Yeah, yeah. Well, thank you. Thanks for bringing the bill.
Further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 860. We're now going to House Bill 760. And that is Delegate Embry. It's the last bill of the night. So we'll see how long this takes. Quite a few people. There are 5 people who are signed up favorable with amendments. So I'm just going to call the favorables first, and if I'm wrong, y'all can tell me. Delegate Embry, Deb Seltzer, Byron McFarland, Tammy Bresnahan, Robert Doyle are the people who signed up in favor. Others signed up favorable with amendments. I'll just call them as the next panel, unless someone's feelings are hurt, in which case I'll have you come up right now and it won't hurt my feelings. I don't care. All right. Glad we worked that out. And do we have anybody on virtually? All right. That's fine. He can come on in. Delegate Embry.
Thank you, Chair, Vice Chair, members of this wonderful committee. Thank you for the honor of standing between you and dinner. We will keep that in mind. So this bill 760 is brought to address an issue that I know faces all of our constituents and all of Maryland, which is the issues, legal issues specific to aging. It's an issue that exists now and will only be increasing as the population of Maryland ages even further. A greater proportion of Marylanders will be over 60 in years to come. There are very specific, we've heard about some of them in testimony in other bills, the issues specific to aging and end-of-life decisions. These include medical decisions, advance directives, wills, caring maybe for adult children who are parents or guardians of. There are preserving home ownership so that that property can be passed on to the next generation, very specific issues. So the purpose of this bill is to authorize and provide support to the Maryland Legal Services Corporation, who is here, so that they can provide legal services specific to this population. I will let the experts who are here to testify give examples and more specifics about the need. I just want to speak to the amendments. I think everyone is in agreement with the specific amendments. They are sponsor amendments that Senator Washington, who has cross-filed this bill, and I have worked out with the Maryland Legal Services Corporation and other providers to ensure that this bill is consistent with their existing internal operations. I'm happy to talk about any of them. Two important caveats, though, are that it does raise the age to 65. And that is actually not specifically responsive to Maryland Legal Services Corporation, but that is did come out of conversations generally. Also, in the bill that you have before you, it talks about providing legal services up to 75% of AMI. That is inconsistent with Legal Services Corporation's current eligibility criteria, which is 50%, so we are bringing it down to 50%. That is still, I think, substantial. The current currently, 50% of AMI for a family of 4 would be, I think, $63,000. So I think it does capture the population that I know that I and Senator Washington are interested in protecting. And then just generally making sure that they can provide the resources outward through grants. So I think the amendments that have been requested we're all talking about the same amendments. If I'm wrong, please correct me. But with that, I will turn it over to the experts who are here, and I hope that this will receive a favorable report. I think it will do really significant good for people across the state of Maryland. And this is an issue as in Baltimore City in the district that I represent, but it's also as much of an issue in rural counties across the state. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Deb Seltzer. I'm the Executive Director of Maryland Legal Services Corporation. We are a legislatively created nonprofit, specifically created to administer civil legal aid funding such as this. We have an established process for funding this type of work. Our board, which has ultimate grant-making authority, is appointed by the governor and approved by the state senate. And we have a network of grantees who has deep experience in doing this work, specifically for Maryland families with incomes at 50% of median income or lower. There will be some providers here who will speak to the importance of estate planning for families at this income level. Our grantees also have experience working with community partners to ensure they can actually reach the clients that this bill proposes to reach, working with faith-based organizations, neighborhood associations, community organizations. They are not the only players on the ground, and they want to make sure that they work with the communities they're serving. We have at least 10 providers doing this work who also collaborate with each other, local bar associations, private attorneys who volunteer to do pro bono work. Sometimes their work, though, can be sporadic based on other funding. They may receive a small grant from their county to do this work, and then it is on hold again until they can find more funding. So a statewide integrated program will provide a lot of stability to ensure these services can be offered on a continuous basis. And we are happy to administer this important program, and we urge a favorable report with the sponsor amendments. Thank you.
Hi, this is Alexis Burrell-Rohde. I'm the Register of Wills for Baltimore County, and I'm here testifying in favor of House Bill 760. I do a lot of outreach in Baltimore County. I've gone to every senior center in Baltimore County talking about the importance of having a will, doing estate planning, explaining what advanced directives are, and general powers of attorney. And there is a massive unmet need for our seniors in Baltimore County, and I imagine around the state as well. Wills are things that can only be drafted with an attorney. When people draft their own wills or download an online form, it creates more problems with the probate process than if they had died without a will in many instances. So when I explain this to the seniors I talk to, their first question is, I can't afford an attorney. I don't know where to go for an attorney, and I can't afford that. And it's really difficult when you're doing outreach and you're telling people, you're telling your constituents that you need this document, that it can only be drafted by an attorney, and everyone you're talking to says they can't afford it. And there's such limited resources available for that type of work. And having good quality estate planning is critical for passing along intergenerational wealth. If you're talking about families with modest means or historically disadvantaged communities, the ability to do estate planning and provide financial wellness really ensures that the next generation is better taken care of. So I think it's critical, and this is legislation that's really, if you teach a person to fish, they can provide for themselves going forward. So this is a program that not only helps people with autonomy and that they can name their beneficiaries and make end-of-life decisions and name powers of attorney, it really is going to help with financial security for Maryland families. So again, I urge support for House Bill 760.
Good evening, Mr. Chairman, members of the committee. My name is Byron McFarland. Again, I'm Register of Wills for Howard County and here to support House Bill 760. I thank Delegate Embry and Senator Washington for filing this important legislation. When I speak with members of the public, I'll just associate my comments with my colleague from Baltimore County. Just like my colleague, I talk to folks at senior centers, churches, you name it, and we get every question you can think of. But generally speaking, we hear questions like, do I need a will? Should I get a trust? What's the difference between a will and a power of attorney? These are all good questions, and I always say, yes, you should have a will, you should have these things. Some people need trust, some people don't. And while we all have to overcome the emotional hurdle to confront, discuss, and plan for our potential incapacity and the eventual end of our natural lives, many Marylanders face a financial hurdle as well. This bill would ensure that at least some of those Marylanders will get the help they need to have the peace of mind to know that their wishes at the end of their lives will be honored. Importantly, this planning would provide a valuable roadmap for their families who will help pay the bills, who will make medical decisions, who will manage the estate, and who will inherit the assets they leave behind. It may even enable some families to avoid probate altogether. And I'll just say in my experience as register, I can say that this process is generally easier when the decedent died with the last will and testament. It gives the family a roadmap. They know who's going to handle the estate. They know who gets what, and it just it alleviates a lot of uncertainty. We also see that our estates that are most likely to be opened without a will are folks who are at the lower end of the economic ladder. So this means that people of lesser means are more likely to go through probate and rely on intestacy laws that you heard about earlier. So this legislation would address this by giving more Marylanders access to needed estate planning services. I urge a favorable report. Thank you.
Mr. Doyle, please, virtually for 2 minutes.
Good evening, Mr. Chairman. Thank you. My name is Robert Doyle, and I'm testifying on behalf of the State Legislative Committee of Maryland Federation of the National Active and Retired Federal Employees, or NARF. NARF supports, which we represent about 300,000 employees and annuitants in the state. We support legislation promoting the general welfare of our federal annuitants, as well as other state legislation to protect and benefit seniors. So we ask for a favorable report on House Bill 760. No doubt all these issues are critical to seniors. In our many NARF chapters over the state, in meetings, our members are most concerned about wills and estates planning, perhaps second only to their health insurance concerns. The most popular speakers we have at our chapter meetings are the attorneys or the county executives, county officials such as the ones I'm looking at right now, who come and talk about estate planning issues. Our folks know it's the utmost importance to have a sound estate plan, which includes the documents, the will, the testament, a general durable power of attorney, and a health care power of attorney. Our members also want to understand probate and how to best manage their assets in light of Medicaid's financial requirements for long-term care assistance. Many Maryland seniors are in a position to afford these, not all, that's for sure. And these seniors can face daunting challenges with their estate planning issues, trying to pass on generational wealth. Finally, let me say that NARF is generally testifies often in recent years in this session in bills that help seniors with senior income tax relief. Part of our strategy to keep seniors in Maryland so people can age comfortably here. We believe that 760 is another example of this kind of legislation to make seniors more willing to stay in Maryland. Thank you for the opportunity to testify today, and we ask the committee to give a favorable report on HB 760. And I also thank you for giving us a whole lot of information about an interesting place for a wedding reception. Thank you.
Well,
Sadly, I was informed.
I don't know if anybody's still here that represent.
Sadly, I was informed that I cannot lease out the Judiciary Committee as a place for a wedding reception. I mean, who wouldn't?
It's a sad day, Mr. Chairman.
It's quite sad, really. Let's talk about that for another hour, or instead, let's hear from Delegates Phillips, Boucher, and Taylor. Delegate Phillips.
Thank you, Mr. Chairman, and thank you, Delegate Embry, for bringing this bill. This is a great bill. I want to also welcome my Register of Wills, Ms. Rohde. And I want to ask, I got to do this now, Mr. Chairman, because we're going to have an amendment on this bill. I like it, so I want to be a co-sponsor of the bill. Yes. So we get to do that, right, Mr. Chairman? We got it.
Do you have any questions for the panel, maybe?
I'm getting there, Mr. Chairman.
All right, great.
So I do have a question. And the question is, because I'm familiar with a number of attorneys, and I'm one of myself, that does a fair amount of kind of education, working with churches, et cetera. Does MLS look to bring in attorneys that are already working in that area through the 10 contractors that you have, so that those people that are doing this work already are part of the network?
Yes, absolutely. So we have 10 nonprofit grantees, about 10 who are doing this work. They work also with private attorneys who do pro bono. There are some that also will do low bono, so they will take, sometimes that's for people who are slightly above these income guidelines who maybe can't afford a full, will at normal cost, but could afford to pay something. So there's a very wide range of services that are offered, but our grantees are very familiar with folks who are already doing this work and partner with them.
Thank you.
Thank you, Chairman, and thank you, Delegate Ember. You're doing very well in front of this committee.
Thank you.
I noticed on the fiscal note, the state's saying it will cost $500,000 a year, which concerned me, but then I want the registrars to answer this question. Do you believe that collectively, the court jurisdictions in all 24 could potentially save that money by doing this? The flip side of it, would there be a savings to your jurisdictions?
I mean, I think that, one of the things the legislature did last year, and we're seeing a huge benefit, is that we completely overhauled our probate fee schedule so that estates that are small estates under $50,000 pay no fee anymore. And we did that just by making the fees sort of flat across the board. I think the more people who have a last will and testament, the more people who have a power of attorney and go through this process can kind of be put on the path to possibly avoid probate altogether, which would mean that we would have less work, and it would save the family the time of having to come into the office and go through paperwork. And oftentimes, honestly, a lot of the estates that we open, it's a bank account, it's an old car, it's a tax refund, it's something like that. So I think that once they get the ball rolling and people have the confidence of having spoken to an attorney, they might move in the direction of being able to save themselves a lot of heartache.
But the big point is, you believe it can potentially save your office time, energy, and money processing with this in place?
Yeah, I believe so.
You'll be more efficient.
Yeah, I believe so.
Yeah, it absolutely would be more efficient. And one of the big savings is, and I can't quantify this because I haven't put together numbers about this, but when you don't have a will, or you've drafted your will yourself, or you've downloaded a form from the internet, you find yourself in front of one of the orphans courts or the circuit court sitting as the orphans court in the county, and that takes a lot of time. It takes legal expenses for the litigant, and also a lot of time with sending notices from our office, actually scheduling the hearings, having the judges sit, and that it would definitely save money across the board, both on our end and on the part of the constituent, avoiding unnecessary legal expenses and
Thank you very
time.
much.
You nearly caused some PTSD up here. We were talking about the probate fees from last year, and fortunately, Delegates Grammer and Cardin are not in the room right now, or we have to have a long conversation about that. All right, I see there are only 2 more questions and a whole other panel. I'll try and be better, all right? So I won't, okay. I'm here all week. Delegate Taylor, then Delegate Pasteur.
Okay, thank you, Mr. Chair, and thank you, Delegate Embry, for this. Seniors are my passion, and for 27 years, we've been taking care of seniors in Maryland, my family. I'm concerned in general, and there's a question coming, that a lot of our senior services are income-based, and dementia, Alzheimer's, and other age-related diseases don't know your income. And I was hoping that I was going to actually ask if we could increase the median age or income percentage, but I understand in this case that's not possible for your services. My dad recently approached me and said, I need to do mine and your stepmom's end-of-life documents. I gave him 2 referrals, both for lawyers that were well out of his price range, so he couldn't do them. So he has an income that's above what you could offer. There's a question here somewhere. Is it possible that we might get an exception for this income percentage? I don't know. Could you think about that? Could we talk about that further? And then secondly, I saw in the bill that it's saying, there's a line here that says, line 17 on page 2, that at least one lawyer is factored in. I would say, Katie, bar the door. Like, you're going to be flooded, I think, with requests. And I know you said minimum, but does the $500,000 fiscal note, is that tied to just one?
So I'll address that part first. The at least one lawyer is actually part of the amendment that changes it to a grant program that will go to our existing grantees who have a network of lawyers as opposed to one. So we'll certainly have increased capacity because this is work that these providers are already doing. So that's part of the amendment that will change it.
And fully funded.
If it's funded, yes. Clarify that it's a grant program as opposed to us holding the attorney, because we do not offer the services ourselves. We are just the funder.
I see.
In terms of the income limitations, that is a statutory limitation that is in our statute as a legislatively created organization, and it has been our mission for 40 years to serve people at that income level. Many of the legal services providers, that is also their goal, is to serve. They have to be able to prioritize, and really, so the priority has been for folks who are least likely to be able to afford legal services on their own. Certainly understanding that estate planning and other legal services are important, as you said, across the entire spectrum. It's just a matter of, for us, of prioritizing on our core mission of helping people at the very lowest levels.
But I just want to say, Delegate, I agree with you, and the Senator and I spent a lot of time talking about that very issue. So I think this is, in my view and in our view, the right bill, at least to get this started, but I'd love to think about in future years.
Thank you.
Addressing that population.
Thank you, Mr. Chair. Thank you so much for this. Just like Delegate, it's, as you'll see later, seniors, elders, my passion. It's what we have to do. This is what we have to do. There's no ifs and buts, no exceptions to it. And I know that this is so critically important. Like you, I went through this with my parents. So glad that they could pay for it and do what they needed to do. On the flip side, there are all of those people, not just those who can't pay for it, because there are a lot of people who can pay for it on some level. So my question is, how do we get that message out? Because this is a wonderful bill. You've got some wonderful verbs here: establish, provide, etc. You go to churches, you go wherever, and they hear it, and they ask the questions, then you leave, and that's it. They move on. You might get one or two. So in my mind, there has to be something that is ongoing, almost advertising. How do you reach people and let them know it is there, it's accessible, they can do it, and to send the message? How are you going to do that? To send the message that even though they think they're poor and that they have nothing to leave anyone, that there's something, and that what you're putting together for them will be different. So how do we do that?
Sure.
I'm real interested in we talk about environmental justice. I call it environmental injustice. When we get to this is an example, or could be, of environmental injustice, how we leave out populations.
Thank you, Delegate. I think one of the things this bill calls for is an ongoing outreach campaign. I think just as you're talking about that, it cannot just be a one-time message. You know, people need to hear the message over and over again before they will kind of be moved to take action to actually develop their plans. So there will be some providers who will come up, I believe, in the next panel who can speak to that even more. But I think with a stable funding source, that's really the key here, because if it's something that can be relied on year after year after year, we can build a multi-year campaign to help reach folks. The bill specifically calls for outreach in rural communities, so making sure that, you know, that may be a different outreach strategy than it is in an urban community, and making sure these are the providers and the community groups that they work with, they have that expertise because they are members of the community, have been doing this work for so long. That I think you're absolutely right. It has to be a sustained effort, and ongoing funding will help support that.
Thank you.
Thank you, Mr. Chairman. Thank you, delegate and witnesses, for coming in today. I was wondering, can you comment a little bit more on the massive problems, the massive probate problems caused by the usage of the online forms? Anybody on the panel?
Well, I can comment on them being a massive problem, and they tend to create a lot more problems for the people who use them than maybe in some instances if they didn't have a will at all. And our hope with doing this outreach that is associated with this bill, and the registers and, you know, the people that are continuing to do outreach about the importance of having a lawyer drafted will, having additional resources, would incentivize people to not do the online wills and actually seek and have access to an attorney to help them draft those documents to avoid the online will problem.
And can I just answer also, Delegate? In my experience, when someone files a LegalZoom will or something that looks like it was a template that they found online, it seems to me like there's a general reflexive mistrust of whether it was a valid will. And in my experience, in my 12 years as a register, we've thrown out 2 wills because they were fraudulent, and one was a LegalZoom will. So I think people just, they have a knee jerk, and they don't see it on kind of letterhead that's been written by an attorney. People generally, like, it creates suspicion in the family that leads to court battles, that leads to thousands of dollars of legal fees, and a real deterioration of family. So I think there are a lot of negative consequences.
Okay, well, today, between today and yesterday, was dealing with House Bill 18 and House Bill 755, and we're discussing using these forms. So were the forms that were thrown out by Zoom, were they notarized?
Well, a last will and testament in Maryland to be valid requires 2 witnesses, and Maryland does not require a notary. So sometimes that's the problem with the online form, is they're not specific to the state of Maryland, and they might miss provisions that are important in Maryland. They might direct witnessing or signature requirements or attestation clauses that aren't adequate for the state of Maryland. So if someone downloads a form from the internet that's not specific to the state of Maryland, many times it's missing important provisions that are important to have a valid will to avoid having to go to orphans court in the state of Maryland. So that's one of the problems.
Okay, on the other side, it was stated that when you use different attorneys to get different wills drawn up, a lot of institutions might not accept the wills because they have different languages in them. Do you have any comment on that?
Well, the registers are used to probating wills written in by all sorts of different attorneys and have different languages, and our staff is trained to read and interpret last will and testaments regardless of the legalese that's chosen for those particular forms.
Okay.
And we even can probate wills written in different languages other than English if they're appropriately translated. So that really isn't a problem for the Register of Wills. It's more of it as if the wills themselves do not contain the appropriate language or clauses that are critical for compliance with Maryland law.
And when we're talking about these wills, are we talking about 1 document or 3 documents? And the reason why I asked you this is because I had counseling with a member of this committee earlier today, and they were talking to me about the difference between the financial will and the will that will help you with your medical assistance?
So the Register of Wills only deals with last will and testaments. And there's a lot of, when I talk to the public, there is some misconceptions about the difference between an advance directive, a living will, a power of attorney, a general power of attorney, a durable power of attorney. Our office only deals with last will and testaments. An advance directive is what we in Maryland call a living will or a durable power of attorney. It's essentially a similar document where you appoint a healthcare agent and you also specify end-of-life decisions. The power of attorney is a document that's for use during your life where you name an attorney in fact that can conduct business on your behalf. But those are the other end-of-life documents or documents that this program addresses, but they don't have, but the Register of Wills exclusively deals with your last will and testament.
Okay, thank you very much.
Last question.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill. Like so many other people on this committee, I think supporting our population that can not truly financially afford this service from an attorney is a really great thing. But this particular bill I'm struggling with because with such a high fiscal note, and then we're talking about people at least 60 years old, so most likely people who are retired, with family income that does not exceed 75% of the median. What are we really looking at financially? Because to me, when I read that, I'm thinking of a family income like the people sitting here, which is like a dual, income family, professionals, and these are retirees who we know live on less than two working individuals who are of a younger age. So I just feel like perhaps this is too broad of a group of people that we're scooping up here, and perhaps we could narrow it to the people who truly need this and reduce the fiscal note.
Well, there's two pieces of that. The first is the amendments do restrict it. So they raise the age to 65 and lower it from 75% to 50%.
Oh, okay.
So that is done. The 500,000 is specifically, that is the number we came up with. So you could adjust that. I mean, that's the amount that we thought was a good starting place given the need. So that is the amount that we're asking to be appropriated for this program. So it could be 250,000, it could be $1 million. We just thought for a statewide effort, 500,000 was a meaningful amount. It doesn't remotely address the entire need, but at least it's enough so that it could actually meaningfully expand services when doled out to the grantees by the Maryland Legal Services Corporation across all the many communities in the state. But I take your point, and I think the amendments do address at least partially at least.
Like narrowing the scope. I apologize, I missed that.
Oh, no,
and so I'm assuming, because I'm looking at the bill without the amendments, if you did, I don't know if you guys have been able to do the math, or if you could, if you raise it to 65 and you reduce it to 50% of the median family income, are you aware of how much you could reduce that 500,000 ask?
Well, there's no shortage of need, right?
Yeah, the 500,000 and the need are not currently linked.
Right.
The 500,000, I believe, was chosen by the sponsors as a requested appropriation. That is not based on the need right now.
It's not based
kind of
on
seed
need.
money for the program.
Okay.
Precisely, thank you.
Okay, thank you.
All right, thank you all very much. We're now going to hear from the second panel. Tammy Bresnahan. Allison Harris is online, I believe. Okay. And Meredith Gerard. Aisha Sneed is also signed up virtually. Angus Derbyshire is also signed up here in the room.
Good evening, Mr. Chairman and members of the House Judiciary Committee. I am Tammy Bresnahan. I'm the Senior Director of Advocacy for AARP Maryland. AARP Maryland supports House Bill 760. On behalf of our almost 900,000 members, we'd like to thank you for this opportunity to speak about House Bill 760. I wouldn't want to scare you to say all 900,000 of them would want the services of this bill, but they do support. Older adults have unique health and social needs, as you've heard. Many are on fixed incomes. Often older adults depend on government benefits and services. Actually, the average Social Security payment for someone over 65 is about $1,400 a month. Navigating the system can require access to competent legal assistance, and that's what we think that this bill does. ARP believes that states should expand access to free or reduced cost legal services for older adults with low and moderate incomes, and that includes exploring legislative remedies like this. We thank Delegate Embry for bringing this bill forward. We thank you for giving us this time at this late hour, and we ask for a favorable report on House Bill 760.
Good evening, Chair and members of the committee. My name is Meredith Gerard. I'm Executive Director of Midshore Pro Bono based in Easton. This bill is a game changer for rural communities in Maryland, especially the Eastern Shore. Having access to life and estate planning documents makes a concrete difference for older adults with limited means, especially in rural communities. Midshore Pro Bono uses volunteer attorneys to do this work. I was one of those volunteer attorneys for many years, assisting in local senior centers before I came onto the staff of Midshore Pro Bono. 21% of Eastern Shore residents are older adults. The demand for these services far outstrips what we can possibly provide at this point in time. We recently assisted a woman, an 81-year-old woman who had worked in agriculture her entire life since she was 16 years old. I urge your support for this bill. Thank you.
Good evening, Mr. Chairman, members of the committee. My name is Angus Derbyshire. I'm the Pro Bono Program Director for Maryland Legal Aid. I learned as a young trial attorney to read the room and to not say too much. So seeing that I'm standing between all of you and dinner, I'm going to continue to do that. My colleagues have really talked about the need. It is extreme. It is unmet. The need for this is significant. And this bill, if passed, would provide us with the means to be able to go out and to meet that. It is not currently a legal practice area that we have the ability to do. And as the largest provider of free legal services in Maryland at Maryland Legal Aid, and in conjunction with our more than 50 partners providing free legal services, we still don't have the ability to do wills for everyone that needs the wills and would fit within this income guideline. So with that, I highly recommend passage of HB 760, and I will step back.
Ms. Harris, 2 minutes.
I'm Allison Harris, Director of the Home Preservation Project at the Pro Bono Resource Center of Maryland. I'm here as a legal services provider of estate planning and other homeownership-related services to low-income homeowners in Maryland. People often don't understand how estate planning fits into home preservation for low-income people, and I'd like to help make that connection for you. Estate planning is one of many tools we use in our tax sale foreclosure prevention efforts, and we actually started offering estate planning services as an upstream measure to prevent families from losing their homes to tax sale. Each year during tax sale season, we see a significant number of homeowners who are not on the deed, but who have lived in the home for years or decades. They're almost always the adult children of the original homeowners who have passed away. Those parents worked for decades to pay off the mortgage and to own that home free and clear. But when they died without a will, the adult, child, or children did not undertake the arduous process of obtaining clear title. Without clear title, these heir homeowners cannot take advantage of numerous tax credits and other programs that will help keep their ever-increasing property taxes affordable, nor can they take advantage of other programs available to homeowners that will help keep the bills down. Unable to keep up with mounting tax bills, these heir homeowners may find themselves in tax sale and at risk of losing their home. Having a will and proper estate planning in place would have increased the likelihood that these heirs could obtain proper title and avoid tax sale. Another benefit of estate planning as a tool for home preservation is intergenerational wealth building. The vast majority of my clients are Black families from low-income communities. We know that Black and brown families in this country have not fared as well as white families when it comes to home ownership and generational wealth building. Proper estate planning can facilitate the passing of home equity to heirs and can be one of many tools to advance economic racial justice. Thank you for the opportunity to testify in favor of HB 760 with sponsor amendments.
Delegate Bartlett.
So, Ms. Bresnahan, hi, how are you?
Good, how are
Good to see you. Given, I don't know if you heard Delegate Pasteur's question about getting this information out, I would think that your organization would be able to, okay. would be able to help with that. Thank
We could work, and we get lots of calls from people, and sometimes I'm like, do you have a disability? Because I'll send them to the Disability Law Center or to the Pro Bono, so we will help them advertise.
Well, your marketing is excellent. Thank you.
One last question for Ms. Harris, who's still here. Am I right in understanding that you have programs for lawyers who want to learn how to help other people draft wills? Or are there programs out there where you can effectively take a class? So
Yes,
because
I have a training online on demand that is available for any lawyer who wants to volunteer to offer estate planning services. They can just sign up on our website and do it, and they can provide it through any one of statewide legal services providers in Maryland.
one of the challenges, of course, serving in the legislature is you don't have a whole lot of time, but it's also somewhat embarrassing for the lawyers in the room to report that they haven't done any pro bono hours year after year. So I'm just saying that if people are looking for something to do, I'm just saying that, you know, if you're looking for something to do, it's maybe some kind of thing to think about. All right, I've had enough. That's enough, I think, and thank you all very much. That concludes the testimony on House Bill 760. We have to clear the room. There's somebody using it as a reception apparently now, and tomorrow there will be 170 witnesses tomorrow. Today there were 90 witnesses. See you tomorrow.